Gentlemen, we'll begin the September 25th meeting of the Ventura County Planning Commission. Can I have you all please stand and join me in the Pledge of Allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. If I can have the clerk take the roll.
Commissioner McGee,
Here.
Commissioner Dukas,
Here.
Commissioner Rodriguez,
Here.
Commissioner Onstad,
Here.
Commissioner Westner.
Present.
Moving on to item 4, public comments section. This is a time in the agenda when anyone that is here wishes to speak on any item that is not on the agenda. This is your opportunity. I see no designated cards and I see no speakers. So we'll move on to item 5, approval of the July 3rd, 2043 minutes. Do I have a motion?
Motion as recommended.
Second.
Okay, we have
Oh, yeah, we got to do
a
that.
motion and a second. Bear with us while we deal with our electronics up here.
On the floor. And yes.
Okay, minutes are received. Item number 6, approval of the August 7th, 2014 minutes. Do I have a motion?
Yeah, I move to accept as written.
Have a second?
Second.
Sorry.
Where'd it go? Disappeared.
Oops, a daisy.
Pardon me? Yeah, I can do it. Can I have a voice vote on this?
Aye.
Aye.
Yeah.
Motion passes. Minutes received. Moving on to item 7, PL 13-0046, Decor Oil and Gas Exploration. Staff?
Good morning, Chair Rodriguez, members of the Planning Commission. I'm Jay Dobrowolski, planning staff and case planner for the item before you. The item before you this morning is an appeal of the planning director's decision to grant conditional use permit PL 1346 for oil and gas exploration. The appellant and the CUP applicants are in attendance this morning. The project site is located approximately 1.5 miles north of Piru and 2.5 miles southwest of Lake Piru. The project site is located approximately 1.5 miles outside of the Los Padres Forest, to the south of the forest. The proposed project is the development of a drilling pad approximately 1 acre in size. The drilling pad will have 2 oil and gas wells, and those wells will not use hydraulic fracturing or any well stimulation technique similar to hydraulic fracturing. The pad will also have temporary production facilities, and the project will require minimal grading of the access road and tree trimming along the road. There will also be an emergency helicopter landing area. The project site is accessed via Piru Canyon Road and a private unpaved road known as Modelo Canyon Road. The private road is located along Modelo Creek. There is one creek crossing along the road. Modelo Canyon Road is currently used for agricultural and grazing purposes. The road will require brush clearance. The road will also require grading to widen the road. The road is 15 feet wide at the creek crossing.
Can I just ask why the date shows 10/23/14?
Yes, those photos were actually taken on Tuesday of this week, and we couldn't figure out how to use the digital camera.
Okay, thank you.
The creek crossing is located next to a natural oil seep. The project includes tree trimming along the roadway, and there's a photograph of a sedan underneath the tree. The tree trimming is required for the drilling equipment and also fire equipment access. There's a photograph of a SUV with the low clearance.
This is a separate tree, different than the other picture.
I'm sorry, what was that?
This is a different tree, rather as
It's
opposed to
actually the same tree that the sedan is underneath.
Okay, thank you.
I just used two vehicles for reference. The road will have turnouts for fire equipment access. There's a little bit of the turnout visible on the left side of the picture. The drilling pad area is relatively flat, as it is located on a site that was previously used for oil drilling. The proposed wells will be located greater than 75 feet from Modelo Creek. The line of rocks in the middle of the photograph represents the 75-foot distance from the creek. The creek is off the screen to the right. The wells will be drilled on the left-hand side of the rocks. The road adjacent to the pad will be graded for easier drill rig access. The well locations are indicated by the red stars. The well pad will have 2 pumping units, one for each well, and a test tank. This is a photograph of the drilling pad looking from the road up towards the pad. Here's another photograph of the drilling pad. This view is from the east of the pad. The foreground shadow area is Modelo Creek. Here's another photograph of the pad, taken from the pad, looking back towards the access road. The pad will have rod pumping units, typical of other drill sites throughout Ventura County. The pad will also have a test tank, similar to those found at every other drill site, or exploratory drill sites. The project site was previously used for oil and gas production as early as the 1890s. The last oil wells were abandoned in 1990, and all equipment was removed from the site. In March of 2012, the planning director granted a CUP for a previous design of the current project. That was LU 08-100. On June 30th of this year, the planning director granted CUP PL 13-46 for the current project. On July 9th of this year, and within the 10-day appeal period, an appeal of the planning director decision to grant CUP PL 13-46 was submitted. Pursuant to CEQA, the project was evaluated for environmental impacts, and an MND was made available for public review. The project will create potentially significant impacts to fire hazards and biological resources. With 13 mitigation measures, these impacts will be reduced to a less than significant level. Staff prepared responses for all comments received, and also topical responses, which are included in the MND. The planning director adopted the MND when the CUP was granted. Pursuant to the non-coastal zoning ordinance, notice of this hearing was mailed to surrounding property owners, and a legal ad was published in the newspaper. An email was sent to interested parties who requested notification. The appellant submitted an appeal form with 5 grounds of appeal and an attachment with 6 grounds of appeal. The 2 lists of grounds are essentially the same. The first ground of appeal is the initial study, mitigated negative declaration, fails to adequately evaluate the cumulative impacts of the project in violation of CEQA. Regarding issue number 1, staff evaluated projects within 2.5 miles of the project site. Staff did not identify any cumulative impacts to which the project could make a considerable contribution. The installation of 2 wells on a 1-acre pad, or the project is the installation of 2 wells on a 1-acre pad in a region that has been used for oil production before the turn of the century. Therefore, staff recommends your commission find that this ground of appeal is without merit. The second ground of appeal is the initial study, mitigated negative declaration, fails to adequately evaluate the impacts of the project on endangered California condors and their habitat in violation of CEQA, the ESA, and CESA. For more on that, we have the planning biologist.
Good morning, my name is Holly Harris. I'm a biologist with the Planning Division. Potential impacts on biological resources, including the California condor, were evaluated in Section 4 of the Mitigated Negative Declaration and Initial Study, and in the responses to comments. The environmental analysis specifically addresses impacts to special status species, including the federally and state endangered California condor, consistent with the CEQA guidelines and with the Ventura County Initial Study Assessment Guidelines, which require the evaluations of these impacts consistent with the definition of a take permit under the Federal and California Endangered Species Act. Specifically, staff analyzed if the project would result in the loss of 1 or more individuals, occupied habitats, or critical habitats. There is no substantial evidence of an impact to the California condor or its habitat. The site does not contain nesting, roosting, or foraging habitat. Specific mitigation measures recommended by U.S. Fish and Wildlife Service were included in the project description and the mitigation measures, and California Department of Fish and Wildlife mitigation measures were also integrated into the mitigation measures, which included a walnut tree replacement and pre-construction surveys and monitoring. Therefore, staff recommends that you find that this appeal is without merit for ground 2. Thank you.
Mr. Chair, may I have a question? This is your expert opinion as the county biologist?
Certainly is.
Thank you very much.
Thank you. The third ground of appeal is the Planning Division failed to accept fair argument of substantial evidence of significant environmental and public health impacts associated with the project. Regarding issue number 3, the CEQA guidelines defines what is and what is not substantial evidence. Substantial evidence is required to make a fair argument. A fair argument cannot be made that substantial evidence exists. Comments received mention that substantial evidence exists, but the Planning Division has not received any substantial evidence. Therefore, staff recommends that your commission find that this ground of appeal is without merit. The fourth ground of appeal is the initial study, MND, fails to address impacted resources in reopening the oil field and is inconsistent with CEQA. Regarding issue number 4, the initial study, MND, was prepared pursuant to CEQA and the county initial study assessment guidelines. The MND evaluates all reasonably foreseeable impacts of the project. The reopening of the Piru oil field is not a part of the project. It cannot be evaluated as any impacts would be speculative. Attached as Exhibit 7 is a recent court case that supports the decision of the county. And we'll have more on that later. The fifth ground of appeal is the Planning Division failed to obtain sufficient analysis from California Fish and Wildlife and U.S. Fish and Wildlife regarding wildlife impacts. For more on that issue, we have the planning biologist. The Planning Division prepared the environmental analysis with adequate consultation with the California Department of Fish and Wildlife and the United States Fish and Wildlife Service regarding wildlife impacts. The Planning Division incorporated all the mitigation measures recommended by these agencies into the conditions of approval. The Planning Division also met with each of these agencies on at least 4 occasions to discuss the analysis and mitigation measures. Therefore, staff recommends that you find issue number 5, ground of appeal, is without merit.
Mr. Chair, if I may again. Again, this is your expert opinion as the county biologist.
Mr. Chair, Commissioner Wessner, yes, it is.
Thank you.
Ground of appeal number 6 is that the MND conflicts with the Federal Endangered Species Act because of the substantial evidence for the degradation of habitat. As evaluated in the mitigated negative declaration for the project would not substantially degrade habitat for any endangered species, including the California condor. The proposed project would not result in any substantial effects to habitat or biological resources. Again, the site does not contain nesting, roosting, or foraging habitat for the California condor. Staff recommends that you find ground of appeal number 6 is without merit. And I'll turn it back over to the staff planner.
Ms. Harris, before you go again, it is your expert opinion?
It is absolutely my expert
Okay.
opinion.
I don't mean to be annoying, but there's
okay.
purpose for this. Thank you.
Mr. Chair and Commissioner Wessner, it's both Ms. Harris's opinion, and I trust her implicitly, but it's also the opinion of the other agencies that these measures are adequate. I would like to point out one thing just as a point of clarity. Ms. Harris just said that we incorporated all of the U.S. Fish and Wildlife recommended measures. And I just have to point out that in some of my commentary, I have said we have imposed essentially all. And the essentially is there were 23 items listed in the U.S. Forest Service July 2013 letter. That is the Fish and Wildlife Service. One of the items that they recommend is a matter of county policy that cannot be placed upon a private applicant. And that item was that there should be no industrial activity within 1.5 miles of a condor nest. Well, we can't impose that on this applicant. They're consistent with that in their project, but that's a matter of county policy, and we can't have a mitigation measure, telling an applicant you have to amend county policy. So 22 out of 23 listed items, but those were virtually all, or exactly all of the actual mitigation measures.
I'm unclear. What's the county policy that you can't say, stay 1.5 miles away from a condor nest? I didn't understand.
Mr. Chair, Commissioner Idukis, there is no current county policy regarding setback from a condor nest. And so we can't impose the requirement for the applicant to come to the board to get a county policy. It's a matter of something which would be initiated by the county or someone else requesting a zone change or a general plan amendment. So we can't condition a project for a general plan amendment. That's my point. So it's a matter of policy.
Mr. Chair and staff, understand the purpose of my questions here. The appellant has brought this matter before us based on the fact that there is substantial evidence that there should have been an EIR rather than an MND. So that's what I'm trying to get to, is the narrow area of substantial evidence. One of that is expert opinion rather than statements. So understand when, as I ask these questions, I'm going to be asking the same of the appellants. So we get into the position of which experts do we believe. So again, that's the purpose of my questions.
Okay.
In summary, staff has not received substantial evidence of significant impacts of the project. No substantial evidence has been presented to support a fair argument that an EIR is required. No evidence has been presented that the decision of the planning director to grant the CUP was made in error. The appellant's recommended actions are detailed in the staff report. They are that to direct the planning director to withdraw her decision and prepare an environmental impact report that appropriately evaluates the direct, indirect, and cumulative environmental and public health impacts of the project. Staff has received some items within the past 2 days. Staff has received a letter from the Center for Biological Diversity. It's a 30-page letter with a 6,780-page attachment. Staff also received Exhibit H. Rather, the Center for Biological Diversity letter is Exhibit H. Exhibit I is a letter from Leif Deutsch. Exhibit J is a letter from Gary Cushing. And Exhibit K is an email from Kevin Hartigan. Staff has reviewed these late items, and no new issues have been raised. Staff has also compiled an errata sheet, and it details some updates to the hearing documents. Those details, or those updates, were made in the staff report, the MND, and also the conditions of approval. Therefore, based on the previous discussion, staff recommends that your commission take the staff recommended actions detailed in the staff report. Those are also listed on the screen, but I won't read them. And at this time, we have a brief presentation from Mr. Brian Baca.
Thank you, Jay. Mr. Chair, members of the commission, just some additional comments on the analysis by staff of the project. First, since it was brought up by the appellants, and is the decision that was made by the Monterey Superior Court in the Center for Biological Diversity versus County of San Benito case. That case involved a proposal by Citadel Petroleum to drill 15 wells and conduct cyclic steaming operations on a known oil deposit. And so the situation there was an MND had been prepared. The argument was made that you needed to overturn that and do an EIR because you needed to look at the expansion, the future expansion to the full development of the oil field. Well, the situation in that case was the oil deposit had already been delineated by 15 wells that had been drilled by Chevron in the 1970s, so it was known where the oil was. And so the proposal by Citadel, of course, was a pretty massive proposal to drill 15 wells and conduct cyclic steaming operations. It was essentially an economic test of a known oil deposit, that its boundaries and volume were already known. And so the court decided that, yes, you have to do an EIR and you have to look at the expansion, the reasonably foreseeable expansion of the oil field, since you already know that the oil is there and you know where it is, and you're already drilling 15 wells, and 15 wells have already been drilled, so you'd be 30 wells down the road. So that's markedly different from the case in front of you today. Today we're looking at 2 exploratory wells that are not intended to tap an existing oil reservoir. They're taking advantage of previously disturbed land on the surface, but they're not re-drilling or reactivating an existing oil deposit that's already been produced. They're looking for new oil. It's an exploratory well. And in fact, in the decision by the court, they specifically differentiate between the Citadel project and a project that has 1 or 2 wells. And I'll just quote and this is a quote directly from the decision. The No Oil Court, that was a previous decision, No Oil, went on to note that the issue thus narrows to the question of whether the city, before drilling the test wells, has sufficient data to permit preparation of a meaningful and accurate report on the impact of commercial production. No Oil did not decide that issue, but Brentwood, another case, and Lake County, another case, applied its reasoning to conclude that commercial production need not be considered in the EIRs for 1 or 2 test wells to be drilled in those cases. So this decision, and when you read it in part or in totality, says that this project falls under what the court talks about, 1 or 2 test wells, doesn't require an analysis of future commercial production of a speculative oil field that currently we have no information as to what it would be. And as I said in my response to comments here, unlike the Citadel case, there is no information by which commercial production of a speculative future oil field can be generally forecast and analyzed. So there actually would be nothing for us to analyze since it's exploratory and it's not known what's down there, if anything. And so I want to point that out, and that's Exhibit 7 to your staff report, is a memorandum where the various key points of the Center for Biological Diversity versus San Benito decision are discussed. As is usual, when I'm in this room, I turn to the page with the pink stripe on it in my CEQA book, and we're going to talk about substantial evidence. And Jay touched on it briefly, and the fact is, substantial evidence is the prerequisite for requiring an EIR. It's the prerequisite for making a fair argument that one is required. And as I commonly do, Section 15064 F5 of CEQA states that argument, speculation, unsubstantiated opinion or narrative, or evidence that is clearly inaccurate or erroneous, or evidence that is not credible, shall not constitute substantial evidence. Substantial evidence shall include facts, reasonable assumptions predicated upon facts, and expert opinions supported by facts. Well, I'll give you some examples of some of the evidence that we've received that we have found to be not substantial or credible. There's been arguments made that because a pipeline leak occurred in 1994 during the Northridge earthquake, that this project would somehow should be analyzed under an EIR. Well, the pipeline leak in the Santa Clarita area that did occur during the Northridge earthquake is an interesting event and a rare one, but the project in front of us does not involve a pipeline. There is no pipeline involved in the project. So that's evidence that occasionally bad things happen in the oil industry, but it has no bearing on the case in front of us today. Another issue was that there's a well casing that failed, and there was a leak of salt water out of a well in the Ojai area that was subsequently plugged by the operator and reabandoned. Well, that was one well. It was drilled in 1911 under uncertain engineering conditions, and you had a casing failure. There are 12,000 wells that have been drilled in the Ventura Basin, and one anecdotal episode of one well that was drilled in 1911 does not mean that a modern well drilled under current standards will have suffer that fate and have a casing leak. This is the kind of evidence we've received that really does not relate to the project at hand. In terms of professional qualifications and who can provide expert opinion, the state of California, the law that is, has found that certain professions and certain practices can only be done by licensed individuals. And in fact, substantial evidence on the record before your commission or really any public hearing body in certain fields of endeavor can only be done by licensed professionals. Therefore, if someone is giving testimony on a medical issue, that person has to be a licensed physician in the state of California. If they're not, that's a violation of the Business and Professions Code. If someone's giving testimony on engineering, similarly, they would have to be a licensed engineer licensed by the state. That goes for geology as well. If you're trying to make a point on geology, you can certainly, as a citizen, make a statement, but it's not substantial evidence on the record because you have to be an expert, and in California, that's recognized by someone licensed by the state of California as a professional geologist. So, and I would point out that CEQA as well has the same provision. In CEQA section 15149, it talks about the use of registered professionals in preparing EIRs. And again, in certain fields of endeavor, you can only write something in an EIR that its source was a licensed professional. So you may hear a testimony regarding geology, engineering, hazards, and things like that. If it's geology or engineering or medicine, you have to have a licensed person in front of you. You can consider it as lay opinion from the public, but it can't be considered substantial evidence on the record. A question that you may have thought about when a slide flashed up on the screen is why were there 2 permits for this same project? The project was originally proposed in 2008, and that was under case number LU 08-0100. That conditional use permit was approved by the planning director, passed all its appeal periods, and was a permit in good standing. Later on, within the year after the CUP had been granted, the applicant came in and had decided that they needed to do some additional grading of the road and of the drill pad that was not considered in the previous proposal. And so we looked at that, and we determined that that was a substantial change from the original permitted project, so they had to file for a permit modification. That is the permit in front of you today, is now we're looking at the full scope of the project when the previous project description did not fully include all the grading and changes of the site that are now in front of you. So that's why there's 2 permit cases. But there's actually an outstanding approved CUP for this project, although it's not exactly designed as it is now today. And so the applicant wants to do what they want to do, and so that's what we've analyzed. Some general comments.
Can I just jump in with a question?
Sure.
Does that include the upper pad, the existing CUP that's approved by the planning director? Did that include the upper pad, or is it just this one?
I believe it includes the upper pad as well.
Thank you.
Excuse me, when does the original CUP that was granted, what's the expiration date on that?
Well, that's actually a question I have for council, because this is an unusual case in that we have a CUP that was granted. I believe the applicant applied for a modification before that CUP expired, and so it may be that the time is told. We haven't actually given full thought to that question as to whether that CUP is still alive or not, because the applicant has a new proposal now.
County Council?
I haven't given that issue any analysis, but I think for purposes of today's hearing, the project before you is a project that is described in the CUP modification, and so that's what you should focus on, as opposed to what was in the previous CUP. Or I should say the existing CUP. But
Okay.
my point is that the applicant has decided to modify their project, and that's what they're asking your commission to weigh in on today. That they've decided not to go ahead with the project that was described in the existing CUP, and so we should focus on the modified project that's before your commission today.
So would this supersede that one? I'm just specifically interested in that upper pad, because
Yes,
there's a lot of discussion in this.
Yes, it would.
Okay.
Most definitely.
So what was the length of the original CUP? What was the timeline on the
The
original
length,
CUP?
it was 8.5 by 11. Sorry, I couldn't.
I came in with a headache this morning, so.
Sorry, Chair.
I mean,
Rodriguez.
what was it,
It was
3
same
years,
5
5
years.
years, 25
Same
years?
5 years.
How long?
It was a 5-year permit.
Okay.
That hasn't changed. And so, anyway, I have a few other general comments. The site, as you saw in the photographs, the road is existing and existing used, and you saw there was a cattle trailer there, and so this is an active cattle ranch, and you can tell by the material that is on the road at various places that you have to step around that there's active cattle operations going on the site. The road is used. It's never revegetated. In fact, parts of the road are paved. Because this site was actually operated by a relatively major oil company for a short period of time, and they paved parts of the road. And so there's still some remnant paving along the road. So none of the road is habitat. It's been a road and it's been actively used, and none of it's overgrown. So it's an existing road in really good shape. One thing that you notice in the slides is that there's one creek crossing, and just one. And the creek goes through a very shallow swale there, and at that very point is an oil seep. So actually, when you're at the thalweg of the creek, or the low point of the creek, you would be standing in tar, because there's a natural oil seep right at that point, and it's currently 15 foot clear, and there really doesn't have to be any grading in terms of grading through a dip or any kind of a crossing. You just drive right over the rocks that are sitting there, and so there's really nothing has to go on at that creek crossing, and it's already disturbed and currently used, and the remainder of the road is quite a ways from the creek in most places, and really the project doesn't get back close to the creek until you're at the drill site. And the drilling area is also interesting in that if you notice from the pictures, we had the pictures with the line of rocks, and then we had a picture with some green grass on there, obviously taken at different times of the year. But there's no substantial vegetation growing on the pad. And I believe that part of the reason for that is that it's an artificial fill. That area, as you know, has been the subject of oil activity since the 1890s, and both banks of the creek are fill. There's artificial fill from the road grading and pad grading from way back in the past, and the creek at that point is sedimented with broken chips of shale that are from the bulldozing and creation of all the drill pads in the historic past. And so it's a very disturbed site, and other than the pad there's some revegetation growth going on, but it's not a pristine site. So you basically have a good road all the way back to the drill site that doesn't need really much work, and the drill site itself is not substantially vegetated. I already mentioned that all of our mitigation measures recommended by the U.S. Fish and Wildlife Service have been incorporated, except for the one recommending a change in county policy, which the applicant cannot do. We did receive a late exhibit yesterday that is a letter from the Center for Biological Diversity with 6,780 pages of attached exhibits. We've actually gone through the 6,780 pages, and the material, in fact, thankfully they provide a list of what these references are. These are references cited that they list on their report. And I would say a lot of this is very interesting material, but it doesn't really directly relate to one is I can just give you some examples. One is from an article from Daniel Arthur, Hydraulic Fracturing Considerations for Natural Gas Wells of the Marcellus Shale, which is in Pennsylvania and New York. That doesn't really have anything to do with the DECOR project in Peru. We have another one, the British Columbia Oil and Gas Commission investigation of observed seismicity in the Horn River Basin. That's of course in Canada. There's a report from California Department of Conservation, DOGGR, and that's the preliminary report for California oil and gas production for 2012. That's production statistics. Well, I mean, the applicant hopes they become part of the production statistics, but it doesn't really have anything to do with the case before you today. And I'm going to read just a couple more and then end the suffering. They have Colorado Department of Public Health and Environment, Conservation Commission, Colorado Weekly and Monthly Oil and Gas Statistics for the Colorado, the Four Corners Air Quality Group, Four Corners Air Quality Task Force Report. Of course, that's Four Corners is in New Mexico, Arizona, Utah, and Colorado. They have 2-year survey comparing earthquake activity and injection well locations in the Barnett Shale, Texas. But the project in front of us does not have an injection well. There will be no injection going on. They don't frack. They don't have any injection. They don't have a pipeline. And so a lot of this material relates to oil and gas activities at various parts of the country, but they don't relate to the project in front of us. So, while the stack of paper is rather high and substantial when you have to carry it, it doesn't constitute substantial evidence on the record for CEQA or decision-making purposes. I believe that's it for my commentary. I and Mr. Dobrowolski and Ms. Harris are available for your questions.
I have a question. You're familiar with DOGGR. Would you explain to me the definition of an experimental well versus a confidential well, and the restrictions that are placed as far as release of information?
Mr. Chair, the Division of Oil and Gas, well, let me back up slightly. When an oil company, and I've been there on the oil company side, as you know, when an oil company is drilling a well to a unit or a zone, a geologic zone below the ground that is not on production, in fact, they're not sure there's even any oil in it, that information, whatever you find in your well, can be of value to other oil companies for leasing purposes. If you know something that another oil company doesn't know, then you have the advantage in getting oil and gas leases and negotiating. So that's why the oil companies would desire to have certain information about what's in a wellbore confidential. The Division of Oil and Gas has the ability, under the law, to grant confidential status to various wells, and the criteria is that they would be drilling the well to tap a formation that is not on production anywhere else. It's not part of an existing oil field or oil producing zone, and they can be granted confidential status. And informally, we call that an exploratory well.
So that's defined as an exploratory well. What is the obligation on the driller, for lack of a better description, the person, the company drilling? What is their occupation as it relates to reporting that information I understand what you're talking about with regard to the depth and how they did it, and where they went with it, and what the results were based on various issues. But what about the process itself and how they got to those results? The process in their drilling.
Well, the oil operator has to report everything to Dogger. There are no secrets from Dogger. It's confidential in terms of the State Division of Oil and Gas will not release that information because it's been granted temporary confidential status. The oil company has to report everything, the directional program of the well, the depth, the zone, the geology. They have to report everything, anything they produce, any test results. They have to report it all. The issue is whether the Dogger releases that information to anybody else. Now, Dogger can release it to a government agency. They can't release it to the public because it's got confidential status under state law. Now, that status is generally granted for a year, but with various extensions allowed under the law, the maximum that the confidential status can remain is 4 years. So after 4 years, all of that information that the oil company would have turned in to Dogger 4 years after the well is drilled, it would be public information that we put on their website and be available to all.
Okay, thank you. Any other questions of staff?
I don't
Mr.
need an
Westner.
answer right now, but one of the things that analysis this is the reason for the 2.5 radius. I'll just save it for later because that's one of the contentions that the appellant has made. So I want to visit that a little bit later on.
Okay?
Thank you.
Okay, I'd like to take a brief break. Let's come back in 10 minutes. Thank you. Technical problems with the recordings, and so thank you for bearing with us.
Yep, or if you have no further questions.
Not now. Yes, we do. Commissioner Dukas.
I had a number of questions, and I thought that it would be helpful to get them out of the way first instead of waiting for public testimony. On page 75 of 408 in timing, there's a paragraph, in the paragraph that says timing. You know how there was a difference between whether to use caution tape or construction fencing? I noticed an inconsistency, and I just wanted to make sure that it was consistent throughout, that it would be construction fencing and not caution tape. And that's on page 75 of 408 on the paragraph called timing.
Mr. Chair, Commissioner Idukas, if we missed one, we'll make sure that it's consistent throughout.
Just wanted to be sure of that. And then on micro trash on page, it's either page 78 or page 26 of 104. Is there some kind of more inclusive, like such as, not limited to, and have the iteration of the different things that need to be controlled in micro trash? And I didn't notice cigarette butts being enumerated, and I thought that would be one that would be helpful.
We can add more and add the not limited to language.
Yeah,
to that.
and bottle caps, pull tabs, gum. And then also, I was wondering if the area of known microtrash should include the access road that leads to the project site. If there could be, a sweep through to make sure that there's no microtrash, because that is part of the project.
We could add that.
Okay. And I wasn't sure how the monitoring of this mitigation measure occurs. I couldn't find it. It might be fine. Page 84, Oak, is not okay, O-A-K. It's just a little misspelling, but it just amused me. It's an okay tree.
Where's well, actually,
I thought it was okay.
we talked about several protected okay trees.
It's just, yeah, it's just page 84
Okay, I got that.
as I was going through. Okay. This one I get to skip because I found the answer. Ah, my favorite. It's either page 136 or page 84 of 104 on the water supply for a temporary hand washing station. Is that part of the porta potty? I remember this coming up before in Santa Paula. The guys had porta potties and no hand washing. In an oil field. It's terrible.
I know what you're talking about. I've seen them at a soccer field, and we can make sure they have that available.
Yeah. I think there might have been a typo someplace, but I just want to hammer down. The site of the nearest condor nest is 1.5 miles away, right? It's not 0.5, it's not 2.5, it's 1.5 miles away. Is that correct?
Mr. Chair, well, I probably should defer this to Holly, and she may have a better answer than I have.
Okay, thank
But my
you.
understanding is that from the upper pad, there was a condor nest a mile and a half from the upper pad, and that pad's been eliminated from the project. But go ahead.
Yeah, Mr. Chair, Commissioner Dukas, based on the information that we received from U.S. Fish and Wildlife Service, the closest condor nesting site is approximately 2 miles from the lower pad. And the upper pad would have been within approximately a mile. But again, these numbers are very approximate, just given the data that we received.
Understood. Okay, thank you. There was a question about, on page 177, about greenhouse gases. Were greenhouse gases analyzed in this MND?
Mr. Chair, Commissioner Idukas, as part of your errata sheet, we have incorporated a analysis that we did on greenhouse gases into the MND. Essentially, this issue arose with the Murata Petroleum case that your commission reviewed last year, and that involved 9 new wells, and it's the same mathematics. It's per well the amount of greenhouse gas emissions, and so essentially the emissions were 2/9 of what was analyzed in the previous oil case, and so we've put that analysis, and it's included in the errata sheet and is incorporated into the MND.
Okay, that might head off discussion of that as we open the public hearing then. Is the only measure with regard to impacts to condors that wasn't incorporated as part of this the buffer zone, or were there other ones that were not, that didn't apply? I was just wondering, there's a statement on page 197 of 408 that says all of the measures should be conditioned, they should all be part of the conditions of approval. And I wasn't aware of which, I couldn't ferret out which ones weren't included.
Mr. Chair, Commissioner Idukas, there are 23 enumerated measures listed in the U.S. Fish and Wildlife Service memorandum or letter of July 2013. I believe it's July 18th, 2013. We included all but number 1.
Okay.
And number 1 has to do with a
Right,
policy matter,
right, you said
which
that.
the applicant doesn't have any authority. In fact, we don't, as we sit here, to change county policy to prohibit something.
Understood.
See, if the applicant wanted to propose at some future date, or someone else, a drilling pad that's closer to the forest, they can currently do that under county policy because there's no prohibition in county policy. And this applicant, while they're consistent with that, the drill site that is now the focus of this proposal is more than 1.5 miles from the nearest condor nest. So it's not a problem with this case, but we can't impose the burden of creating a county policy on a private applicant.
Right, you said that previously, but I
Yeah.
just wondered if there were other ones because it's
No,
part
no.
of it's part of the critique
I understand. We've received a lot of information and suggestions from the Los Padres Forest Watch organization, Mr. Kuiper, and we agreed with him, and we put all the mitigation measures in there. I'd just like to point out that some of the mitigation measures, which we didn't originally put in, we didn't see the connection to the project. One of the mitigation measures is that no one should have any firearms at the project site, and also they shouldn't be shooting anything with the firearms. Well, the applicant hadn't proposed having armed oil field workers out there, and we didn't think that was really necessary. And originally, the wildlife agencies didn't think that was necessary either, to have a specific ban on having firearms out there. But through later commentary, we decided to go ahead and put it in. But it's not something that was part of their proposal, and we hadn't really considered that to be a reasonable possibility that they're going to be out there shooting condors. And so, but we put it in there. It's in there now.
Okay. On page 221, or page 13 of 13, on timing, it has a section on photo documentation. And I wondered, and it was to document that the mitigation measures, I guess the signage and the picking up of microtrash. I was wondering how often that photo documentation will be required. Is it quarterly? Is it?
Well, this particular thing talks about, before they even start construction. That's what this measure's about. But you're talking about
going forward.
But going forward, how often will we monitor the site?
That's right.
Well, I guess that would be a discussion of today's hearing. I mean, normally under a CUP, we'd normally monitor every CUP every 3 years. And we could add specific language if you have some frequency that your commission would like.
Well, the only thing that caught my attention is in other instances we've had as a mitigation measure, a sign to say to do something, but just because you put up a sign doesn't mean that people are going to do it, including washing their hands.
Mr. Chair, Commissioner Idukis, I would point out that the Division of Oil and Gas will be inspecting the site every year. So
for microtrash?
Well, we are trying through our oil and gas program, Ms. McGee, we're coordinating with them to try to sort of piggyback on their inspections. And so we could do that, and we could participate in the inspection that the Division of Oil and Gas does for other reasons. They do them for environmental reasons as well. And we could probably have them photo document the site and give us the information when they go out on their site. Mr. Hessen over at Dogger has been very helpful in coordinating things like that.
Mm-hmm. And not just microtrash, but the things like loose caution tape or whatever else that condors like to play with.
Well, we have no caution tape anymore, as you pointed out a few minutes earlier.
Okay. Tubing, wires.
The applicant fully understands that it has to be a fastidious site with no junk lying around. Which is different than my history in the oil business. I look at the sites today, and they're quite clean compared to what I recall.
Terrific. Pages 260 to 263, there is discussion about an end run around the Board of Supervisors fracking disclosure requirements. And I wasn't aware that the Board of Supervisors had fracking disclosure requirements, but I guess there's a concern that somehow by approving the CUP that there'll be a way to get around whatever those requirements are?
Mr. Chair, Commissioner Idukis, the Board of Supervisors directed the Planning Division to include certain questions in the application questionnaire for any oil and gas project. And among those questions were, are you going to be doing any hydraulic fracturing or well stimulation as defined in SB4? And so that's a question we're asking. And if the answer is yes by the applicant, then we would analyze that as part of the whole of the action under CEQA, and that would be part of our analysis. If the answer is no, you're not going to be doing fracking, well, that's fine, but you're also going to have a line in your project description that says hydraulic fracturing is not authorized by this permit. And so in this case, the requested permit would strictly prohibit that practice.
Okay. Guess one I'm skipping.
Well, she's looking up some additional information. How would we know if it occurs, we as a county?
Mr. Chair, the Division of Oil and Gas, of course, gets notified of everything that is done on an oil well, and all the hydraulic fracturing jobs are now posted online at the Dogger website, the State Division, the Department of Conservation website. And we regularly check it to see, because we do have a couple of CUPs that prohibit fracking. The Murata case that your commission dealt with last year, and there's actually another permit in the Ojai area which also prohibits fracking. So we are monitoring, and basically every frack job that's proposed goes onto the website, and we would get notification. Now, you really can't hide a hydraulic fracturing job. It involves all kinds of equipment, trucks, tanks, and things like that. So it's not something you can hide. There's another factor here, that the pumps that are used for the hydraulic fracturing job require a temporary permit from the Air Pollution Control District. These are generally diesel pumps that do this. And so there's another checkpoint that we have with the county of telling when one is occurring. So I'm pretty confident that there won't be any secret frack jobs in the middle of the night.
Okay.
Commissioner Dukas.
Moving forward, on page 312, T3, there's a phrase that seems to be ambiguous, and I want to get clarification from staff. It says that staff is unaware of any evidence that condors frequent the lower drill pad and roost in close proximity to it. This was a response to comments. Do you want to say definitively, when it's kind of ambiguous when you say staff is not aware, well, somebody could make you aware. So do you want to respond to that a little more clearly, please?
Mr. Chair, Commissioner Dukas, based on the habitat that is present at the site, there is not roosting, nesting, or foraging habitat for the California condor on the drilling pad, given its sort of topographic nature. Records that we have from U.S. Fish and Wildlife Service do indicate that there is feeding and roosting habitat approximately 2 miles to the northeast.
Okay.
But the nature of the site is not conducive to condor activity. They do fly through the area, as is evidenced in maps that have been provided to us by U.S. Fish and Wildlife, hence the application of Mitigation Measure 5 for the best management practices for the condor.
Okay.
Does that answer your question?
Yes, it's much more clearly. It did seem ambiguous to me to say staff is not aware.
Yeah, I can
just-
understand the confusion. Okay.
Okay. On page 354, again, this is the area that should be inspected daily for microtrash. I've got another note here that I believe it should include the road leading to the project. There was a criticism on page 406 that there wasn't a pre-construction survey performed for the condor. I'm assuming that there will be a biologist that will be on site prior to construction?
Mr. Chair, Commissioner Dukas, a mitigation measure requiring pre-construction surveys, relocation, and monitoring was added consistent with the recommendations from the California Department of Fish and Wildlife. That mostly pertains to small terrestrial species such as the silvery legless lizard. However, if a condor should be encountered, which is extremely unlikely during pre-construction surveys, that would require notification of U.S. Fish and Wildlife and other resource agencies consistent with that mitigation measure. But there will be a biological monitor
There will be a biological monitor, okay. And then do they have authority to stop work?
I believe they do. Let me just confirm real quickly. The provisions of that. Well, it doesn't specifically say that work would be halted should a endangered or listed species be found, but for consistency with the California Endangered Species Act and the Federal Endangered Species Act, the proper process for stopping work would be adhered to.
So does that mean that, I'm not readily familiar with that. I'd have to look it up. Do they have the ability to stop work?
Mr. Chair, Commissioner Idoukis, we could add a sentence here in the requirement that work can be stopped by representatives of the wildlife agencies if deemed necessary.
Okay. And then, is there an employee environmental education program that's available for, construction crew or, roustabouts or whoever happens to work there?
Mr. Chair, Commissioner Idoukis, we could add a condition of approval requiring a environmental awareness training.
Is there such a program?
Well, that has been applied to other oil and gas facilities, such as those down at McGrath Beach, and could be applied in this instance as well. So the county-approved biological consultant could be required to host a worker education training prior to use inauguration.
Okay, I think it's a good idea. There's a lot of information about seismic risk, and I just want staff to go over that again briefly. It says that there's a risk of seismic action, I guess, posed by the wastewater disposal. That's on page 345.
I'm 100 pages away. Give me a second.
Okay. And it's page 345 of, I think it's in the Sea Frog. I think it's in the Sea Frog letter.
I'm not at your point here.
Well, at this point, I cleverly left off 345 out of which, so I'm not sure which document it is. I think it's the Sea Frog one that talks,
Well-
there's a lengthy discussion about seismic activity and the risk posed by all sorts of
okay.
activities.
Well, as Mr. Chair, Commissioner Idoukis, there's a specific paper that is included in the ND called a topical response to comments, where I talk about seismic hazards and oil spills. And just for the record, my name is Brian Baca. I'm a registered geologist, certified engineering geologist, and certified hydrogeologist licensed by the state of California. And I have 30 years of experience in doing this stuff. Like most of Southern California, we have active faults running virtually everywhere. And of course, we have earthquakes, like the 1994 Northridge earthquake. By and large, those earthquakes do very little damage to oil wells. Remember that an oil well is a hole in the ground that is cemented in steel casing, cemented into a hole in the ground. It's not a structure on the surface that can flop sideways and then fall over. And so there's almost no record, almost no, and I'll tell you what the almost means, of wells being substantially affected. There are occasions where a well has been sheared off by an actual fault, because many wells drill right through active faults. And that's the case throughout the Ventura Basin and the LA Basin. During the Long Beach earthquake, some wells were sheared off by the Newport Inglewood fault. Well, that's what you would call an effective abandonment, because you really can't abandon a well any better than having it cut off by thousands of feet of the earth, and it's thoroughly plugged. So there really is just, there really is no real seismic hazard involving oil wells. And in this case, the commentary was that we're next to the San Cayetano Fault. Well, yes, we are. And in fact, the next oil fill over, there are oil wells that drill right through the San Cayetano Fault and are producing an oil zone that's on the downward thrown block of the fault. And so, but that's a common thing. Matter of fact, the reason we have all the oil fields that we have is because of the active faulting in the Ventura and Los Angeles basins. And so I agree with the science that's been done, but just on a practical planning basis, the science that was done by my college roommate, Dr. Tom Rockwell, who's now a professor at San Diego State, he did this back in 2002 with a partner, James Dolan. They looked at trenches that they had excavated across the San Cayetano Fault in the Piru area, and they found that there was likely a large earthquake that broke the fault approximately 200 years ago, but nothing since. Well, you have an active fault, and we know if you're given thousands of years, there can be numerous large earthquakes along that fault, but we're talking about a 5-year window for this project. And so you have a fault that hasn't broken in 200 years, and you have a 5-year window. It's not reasonably foreseeable that we'll be lucky enough that that particular stretch of the fault will break during this 5-year period. No one would predict that with any certainty. And then, on top of that, the second level of uncertainty is that even if there were a major earthquake there, that it would do some kind of damage to the wells. Then the third level of uncertainty is whether the damage to the wells would cause any kind of an oil spill. So there's so many levels of uncertainty on the side that nothing's going to happen. It's just not reasonably foreseeable that the fault will do anything to these wells.
I appreciate all that. I think the argument that's in our packet, there was a thing called induced seismicity potential in energy technologies, and it's just pages and pages and pages of, I guess, a position that these activities cause earthquakes. That was my understanding as a layperson.
Well, Mr. Chair, Commissioner Dukas, a hydraulic fracturing job is an earthquake. When you break rock below the ground, it's an earthquake. You're breaking the rock. That's what an earthquake is. Rock breaks below the ground and it sends shock waves through the earth. But a hydraulic fracturing job is a very small breakage compared to the earthquakes that occur naturally every day and every week in the Southern California area. I think that I pointed out in my memorandum, the topical response, a dozen or more earthquakes that have occurred in that very same area. And why is that? It's because the San Cayetano Fault is active and parts of it below the Earth's surface are in constant motion, and you have micro earthquakes or small earthquakes all the time in Ventura. And from that fault and several others that crisscross the county. In fact, a place that has a great seismic hazard, in my view, is the Ralph's Market down here on Victoria. And you'll notice that there's a hill right behind it. And you've got to ask yourself, why is there a hill behind Ralph's? And that's because a major fault runs right under that area and right out to sea. So we are living with faults, and so there is just an incredibly negligible concern regarding seismic hazards and these two oil wells that are proposed.
Okay. The Los Padres National Forest and the BLM, it's in our report that they propose 30 minimization and avoidance measures to minimize the potential for condors to become habituated to the area. Are those different than the 23 that were by U.S. Fish
My
and Wildlife?
recollection is that it's 23, and Ms. Harris can check me on that. It's the July
Page 149 of 187, I think, on the Forest Watch letter, talks about Los Padres National Forest and the Bureau of Land
well,
Management, and I guess
do you
also
have
the
do you have
U.S.
another page
Department of
number?
Interior.
Do you have another page number for that letter?
I'm afraid not. 149 of 187 is what I wrote down, but I had computer problems, so I was doing this with, the
Well,
old-fashioned
we
way.
have approximately 8,000 pages of material, so you give me a minute and I can find that.
Is that all? How's that compare to Simi Valley landfill expansion? And that'll be my last question.
Do you have the July 18th letter?
Perhaps staff can follow up on
July
that
18th.
and bring that information back to us for clarification later.
Sounds good. Thank you.
Here.
Okay.
Hold on, we're going to
I'm sorry, go ahead.
respond to Commissioner Dukas.
Didn't realize it was so readily available.
Mr. Chair, Commissioner Dukas, the mitigation measure that was incorporated into the MND represents communication directly from U.S. Fish and Wildlife to Ventura County, which was basically developed specifically for this project. I'm assuming that was based on research and the latest sort of science and ecology that would be applicable to this area. So I can't speak to the level of detail that was in previous plans that were prepared for oil and gas by the BLM and Los Padres Forest Watch, but this represents the latest direction from the U.S. Fish and Wildlife Service.
Thank you.
Excuse me, that concludes the staff report at this time. Before we hear from the representative from the applicant, just a public information announcement. We've been here for almost 2 hours. The parking lot directly behind us here has a time limit on it, so if you happen to be parked in that zone, it might behoove you to move your vehicle, or at least consider that. Okay, I have a card, Eric Nagy for the applicant.
Mr. Chair, point of order.
Excuse me. Yeah.
Is this time for disclosures of the commission, please?
Thank you. I appreciate
welcome.
your reminder. Disclosures, please, by the commissioners.
No disclosures.
Mr. Dukas.
I looked up how many California condors were currently in the area, and I printed it out. This is just part of my birding activities.
Commissioner Westner.
No disclosures except other reading the notice in the Star that this commission hearing will be taking place today.
Commissioner Onstadt.
I have no disclosures.
Like Commissioner Westner, I also read the article in the local newspaper the other day. Otherwise, I have no disclosures. Okay, speakers. Eric Nagy on behalf of the applicant. And while he's coming up, I have a card on behalf of the recommended action, and I have a card on from a Jennifer Sage with no indication at all what side of the equator she's on here. So, if you're in the audience, are you oppose? Okay. Mr. Nagy.
Good morning, Mr. Chair and Planning Commissioners. I'm Eric Nagy from Jensen Design and Survey, representing the applicant Decor. As you know, the Planning Director approved the CUP modification for this exploratory drilling project, and we concur with staff's recommendation to your Commission for denial of the related appeal. There's quite a bit of information in the staff report, so I won't reiterate all that. But in particular, much of the material presented by parties commenting on this project, as staff has mentioned, such as fracking discussions and case law, is not relevant to our project as defined in our project description. County and state regulatory agencies have applied conditions to the project that address concerns related to environmental impacts. We've worked with them for several years to address all of their concerns and to incorporate these conditions into our project. And we certainly appreciate the efforts of staff over the past couple of years on this. I think they've done an admirable job of addressing the public's concerns. We certainly understand the public's concerns, and we appreciate that. I don't think there's really too much more for me to add here. Staff, I think, covered it all, so I'm available at your request to elaborate on the proposed project and respond to questions as you see fit.
Commissioner Dukas.
Do you have any objections to incorporating some of the extra language that I was suggesting as I was going through?
Mr. Chair, Commissioner Dukas, no, we don't. We think that's all perfectly reasonable.
Okay. And then let me ask you something just generally about risk.
Sure.
These are exploratory wells. Is there a chance that that it's played out?
From what I understand, this is a new formation. There's always a risk with exploratory drilling, I couldn't quote you an exact percentage.
Risk that
that no
that
oil
it
will be
won't.
found. That's correct.
Say that again.
That no oil will be found.
Okay.
Yes, there is
Or
that risk.
or that it wouldn't be economic to invest to.
That's correct. There's with all exploratory drilling, there is always a risk that comes with that you won't find anything. And that's part of the business.
And are you going deeper? Are you going directional? Or are you at liberty to say? I know it's not our purview.
I couldn't speak to the bottom hole aspects of the wells. I do know the land use part of the surface. That's what I'm tasked to deal with as a consultant here.
Okay. Well, there's a lot of argument that it's absolutely certain that there's oil there, and I thought, well, then sign me up. Just to I'm joking. There is a risk that it wouldn't be in levels that would make it economic to go after, right?
That is correct, Commissioner Idugas. There's absolutely a risk that these won't be productive.
Okay, thank you.
Mr. Chair,
Commissioner Westner.
I just want for clarity, because of the discussion that's been in the 8,000 pages of documents that we received, that the applicant clearly understands that this is a temporary permit for exploratory purpose for 2 wells. It doesn't grandfather you the right to expand this without coming back either before the planning director or this body. Is the applicant clear on that?
The applicant is very clear on that, and in fact, that is why the permit is written as such, is partly because of the applicant's request.
Okay. With that, with the other conditions that the county has placed on you, do you have any exception to those?
We do not have any exception to the conditions as written, nor those that Commissioner Idukas has proposed today.
Thank you, sir.
I have a question of County Council. Let's assume that whatever Decor is investing here proves fruitful, and it obviously you want to expand what is there now. Is there anything that prohibits the county from requiring a full environmental impact report given the issue of expansion beyond 2 exploratory wells, or is that an issue that this commission is prohibited from addressing at this time?
I'm not positive I understood your question, but basically this is a 5-year permit for 2 exploratory wells. If Decor subsequently proposes to add wells for exploration or for production, then that would require a subsequent granting of a discretionary approval, whether it be a modification or new conditional use permit. And as part of that discretionary permit processing, a new review of the proposed project expansion or new project would have to take place under the California Environmental Quality Act. And so based on the potential impacts of that expanded project, at that point in time, the decision would be made whether an environmental impact report was required or some other environmental document. And so the long and the short of it is, if this project were to be expanded in the future, that would require new discretionary approval and new environmental review.
Thank you. Other questions of Mr. Nagy? I have one other card, supports recommended staff action from Brett Matthews. I assume you're in support of the applicant. If you come forward, please. Do you wish to speak?
Yes. This is to support the action to deny the appeal.
Did you have any other?
I just want to make sure I was on the right side.
Okay. We have multicolored cards, a red and I think and a white, and so these white cards tend to indicate to us that we have a speaker who wants to make comments. But if that concludes your comments, you're free to sit down.
Yeah. so I'm allowed to
If you'd identify yourself for the record.
Yes,
please.
my name is Brett Matthews. I'm the Director of Public Policy and Government Affairs for the Ventura Chamber of Commerce. I'd like to thank Commission Chair Rodriguez and the Planning Commission for their work on these continuing issues, and also commend staff for their diligent work on this matter. As previously stated, this appeal is without merit. Staff has studied this matter thoroughly and made a thoughtful, nonpartisan decision based on facts, not fiction. We're walking a slippery slope when outside groups are allowed to contest well-researched decisions by staff whose job is to come to unbiased, balanced decisions. I would ask that the Planning Commission deny this appeal on the grounds that it is without merit, and I would also like to thank Commission Chair Rodriguez, the Planning Commission, and staff for their continued hard work on issues such as these. Thank you.
Okay. Moving on, I got the applicant, excuse me, the appellant, Citizens for Responsible Oil and Gas. Who was the primary speaker for that, and would you come forward? I understand you have a...
We're letting Mr. Kuiper of Los Padres Forest Watch.
Pardon me?
Mr.
Would you come to the podium, please? Identify yourself.
Certainly.
Two groups are the appellants in this case, Citizens. I'm John Brooks, with the president of Citizens for Responsible Oil and Gas. Two groups have appealed this decision. The other is the Los Padres Forest Watch. We've discussed among ourselves, and we believe that it would be appropriate that Jeff Kuiper, the executive director of Los Padres Forest Watch, would begin the appellant's presentations.
Speak on behalf of both groups.
No, just on behalf of Los Padres Forest Watch.
Oh, I'm sorry. Okay.
Jeff?
Good morning. Would you identify yourself, please?
Good morning, Chair Rodriguez, members of the Commission. My name is Jeff Kuiper, the Executive Director of Los Padres Forest Watch. And I have my cell phone up here because it's serving as a stopwatch, so that way I don't talk for an hour. Is that a good idea?
I didn't know you intended to talk for an hour.
Strange things happen when you come up to the podium. No, I will be up here 15 minutes tops.
Okay, thank you.
Just to let you all know. So again, I'm the Executive Director of Los Padres Forest Watch, and we're interested in this project because we have concerns whenever an abandoned or a new oil field is proposed to be reactivated in close proximity to the Los Padres National Forest, particularly when it's in habitat for the California condor. So I'd like to briefly summarize the reasons for our appeal. Some are more detailed than others, but I intend to get through all of them pretty quickly this morning. The first one, we're concerned that the Planning Division unlawfully segmented the project description. Second is there was a mandatory finding of significance in the mitigated negative declaration that should automatically trigger preparation of a full EIR. I'd like to address the inadequate analysis of cumulative impacts. Of course, I'd like to address some issues regarding endangered California condors. And last but not least, I'd like to make a brief point about the setback from Modelo Creek. So the first issue, the segmented project description. So what's our baseline here? What do we start off with? So let's look at the CEQA definition of project. It means the whole of an action, the entire part of what's being proposed, which has a potential for resulting in impacts to the environment. Courts, when they look at this definition, they interpret it extremely broadly, and they interpret it in a way that maximizes protection of the environment. So what we don't want to see under CEQA is the applicant or the lead agency segmenting or piecemealing a project into small bits to avoid a finding that the entire project as a whole will have a significant impact, because you can literally break down a project into small enough pieces to where it won't ever have a significant impact. And so we'd like to see, and CEQA actually requires the county, the planning division to look at the whole of the project. What is the whole of the project? Well, it's stated quite clearly under the conditions of approval up on the screen, page 1, number 1, project description. It authorizes the drilling, testing, reworking, production, and maintenance of up to 2 test oil wells on one drilling pad. And this is the important part, to determine the commercial viability of the reaction of the Modelo area of the Piru oil field. The county dismisses our arguments that they need to look at the whole of the project, including reasonably foreseeable future development of the oil field. Throughout the response to comments, the Planning Division considers any future development as speculative and uncertain. And we respectfully disagree with that characterization. So if you look at a map of the historic oil wells that have been drilled throughout time in the Piru oil field, which is right here. This box right here is a Piru oil field. It's adjacent to the Hopper Canyon oil field over here, and the Temescal oil field up here. And there's a tiny little oil field over on the right-hand side called the Piru Creek. It's also been abandoned for a while, but it's becoming reactivated as well. So onto the subject oil field, Piru oil field. Each of these black dots represents a historically drilled oil well. We know that this oil field is abandoned currently. The proposed drill site is this white dot just about right in the middle of the screen there. And you can see there's quite a bit. There's actually 63 oil wells that have been drilled historically in the Piru oil field. Quite a few wells have been drilled in the Hopper Canyon oil field as well, and as well in the Temescal and Piru Creek. So we know that this place has a rich history of previous oil drilling going back nearly a century. We know that they found oil in the past, and I think it's reasonably likely to assume that they'll find oil again, particularly considering that there are active oil operations here in the Hopper Canyon oil field, over here in the Piru Creek oil field, and up here in the Temescal oil field. It doesn't take an expert to come to the logical conclusion that, yes, since this area has such a history of oil drilling, and since it's surrounded by active oil wells, I think there's a good chance that they will find oil in that area. So what else do we know? We know, and you can't see the numbers, but I'll read them to you. This is the last time that Dogger prepared a cumulative calculation of the amount of oil that has been recovered in each of the oil fields in California. It was 2009, and again, this is the most recent analysis, which is good enough for our purposes because this oil field has been abandoned for nearly 20 years. So cumulatively, the Piru oil field produced 482 million barrels of oil and 156 million cubic feet of gas over its lifetime. And again, that's just important because to show that, yes, there has been not just a minimal amount of oil production in the Piru oil field historically, but quite a bit. And this map shows the wells that, I think I did that last time. It's that button that is right where my thumb goes. Thank you very much. So this map shows the active oil wells in these 4 oil fields that are actually operated by Decor, the project applicant in this case. The Decor wells are indicated in yellow. So you can see quite a few active Decor oil wells in the Hopper Canyon oil field, quite a few active Decor oil wells in the Temescal oil field, and a couple of active oil wells in the Piru Creek. So again, there are 27 active oil wells in the Temescal field, up in the upper right corner. 15 of those are operated by Decor. And in the Hopper Canyon oil field, there's 11 active oil wells. Again, this map shows all historic wells. There's 11 currently active oil wells. All of those are operated by Decor. So I think we'll be hearing a lot today about this particular court decision that came out just a couple of months ago, Center for Biological Diversity versus San Benito County. And the Planning Division is trying, I'll give them props for trying to distinguish this San Benito case from our instant case here But really, in my 15 years of working on legal and policy issues, particularly with oil drilling, condors, and looking at environmental impacts, there's not a case that I've seen that is so clear and on point to an issue that I've been working on as this particular case. In both cases, both project applicants, and it showed on the record that we already know oil exists on the site. Here in this case, almost a century of oil drilling shows that oil exists on the site. The planning division showed photographs of an oil seep. Oil is bubbling out of the earth. There's so much oil in this area. And as well as existing data. We have almost a century of drilling records. Surely exploratory wells have been drilled here in the past. And many of those have been drilled by Chevron, the same company who had previously drilled wells and had data on the record in the San Benito case. And so really with all this evidence before us, we really disagree that any future development of this oil field is speculative. And I think also looking at the permit history here, I don't think DECOR would be coming back to try to amend their permit, which was just approved a few years ago, if they didn't have a reasonable expectation that they would find oil here. So in the San Benito case, the court rejected the very same arguments that the county planning division has made here in the record and here in the room today as well. And I'm not going to read the whole case, but I think these two passages here sum up nicely why this case is so important to our current topic of discussion here this morning. So the first passage, to the extent the county cannot know at this point the exact number of wells, their precise locations, and how much oil they will produce, that's the exact same situation we have here, CEQA provides that the county complete a more general analysis now and a subsequent analysis at the next stage of approval that tiers to the earlier analysis as appropriate and incorporates data from Citadel's pilot wells work. CEQA endorses several tools for fine-tuning an initial EIR to address additional environmental impacts at the next stage of approval, including the preparation of an addendum or supplement to the EIR, or if necessary, a subsequent EIR. And that's what we're asking for here. We want the county to look at the whole of the project, look at any reasonably foreseeable future development scenarios of the entire oil field. And of course, nothing is reasonably certain, particularly in this business of CEQA and land use. But reasonable guesses can be made, and I'll get to that in a second. And those reasonable guesses can then be supplemented in the future as we gather more data, more information. The other passage I'd like to briefly run through is on the bottom of the screen. Expansion to full commercial production is not sheer speculation, but a reasonably foreseeable consequence of the pilot project. And that's the exact same argument we're making here and that the county has just dismissed in this instant case as well. It also presents a greater opportunity for later environmental review of commercial production to result in more bureaucratic and financial momentum behind the project in the incentive to ignore environmental concerns. If the pilot project confirms commercial viability, there will likely be such momentum. And so that's why we don't want to see this analysis done now and a future analysis done later if oil is indeed found with these exploratory wells. CEQA requires it be done now before there's enough political, economic, financial momentum to skew the analysis later. It needs to be done now. So the court in the San Benito case used this phrase, and it's a phrase that I'm familiar with quite well. It's reasonably foreseeable development. And if we can shift a moment from the realm of the county to go into federal oil and gas law, which I'm familiar with, working with the Los Padres National Forest quite a bit, they evaluate reasonably foreseeable development scenarios all the time. Anytime the federal government considers whether to open up federal lands for oil leasing, we're not even talking about drilling an exploratory well or drilling actual producing wells. We're just talking about leasing land for future exploratory or production drilling. those federal agencies conduct what's called a reasonably foreseeable development scenario, and that's defined in the federal regulations, and it requires the agencies to project the type or amount of post-leasing activity that is reasonably foreseeable as a consequence of conducting a leasing program consistent with that described in the proposal and for each alternative. So here's an example of, in 2005, the Los Padres National Forest conducted their own reasonably foreseeable development scenario. And you can see just by peering through the table of contents some of the issues that they take into consideration in evaluating the whether foreseeable development whether future development is reasonably foreseeable. Geology, indications of oil and gas near the forest, shows of oil in seeps and outcrops, exploration and production to date. They look at high potential areas. They look at geologic potential, whether lands are available for drilling. They look at the history of exploration and development activity, recent drilling activity. They calculate the estimated recoverable resources. And they look at surface disturbance. For example, they estimate the number of pads that will be required for further development of the field, the miles of roads, the mile of pipelines, et cetera, et cetera. So it's not like we're asking the county to do something that's never been done before. Federal agencies do this all the time, and if the Los Padres National Forest in their current fiscal crisis can put something like this together, certainly the county and the applicant can as well. And there's been studies on how to evaluate reasonably foreseeable development scenarios and even take that a step further and calculate how reasonably foreseeable future development will impact target species, for example, the California condor. This study focused on areas around Wyoming and Montana, and it looked at several variables used by geoscientists to predict where hydrocarbon deposits may occur. So they didn't even look at historic oil records, historic well records. For this project, they looked at geology, topography, bedrock depth, and changes in aeromagnetic gravity and other types of gravity. All those issues taken together, and they put together a model that had an 82.9% accuracy in determining where oil deposits could occur in a fairly specific area. And again, there's no reason why the county and or the applicant can't take that same approach in this case. So just in summary, we'd like the planning division to step back, adjust the project description and clarify it, and clarify in the analysis that we're looking at the whole of the project, including reasonably foreseeable future development of the oil field. That's my big topic. The next topics will go pretty quickly here. Mandatory finding of significance. The county in the mitigated negative declaration checked the yes box under a finding of mandatory significance. And when, as the name suggests, when a mandatory finding of significance is made, that automatically triggers the requirement to prepare a full environmental impact report. That was not done here. Still trying to figure out why that was not the case. There is a small exception to this automatic trigger, but that's only when the applicant agrees to mitigation measures or modifications to the project prior to commencement of the preliminary review of the environmental document. Many of the mitigation measures that we're talking about today, especially those regarding California condors, weren't even mentioned in the record or mentioned in the equation at all throughout this process until the MND was released for public review and throughout the public hearing process as well. So in situations like that, the county can't then go back and say, okay, well, even though we have this mandatory finding of significance, we put in these mitigation measures without doing any analysis in the MND to evaluate whether those mitigation measures are effective, what impacts might still occur. The county cannot use that argument to escape preparation of an EIR once they make a mandatory finding of significance. Third issue, cumulative impacts. So in the mitigated negative declaration, the Planning Division identified 12 projects as part of their cumulative impacts analysis. Here's the list cut and pasted right from the MND. And they came up with this list by drawing a 2.5-mile radius around the proposed drill site. And they looked at which current permits either are in place or are coming down the pipeline within that 2.5-mile radius. We think that's certainly a good start, but it doesn't even begin to scratch the surface of what other activities, land uses in even that 2.5-mile area can contribute to cumulative impacts. So again, here is our drill site, that white dot, and the dotted line around it is the 2.5-mile radius. Our first concern is the CEQA guidelines require the county to explain the methodology behind selecting the sphere of influence, for lack of a better word, when they prepare a cumulative impacts analysis. So it's fine if the county selects a 2.5-mile radius, but they need to explain why they selected 2.5 miles instead of 3 miles, or instead of 1 mile, or instead of 5 miles. They did not do that in this case. So that leaves the public scratching our heads as to, well, why did they only look at 2.5 miles? So that's our first issue.
Can I ask a question?
Yeah, sure.
What do you think a sphere of influence, i.e. radius, should be?
Yeah, that's a good question, and I think it depends partly on what issue you're looking at. Condors, if we're talking about looking at the impacts of oil drilling on condors and really looking at what the cumulative impacts are, we should be looking more at maybe a 5-mile radius, 5 to 7 mile radius, to include not just this area, but some of the active oil fields over here, and over here where there's a lot of condor activity as well. So I think it depends on the issue, but I don't think it's unreasonable to conclude we should look at a 5 to 7 mile radius here. That's just my initial off-the-cuff answer.
Thank you.
And so even if we're to assume that the 2.5-mile radius is adequate, again, that's the dotted red circle here. There are several land uses, particularly oil drilling, within that 2.5-mile sphere of influence that the county didn't analyze. They didn't list it in their cumulative impacts analysis, and therefore it was not analyzed as part of this project. And this map, as cluttered as it is, I think that clutter makes a good point, in that there are quite a few activities that the county didn't look at. So let me briefly walk you through some of these issues here. Yes?
Could you identify where the community of Piru is at within that 2.5-mile radius, or if it exists?
Yeah, the community of Piru is right down here.
Okay, thank you.
Piru Creek is right here. And the Los Padres National Forest is this green blob up here. So some of the things we're looking at in this picture, again, the dots indicate existing oil wells. Correction, they indicate historic oil wells. And the different colors represent whether they're currently active or idle or have been abandoned. But again, there are dozens of active oil wells within this 2.5-mile circle that the county should have analyzed as part of the cumulative impacts analysis, but didn't. Other issues. The Los Padres National Forest in 2005, remember I showed you that reasonably foreseeable development document? That was part of a 2005 analysis where the U.S. Forest Service looked at the entire Los Padres National Forest and said, okay, where are we going to allow oil drilling, and where are we not going to allow oil drilling in the forest? And this yellow area up here is an area where they will allow slant drilling to occur beneath the forest. And these small little slivers of brown here, here, and here are areas where the Forest Service will allow surface drilling. That's actually putting a well pad on federally owned National Forest Service land. That was not discussed as a cumulative impact in this analysis as well. And you can also see there's The other big colorful blobs on this map are the county's conditional use permit boundaries for oil operations within the county. There's 1, 2, 3, at least 3 CUPs. It looks like there's actually 1, 2, 3 right over there, 4, 5 CUP boundaries within that 2.5-mile radius that should have been included in the cumulative impacts analysis, but that weren't. So again, we'd like to have an opportunity for the county to go back, do a more thorough analysis of cumulative impacts, particularly with respect to impacts of oil drilling to condors.
Mr. Kuiper, Mr. Chair, if I could I just stop you there for a second? Because this is a focal point for me.
Certainly.
All right. Because I've already asked staff to tell me why 2.5 early, if you were listening. I'm trying to understand, I almost said nexus, but relationship between what you've identified as far as these other oil wells and a permit for 2 exploratory wells as far as a cumulative impact. So can you give me an opinion on that?
Yeah, certainly. So when we're looking at cumulative impacts with respect to any well, whether it's exploratory, whether it's a producing well, all the impacts that the county evaluated in the MND regarding oil spills, impacts to biology, impacts to cultural resources, air pollution, one well can contribute cumulative impacts to that, especially if the current impacts from current activities within the sphere of influence are already contributing to significant impacts. And so our argument, just to get to the point of your question, is we want the county to look at what are all those impacts to all those issue areas within this entire area, whether it's 2.5 miles, 5 miles from oil drilling. The county looked at other issues in the MND. A shooting range, ATV motocross track. We want the county to look at, okay, what impacts are a century of oil drilling in this area, much of which is still ongoing today. What impact has that had on water quality, air pollution, some of these other issues that the county addressed specifically these two test wells, but they did not evaluate the cumulative impacts looking at impacts from other activities, other similarly situated, similarly located activities in the vicinity. Does that answer your question?
You got there.
Okay.
Excuse me, that cumulative impact that you're asking should have been included. That would also include those areas you identified in Los Padres Forest area that are identified as allowable drill sites that don't have any drilling occurring on them right now that would require exploratory wells. You're saying that the county should have also considered that as part of the overall cumulative impact?
Right, because in any analysis of environmental impact, you need to look at what's reasonably foreseeable. And so we'd argue that, well, if the Forest Service came up with a plan in 2005 that specifically allows surface drilling in certain areas of the forest, even if there isn't drilling there yet, it's reasonably foreseeable that it could be there in the future, and the county could actually tier to that reasonably foreseeable development scenario that the Forest Service prepared to evaluate what those cumulative impacts would be for the National Forest Service component of that.
Would that be speculative in that no wells have been drilled and in essence would require the county to take a worst case scenario as far as environmental impact from the
no, I really don't think so. I think the county could simply go back to the reasonably foreseeable development scenario that the Forest Service prepared, and it's very, very clear. They lay out, okay, we estimate X number of well pads, X miles of roads per well pad, and come up with some reasonable estimate of okay, well, these are some fairly limited areas of surface disturbance. Would we expect 1 well, 5 wells, 10 wells, whatever their analysis concludes, and then evaluate impacts based on those reasonably foreseeable outcomes.
Or no wells.
Or no wells.
Okay.
Certainly. But to clarify that, the Forest Service didn't conclude in their reasonably foreseeable development scenario that no wells would be drilled under their plan. So I think at a minimum, the county would have to assume that a certain number of wells would be drilled in those areas. It's ready to talk about Condor some more? Okay, so just as a little bit of background on this topic, the U.S. Fish and Wildlife Service concluded in 2011 that the combination of condors and well pads creates a difficult management challenge for the California Condor Recovery Program. And again, we talked about this a few weeks ago. It's because you have intensive oil development right in the middle of the best condor habitat in the world. So these challenges are bound to occur. Which is unfortunate. And our job is to make sure that those challenges are minimized or avoided. And I think we all share that same concern. I'm not going to give a big speech again today on the impacts of oil drilling on condors, but just really briefly to hit on the main impacts: direct habitat loss, noise, human activity, habituation to human presence, microtrash, electrocution, strangulation, and direct coating with oil. Those are some of the main impacts that have been documented over time by the U.S. Fish and Wildlife Service as occurring to condors in this area. And so how much condor activity do we have in this area? We wish the MND would have had a map like this, but we didn't let that stop us. We requested condor data from Fish and Wildlife Service, and we made our own map. And this map shows condor activity. Each little blip is the presence of a condor. Some condors wear little radio transmitters on their wings, some don't. But this gives us our best indication of where condors are currently being active and where they're not being active. And you can see there's not a whole lot of condor activity down around the town of Piru, around the Santa Clara River and on the other side. But there's a huge amount of activity, condor activity, in this area, so much that we can't even see the map underneath. And so this, I just wanted to demonstrate to the commission that this is an area of extremely high condor activity. We're not talking about an occasional condor flying over the area. This is an area that condors use all the time. And again, you can see on this map the wells, the green wells are the active wells in this area. So you can see even where the active oil wells are located, there's quite a bit of condor activity.
Mr. Chair. Mr. Kemper, I'm sorry to interrupt you. But you just showed me, I saw a 2004 to 2014, that's the entire data for that 10 years?
That's correct.
Okay. What individuals were responsible for acquiring, what I'm trying to get to is get out of the layman and into the expert position. So if you could represent that to me. Who acquired this and who compiled it?
We submitted a Freedom of Information Act request to the U.S. Fish and Wildlife Service earlier this summer. And they provided us with, we actually asked for condor occurrence data from the last 10 years. And they sent us a disk, and our GIS person put together that data, and they are skilled at map making, and this is the product of that.
But this is from the radio transmitters, right? And how often are they monitored?
That I do not know.
The thing that the criticism I have of this is it implies that there are a lot of condors, but there are not. There are according to this, and I referenced this in my disclosures. There are 68 in this area as of August 31, and that number fluctuates because, they die.
Sure.
So these are based on their radio transmitters on their wing, and then someone has just logged them. But that doesn't represent a lot of condors. Am I correct?
Yeah, there's a few different things at play here. Not every condor has a radio transmitter on them. So this certainly doesn't represent all condor occurrences. Condors could be flying around further south or in some other areas, and we wouldn't know.
So this data represents not the 68 presumed,
No,
but some number less than that.
Approximately half of the condors in the wild are radio transmitted. And so this represents 30, maybe 40 condors. And you're right. The other issue is that there's not a lot of condors in the wild to begin with. And so, yes, whether the radio transmitters send out one blip a day, one blip an hour, I don't know an answer to that question. And this also is 10 years of data. But I think it's not intended to show the abundance of condors. It's intended to show where condors fly, where they concentrate their activity. So there's some inadequate mitigation measures that we're concerned about. I'm going to really run quickly through these. Planning staff addressed some of these in their 40-page errata that wasn't posted to the website until this morning. I haven't had a chance to look at that to determine whether the changes they've made to these mitigation measures are adequately address our concerns or not. But I'll just go through and briefly highlight what those concerns are, and we can duke it out later. So the undergrounding power lines, flaring, access by biologists, and all measures are waivable. Those are the four condor issues. The first one, undergrounding. Fish and Wildlife Service wants all new power transmission and distribution lines undergrounded. And that requirement wasn't included in the mitigation measures, and the U.S. Fish and Wildlife Service actually expressed concern in a letter to the county dated March 25th, 2014, that particular mitigation measure was not included in the MND, even though they had previously asked for it to be. Second one, flaring. No flaring sites will be allowed without review by Fish and Wildlife Service. The Planning Division added some language regarding flaring to the project description. They say produced gas will either be used to power pumping units or be flared on the site. We maintain that no flaring should occur, period. Third,
why is that?
Let's go back here for a second. So flares like these don't burn 24 hours a day. Some of them do, but ideally you don't want a flare burning at any time. We want to capture as much gas as possible. We don't want to be wasteful with it. So flares are designed to burn off excess gas. Sometimes you have excess gas, sometimes you don't, and I guess that's just a general commentary on life in general. So when you have a flare turned off and a condor lands on it, because you got to admit it's a nice little bird perch. Condors can land on the top, gaze across the landscape. If that flare happens to turn on when the condor is sitting there or in the close vicinity of it, you would have a toasted condor, and we don't want that. So that's why flares are an issue.
Excuse me.
Yes.
So in your best case scenario on this issue, in order to capture the gas, and we've already heard from the applicant that there is some intent to use part of it to power, in order to capture that gas, you're in essence saying it would require the applicant to construct or bring onto that site additional auxiliary equipment to capture that gas and expand what their intent is at this time?
That's correct. We'd like to see the gas not wasted, not just burned off. We'd like to see it captured and actually put to good use. And what sort of infrastructure that would require is beyond my pay grade, but that's what we would like to see.
But it would require, to do that, an expansion of what is proposed by the applicant.
I don't know whether it would or not. I know it would require some revisions and modifications, but I don't know exactly what mechanism they could use to capture the gas with on a temporary basis.
It could require pipeline and/or storage tanks on the site to accomplish that.
It
I
could.
believe.
Sure.
Would you agree?
Sure, that's a possibility.
Okay, thank you.
Yep. This is the most important one here from my perspective. The U.S. Fish and Wildlife Service wants to be notified if a condor is observed within 1,000 feet of any oil facility, and they need to have immediate access to the site. If a condor lands on a piece of oil equipment, condor biologists, federal condor biologists, need to be dispatched to the scene immediately so that they can figure out which condor it is, what they're doing, what impacts there are, and how to discourage them from doing that again in the future. And what the Planning Division's condition states, they get it half right. But they say access to the project site shall be made available to representatives of wildlife agencies upon reasonable notice to the permittee and compliance with all required drill site safety measures. Access to the site shall be provided within 24 hours of the receipt of the notice. 24 hours isn't going to cut it. The condor could be long gone by then. Biologists need to be there immediately. I'm not sure what the required drill site safety measures are, but if a biologist has to go through a week-long training before they can even get out onto the site, that's not going to adequately protect condors as well. And there's this 1,000-foot requirement isn't reflected here either. So there's no notice required to Fish and Wildlife Service when any oil field employees actually observe condors within 1,000 feet of the project area. And the other big one, waiver. This language obviously was not recommended by Fish and Wildlife Service, but in the after Mitigation Measure 5 and Mitigation Measure 5.5, those are the two that address condors, the Planning Division inserted this waiver language. The permittee shall implement the BMPs listed above throughout the entire life of the project unless waived by Fish and Wildlife Service or a county-approved qualified biologist in consultation with the Fish and Wildlife Service. So this means all the county has to do is find a county-approved biologist to consult with Fish and Wildlife Service. Fish and Wildlife Service could say, no, we don't agree that this condition should be waived, but the county has, in a sense, complied with the terms of the permit by consulting with the Fish and Wildlife Service, and then they could basically have unfettered discretion to waive any or all of the permit conditions that apply to California condors. That basically renders this whole process useless and a waste of everyone's time if the county, after going through all this, can on a whim waive a permit condition.
So you're saying the county's waiver should implement the recommendations on the part of...
We're saying this entire waiver language should be stricken from both mitigation measures. They seem to be unique to those two mitigation measures. I'm not sure why the county doesn't want to waive other mitigation measures on a whim, but for these two, that waiver language is in place, and we don't think it's appropriate. Last but not least, creek setback. So this is the correct location of the well. It's the Crocker number 10 well. And the county has in place a 300-foot setback requirement for red line channels, 100-foot setback for blue line channels, and a 50-foot setback as the absolute minimum if certain conditions are met. And that language is all included right here in the presentation. It basically says, no well shall be drilled and no equipment or facility shall be permanently located within. And then it lists the 300-foot, 100-foot, and 50-foot standards. So we looked at the county's map of red line and blue line streams put out by the Watershed Division and available on the website. And even though the MND claims that Modelo Creek is a blue line stream, it actually appears as a red line stream on the county's map. And that's important because the setback is much different depending on whether the creek is red or blue. So zooming in, you can actually see here is Piru Creek, here is Modelo Creek. The entire creek is a red line creek. The only setback in the permit conditions is condition number 42, which has a 30-foot setback. So again, we think that's inadequate to guard against the creek from the presence of oil spills and other impacts.
Mr. Chair, if I may.
Commissioner
Kuiper,
Westner.
what you just cited, the word I saw in there was permanent. What is asked for, and correct me if I'm wrong, is a temporary. So how do you reconcile those two?
Yeah, good question. So let's go back to the language here. So we're actually talking about two things. First, no well shall be drilled. Okay, that's the first section. And then the second section is, and no equipment or facility shall be permanently located within. So we have two things. No well shall be drilled within the setbacks, and no equipment or facility shall be permanently located within those setbacks. So there's actually two different categories of setbacks we can have here. You cannot drill a well within those setbacks. And for the very reason I explained. You might be able to have some other temporary facilities that get closer to the creek, but you cannot drill a well that close to a creek because of water pollution concerns. And I think that's why the county made that distinction there. Did that answer your question?
Yes.
Okay. So just summarizing everything, our request: evaluate the whole of the project, look at all the reasonably foreseeable development of the oil field, prepare an EIR based on the mandatory finding of significance, improve the analysis of cumulative impacts, looking at the 2.5-mile radius methodology, look at other oil drilling activities in the area, and then incorporate additional mitigation measures as necessary. Incorporate all of the condor protection measures recommended by Fish and Wildlife Service, remove the waiver language, and apply the appropriate setback to protect Modelo Creek. Are there any questions? I thank you so much for your time, and I apologize for going a couple minutes over my estimated 15.
You talking about the 15 minutes or the hour?
Yeah, I came in short of that hour.
Staff or Commissioner, any questions? Commissioner Armstrong.
It's not addressed to you, sir, but to County Council and to staff. A lot has been said about the San Benito decision. It's a trial court decision. Is it even a final trial court decision? What I saw was intended decision.
Right.
It's clearly not an appellate court decision.
You're correct, Commissioner Onstad. All that I've seen is an intended decision. I'm not sure if that's final even in the trial court. And as you know, as being an attorney, even if it were a final decision, it has no precedential value even in Monterey County, let alone Ventura County, because it's not an appellate court decision. And so the court in that case hasn't said anything about CEQA that is binding upon your commission.
Staff's interpretation, same?
I always listen to Mr. Barnes when he talks law.
And if I could just add a quick little footnote to that. It may not be binding, but it's a good indication of how a impartial, independent judge may look at an issue such as this and interpret the requirements of CEQA to a situation that's very similar to the one we're looking at today. So just
Thank
point
you,
that
sir.
out.
So you say it's reasonably foreseeable?
Yes,
Okay.
it's a good buzzword.
Any other questions of the speaker?
No, just thank you. Just thank you for all this information.
Thank you for your work.
Thank you. I think I left a card out of order. I've got Lynn Jensen here, and I apologize if I passed you over. If you come forward, please. And I believe you're speaking on behalf of the applicant, or support of the
Yes,
applicant?
I'm sorry. I'm Lynn Jensen. I'm with Ventura County CoLab, the Coalition of Labor, Agriculture, and Business. And actually, it was my misunderstanding. I was against the appeal, and so I did put it against, but I clarified that.
Okay.
But anyway, thank you so much. I want to start really by commending the county planning group for the August 7th workshop before the Planning Commission. I think that was an excellent full-day workshop, balanced with testimony of a variety of experts, some of them that are here today, discussing many of the oil and gas issues that have become controversial. And we're glad that you guys have this background when considering this project. In reading the staff report and MND, CoLab supports the planning director's decision to recommend denial of the appeal, and we offer the following comments. Number one, we believe the MND was a correct environmental document. The analysis was thorough and unbiased. The project is not in the National Forest. In fact, it's 1.5 miles south of the forest, and there's no fracking or acid stimulation in the project description, things that people have talked a lot about. On the discussion of the exploratory nature of this project, I'm actually a past exploration geologist for 13 years with Unocal in California and Alaska, and I'm also a licensed professional geologist in the state of California. And I just want to say that having experienced drilling many exploratory wells in both of those places, the true range of success for an oil well, when we were looking at the economics, was between 1 in 20 and 1 in 100. And imagine drilling a water well on your property knowing that the best you could do is 1 in 20 that would be successful. The odds are very low throughout the industry, despite the improving technology. And this particular well is going to be a new trap. And if it was an easy place to drill, it would have been drilled a long time ago. So this is something new. So to assume this project will be successful and force an EIR based on success is really not reasonable. One of the comment letters that I read referred to this property as de facto wilderness. A wilderness designation actually takes an act of Congress, and on the contrary, this is private ranch land that has historically been an oil field, and it's not in the forest. And in fact, we in Ventura County have been good stewards of the land. The Los Padres National Forest is 560,000 acres, almost half of the county area, plenty of places for the condors to range. And it includes the Sespe Condor Sanctuary. According to the environmental report, the potential for California condor to occur in this site is low. Yes, they're going to fly over it, but in my research I found that while this project is in the range of the condor, so is most of the county because condors can travel up to 150 miles a day in search of food. The comment letters also brought up wildlife corridors. I just wanted to talk for a second on that because the mapped wildlife corridor in this area on the county database is 4.5 miles wide. This is one little tiny section of a 4.5 mile wide wildlife corridor. And if you've ever been actually to a backcountry oil site, which I recommend you do, take a tour of them. There's plenty of wildlife migrating through it. And in fact, the roads that are built for these facilities facilitate the movement of wildlife. It seems to me that the conditions to mitigate the contours have been extensive, and the applicant is willing to comply with all the reasonable measures. And so we are calling for a balanced perspective when it comes to the county permit process for oil and gas based on a good understanding of the facts, which I think you guys really have, and I appreciate that. So we support the planning director's decision to deny the appeal. Thank you so much.
Any questions of the speaker? Thank you. Okay, Jeff Keiper? He just spoke. I'm sorry. Please come forward.
Yes, Mr. Keiper already spoke. Good morning.
Yeah.
Well, sure. I want to thank everyone for hanging around for all this time.
Would you identify yourself?
Yeah, my name is John Brooks. I'm the president of CFROG, which is a grassroots group, Citizens for Responsible Oil and Gas.
Can we have our PowerPoint?
Thank you. Commissioner Rodriguez, thank you for being here, and Commissioners, Commissioner Westner, just for the record, I am not an oil and gas expert. I was a journalist for 40 years before I retired, but as I learn more and more, I feel a growing expertise even if I don't have it. Many of us, though, many of the documents that we've read that have been submitted to the Planning Department were submitted by experts, despite Mr. Baca's attempts to downplay their expertise. They listed who they were for, research biologists, scientists of all stripes have commented, and the record is extensive. They're telling you that this oil field cannot be reopened, even though with just 2 wells, without first completing a comprehensive EIR. And the question about the San Benito case was raised just to show you that that's what the current state of the law will be, and will be in Ventura County eventually if this proceeds. We should not be here today. That this project requires an EIR is an easy call, at least it would be in most counties. There appears to be an institutional bias against EIRs for oil and gas projects. How many have come before your planning commission? Do you recall one at all? 2. How long have you served on the commission?
Since last century.
All right. You make my point.
1992.
The M&D says that proposed mitigations will make every one of the impacts it identifies less than significant. Every one. Is this really possible? We don't believe that's true. You've seen the briefs, the presentation by the Los Padres Forest Watch. You've heard about the late additions of all the material from the Center for Biological Diversity, which, by the way, employs a whole flotilla of scientific experts. CFROG, we've filed a 59-page brief, and since the commissioners have already seen that, I suppose, we're not going to spend our time reading it to you word for word. We'd be here all week, I believe. Instead, this morning I'm going to be introducing more experts. Yes, experts who will supply more evidence about this proposal to drill wells in what has been called, that we admit, by Tom Dudley, who is a biologist, certified biologist at the University of California. He calls it a de facto wilderness. Why is that? That's because it's regenerating. It's coming back. Technically, a wilderness does not have roads. I understand that. That's the definition of a wilderness. But the beauty that was evidenced in the planning department's own slides this morning shows that it is regenerating. It's not the oil field that it used to be throughout the last couple of centuries. As you listen, please keep in mind the message that you heard from your own staff this morning. And I'm going to quote it again because it's so key in this thing. Substantial evidence of a fair argument for an environmental impact report shall include facts, reasonable assumptions predicated on facts, and expert opinion supported by facts. There's 3 parts to that. And the staff says either substantial evidence exists or it does not. Well, we're going to show you once and for all today that it does. Now, we're going to put on the board here a photo list of our presenters this morning. And if I could have the sheets so that we could pass it to the clerk, please. So you can have that and see that these people, now some of them like me are not experts, but I don't know that you're all experts either and have what your degrees are. But we all live in this community, and our opinions and our values and our judgments are to benefit Ventura County. Next slide, please. Now, the planning department initially approved 3 test wells and a pipeline linking the upper and lower drilling pads and said that building all of that and greatly expanding the road, you've seen the road, it's narrow, they want to make it at least 20 feet wide. That's a 2-lane road, right? It's not a cow path anymore. Even bulldozing a helipad, which is at this location, would have a less than significant impact on the environment because of the proposed mitigation. Well, we conclude that the construction itself is a significant impact. And how can you mitigate that? You're doing it. Then the federal government sent a letter saying that condor activity had been recorded on the upper pad, which, by the way, is only 2,000 feet from the lower pad, which itself would only be 30 feet away from the stream bed. Rather than viewing that supplemental information from a key federal agency as substantial evidence of possible harm to wildlife, and at that point calling for an EIR, the applicant was allowed to drop the upper pad. Just, all right, make it vanish, and we'll proceed. We view this as an improper segmentation, and the courts, as you've heard, do too. Now, I'm going to bring up CFROG Advisory Board member and California Appellate Attorney Rich Holley to explain why these lawsuits against the practice have been successful and why this segmentation, which is going on in this process, will eventually, or by you, I hope, be determined to be wrong. Rich?
We have a lot of speakers, cards up here, and certainly we're going to go beyond the lunch hour here. I would like to try to control this because we still have time to deliberate and hopefully get out of here before dinner.
I was thinking the same thing.
And so we will have a clock running. I'd like to, if at all possible, keep your comments in the 3 to 5 minute range. And if you cannot do that, would you let me know before we start?
I'd like to address, if I might, address that point. First, I entirely agree with you, and I think I'm going to be able to reduce my comments down to not a lawyer's 10 minutes, but an actual 10 minutes or less. But I don't think it'll be 3 to 5 minutes. And I thought about this, and I believe what the rules are by your commission is that the applicant, as a general rule, shouldn't have any limitations on their time, but that members of the public can be limited to 5 minutes. But rather than going to the mat on that issue, I think all of us are going to try to keep this to a reasonable limit. For instance, I'm going to be incorporating by reference Mr. Kuiper's presentation, so I won't be going over what I was planning on doing. And so anyway, in that spirit, I'd ask that we keep that an open question, and I would object to any 5-minute clock on me, but I think it's not going to be much more than that. It might be less. I am one of the applicants in this appeal as a member of CFROG.
Your previous speaker was identified as a primary speaker. At least he represented himself as a primary speaker for CFROG, and so we gave him the latitude, as we did with to make their full presentation.
Well, we tried to we had a couple of meetings over lunch and so forth among us CFROGers, and we tried to apportion it so that we wouldn't be redundant with each other. And I think you'll see as it progresses that we won't have any
I understand what you're saying, and I will go by your comments.
Just
and
briefly,
let you
the
proceed.
staff called in various experts as well. We respectfully ask to be able to do the same.
But in any event, I think we're going to be all right.
I think we've heard all of staff's experts here. But anyway, if you'd proceed,
Thank you.
We'll get moving.
First of all, as I indicated, I have remarks prepared regarding the segmentation issue and the application of the reasonable arguments made in San Benito. But because of the presentation of Forest Watch, you basically covered everything I wanted to cover. I would ask you, though, to keep in mind the brief discussion regarding this issue that has been briefed and submitted as one of the submissions, and that is covered on pages 3 through 7 of the appellant's brief. Included in there is the case law, and then also a comparison of the facts, as we've already heard several times. The second significant issue that I was going to address has to do with that violation of the county ordinance regarding the encroachment of the stream. I think that was excellently presented by Forest Watch, and we will join in that and ask that that be made part of our appeal as well as all of the slides. However, I also would direct you to our briefing of that issue, and that is on pages 21 through 23 of our brief. Point number 2 of the substantial evidence supporting a fair argument of environmental impacts from the report. All right, so that's all of that. In listening to the remarks and the statements so far, instead what I want to talk about is basically just a couple of things here. They both have to do with your standard of review, and I think they're very, very important, because I don't believe you serve in this. You have many roles that you serve in, and we appreciate you serving in as a appellate review body here. I think it's extremely important for us to keep in mind, what are you really, how are you to decide this appeal? We've already, the first issue that I'd like to talk about is, it was brought up this morning when we've heard for the first time, not discussed in the MND, we had testimony from the county biologist. And that's evidence. And I'm not going to argue otherwise. I've been in this field for over 30 years as a trial attorney, as an appellate attorney, and throughout those years, I have become an expert on qualifying expert testimony in the superior courts, and the law is clear that in this forum, the rules of evidence are even more relaxed. So it's not a question, as Mr. Baca would have you believe, as to the admissibility of the expert or consideration by you, but rather the sufficiency of the expert evidence presented. So what I'd like is there's my first slide. This is what Mr. Baca actually presented in the memo address dated August 20th to Director Ms. Perlhart on that issue that he was talking to you today about. This is important. And why is this important? Because it goes beyond this issue. It really has to do with your consideration of most of the evidence that's been presented to you. Because as Mr. Baca would have it, you shouldn't consider any of it unless there's been a showing that the presenter or the author of the study is licensed by the Business Professions Code to practice in the field they are in California. And that is clearly not the law. So, if we could have the next slide. This is the purported authority that Mr. Baca has to support his claim that you should not consider this type of expert testimony or studies or anything by experts unless the person is licensed. What is this? This is the CEQA guidelines section 15149, specifically used as his basis for his authority in that prior slide, and also reiterated to you today. Let's read it, because it's important. Why? Because it doesn't state what Mr. Baca would have you believe that it states. A number of statutes provide that certain professional services can be provided to the public only by individuals who have been registered by a registration board established under California law. All right, well, good so far. Such statutory restrictions apply to a number of professions, including but not limited to engineering, land surveying, forestry, geology, and geophysics. Okay, if that was the only thing that in the guideline, we'd have an ambiguity at best as far as all it says is some statutes require this, provide. But B, the purpose of this guideline is to give you guidance as far as what does that mean here. B, in its intended usage, an EIR, or a less stringent review, such as this MND right here, is not a technical document that can be prepared only by a registered professional. Do you see where they're getting at with this guideline? The EIR serves as a public disclosure document explaining the effects of the proposed project on the environment, alternatives to the project, and ways to minimize adverse effects and to increase beneficial effects. As a result of the information in the EIR, the lead agency should establish requirements or conditions on project design, construction, or operation in order to protect or enhance the environment. State statutes may provide that only registered professionals can prepare technical studies which will be used, what? Here? No. Used in or which will control the detailed design, construction, or operation of the proposed project and which will be prepared in support of an EIR. So that's what it means. And it's common sense. It means that there is no such restriction. There is no such restriction just across the way in the Hall of Justice. I've never heard of such argument that an expert has to be licensed in the state of California to testify as an expert witness. The evidence code in California does not have any such requirement. It's against common sense, it's against the whole trend of the law, and it isn't the law here either. Instead, what does it mean? It means that after the EIR is prepared, we need to protect as the lead agency, needs to protect the public in carrying out the conditions of the EIR and require that anyone building a project, let's say construction, designing such a thing, be licensed so that we know that the mitigation measures are going to be performed by licensed professionals. So without beating a dead horse, Mr. Baca, with all due respect, he's an expert in the oil field, but I don't think he's an expert in this area of the law right here. It's entirely, lastly on this point, my interpretation of that statute there is entirely consistent with the rest of the body of the law of CEQA. When you think about it, there's no such restrictions regarding the evidence. And as a matter of fact, from Friends of Old Trees versus Department of Forestry and Fire Protection, 1997, 52 Calap 4th, 1483, 1398, 1399, mentioned in the brief, in my brief. Expert testimony for fair argument, I think we're getting close here, purposes need not meet standard required of such testimony at trial. It's entirely consistent with that. And again, there'd be no such, it wouldn't even be, such a requirement isn't even required in the Superior Court, let alone for you to evaluate potential environmental impacts. Secondly, there was discussion today regarding the biological opinions and a question from your board, making pains to make sure that we have qualified expert testimony, and I think that is, I entirely agree with that. But then the question is, where do we go from here? What if there is substantial evidence based upon expert testimony, presentation, which I would not agree with, or I would not disagree, that has been presented from the county biologist. What if, on the other hand, there is substantial evidence on the other side indicating that there may in fact be an environmental impact regardless of the mitigation in the NMD? What do you do with that? The conflict in the evidence. Well, the guidelines, again, let's go back to the guidelines. And 15064 of the CEQA guidelines, which inform you, board commissioners, as to how to evaluate and what your standard of review is. The headline or the title of that is Determining the Significance of the Environmental Effects Caused by a Project. The pertinent part for this issue here is subdivision G. After application of the principles set forth above in section 15064F and in marginal cases where it is not clear whether there is substantial evidence that a project may have a significant effect on the environment, the lead agency shall be guided by the following principle. I submit this is where we're at here. If there is a disagreement among expert opinion supported by facts over the significance of an effect on the environment, the lead agency shall treat the effect as significant and shall prepare an EIR. So, applied here, Mr. Jeff Kuiper from Forest Watch has presented you substantial evidence on the issues that he was discussing, not just argument, but backed up with substantial evidence. And then we had a conflicting opinion by the county biologist who did not find such significance. It's very simple. You adopt Mr. Kuiper's substantial evidence that he's submitted and order an EIR, direct an EIR. Why is that? The cases are replete with this basic principle, cited in the brief and otherwise, is that the MND is the lowest environmental review. It ought to be the exception rather than rule in questionable cases. CEQA is set up in that fashion. I would agree with Mr. Brooks. I don't see that analysis in the analysis by the staff of this project. And because of that, CEQA is set up in such a fashion that we should have an environmental impact report to evaluate the tremendous amount of evidence that has been submitted, not just by us, but by the winning plaintiff in the San Benito case. Not just argument, but 6,000 pages of scientific evidence, which may or may not all apply. I don't disagree with Mr. Baca, but there is definitely a whole lot of evidence in there, and I strongly urge you to consider it. That's all I have to say at this point. I would perhaps be able to reserve a couple of minutes at the end, but let's just see how we all feel at that time. Thank you.
Thank you. I'm just going to go down the speaker list that you provided me.
No, thank you. Mr. Chairman, with all due respect,
We're running the meeting. This is our commission meeting.
I'm just addressing the chairman. Mr. Chairman, I would like the permission to call our expert witnesses. May I do that?
I would prefer to run the meeting based on what you presented, what the speaker cards are here, and I'm assuming everybody you have on this list has a speaker card in. And I will go in the order that you presented this list of speakers.
Well, I did not present that to you.
I'm sorry?
People. I'm sorry. Go. Yes.
You gave to me.
Yes. Thank you, sir.
And that's what
I thought you meant the speaker cards.
Well, and so the next speaker is Elif, pronounced
Leif Douch.
Was it?
Yes, Leif Douch is a member of the Seafrog Advisory Board. He's a Deputy Attorney General with the California Department of Justice.
Well, okay. We'll let him present his qualifications and history. That'd be a little bit easier since he's present.
You're welcome.
Thank you.
Good morning, Chair Rodriguez and fellow commissioners. My name is Leif Douch, and I'm speaking here today as a lawyer, as an individual, and as a longtime resident of Ventura County who knows how important it is to protect and maintain the beauty and sanctity of the open spaces around the Hopper Mountain National Wildlife Refuge. I'd like to start by talking briefly just about substantial evidence. I know we've heard some discussion here, but really talk about what the published Court of Appeal cases and the California Supreme Court cases say, cases that would be binding precedent on this proceeding and on a trial court in this county. The staff report quarrels with our definition of substantial evidence, so let's just go to the precise wording of the California Supreme Court. And they say, quote, under CEQA, an EIR must be prepared whenever it can be fairly argued on the basis of substantial evidence that a project may have significant environmental impact. And that's the American Coatings case, and I have a written submission, just a written version of the comments that I'll give today that I can give to the clerk, so you'll have the full cites there. Courts have further explained that substantial does not mean uncontested or overwhelming. It instead sets a low threshold for an EIR, which is, quote, the key to environmental protection under CEQA. Courts have also made clear that substantial evidence need not take any particular form. There's been a lot of discussion about this, but we need to remember there's the three prongs. There's facts, there's reasonable inferences from those, reasonable assumptions from those, and then expert testimony. Expert testimony is a third and separate category. It's not the only type of evidence that substantial evidence can be taken in the form of. Instead, courts have made clear that it can be based on federal or state agency reports, public comment from local residents, academic research, expert testimony, or legal opinions from trial or appellate courts. And perhaps no case better illustrates this than the Whitman against Board of Supervisors case, a published California Court of Appeal decision that came out of this very county. In Whitman, a mitigated negative declaration was originally prepared by planning staff for one exploratory well in Cesar Canyon in Upper Ojai. However, opponents of the project, like the appellants here, have provided testimony and reports showing three problems with the proposed site. First, it was in an extreme fire hazard area. Second, it was in a wildlife habitat. And third, it was, quote, within the flying area of the California condor. So not in a roosting area or a nesting area, but within the broad flying area of the California condor. Based on that evidence, the county's Environmental Assessment Committee overturned the Planning Committee's decision, the Planning Staff's Commission decision in that situation, found that the MND was not sufficient and ordered a full EIR. And even after that EIR was conducted for the single exploratory well in Upper Ojai, the California Court of Appeal found that that EIR still wasn't sufficient in its analysis of cumulative impacts, remanded the case back for a supplemental EIR to be conducted in that situation. So if you look here, you've got fire hazard area, a wildlife habitat within the flight range of the Condor Sanctuary. In Whitman, there was only one exploratory well. Here, there's two. The previous three factors have all been met with regard to the Modelo Canyon project. And in Whitman, they got an EIR and a supplemental EIR on remand. So in terms of a case that came out of this very county that had very similar situations dealing with exploratory drilling, if we just look at what that published decision mandates in a case like that, I think it's helpful as the commission makes its decision. And that's not even talking about the seismic and the water consequences.
Excuse me.
Yes.
The document you're referring to.
Do we have this Whitman versus Board of Supervisors?
I have a document.
Yes.
We received a document from you dated September 20th. We received on the 24th, and it was forwarded to us electronically. Is that the document with the various attachments? Is that the document you're referring to?
There is a document there. I also have a copy here of my remarks today that will have the citations to publicly available, published Court of Appeal and Supreme Court cases.
So is that the document you're referring to? These comments here, the document we received yesterday?
There was a letter, but there's also additional comments that I'll be making today that supplement that comment. So I can lodge with the clerk right now.
That would be appreciated, and I'm referring to I believe it was Exhibit I.
Okay.
Which I think.
Sorry for the interruption.
Of course. Without going through and counting, was a couple hundred pages.
Oh no, my letter was only 2 pages.
Okay, well.
Yeah.
Okay, there were 2 of them here.
Okay. Continuing on this point, the staff report trivializes these concerns expressed by appellants and by other members of the community when it states, quote, the level of interest in the project and associated environmental analysis, however, is not part of the criteria that determine when an EIR is required. But we've never argued that an EIR is required simply because the project and the proposal has garnered public attention. Instead, we're arguing that an EIR is required because a diverse cross-section of people from across this county have come together to express genuinely held and scientifically supported concerns about the impact this proposal will have on their families, on their communities, and on the environment. And that type of informed public participation is precisely what urged and pushed the county in Whitman to conduct an EIR and then a supplemental EIR. And on that same evidence, we believe the same should be done here. And if I can just briefly respond to the Planning Department's frequent assertion, and this goes to Chair Rodriguez's question to County Council earlier, Planning Department's frequent assertion that any future modifications of the CUP would be subject to stringent environmental review under CEQA, and thus there's no need to consider any future commercial production at this stage. And that's simply not what the law says. In fact, the law says quite the opposite. Subsequent modification of a CUP will not be subject to the same standard of review and the same standards by a court or by this commission as an initial application for a CUP. Numerous courts of appeal throughout the state have made clear, quote, review under CEQA differs depending on whether the agency is considering a new project or an extension or modification of an existing project. And the Court of Appeal in the Santa Teresa decision, which is cited both in the letter and in the brief memo that I just submitted to the clerk, the Santa Teresa decision states, the fair argument test for new projects establishes a low threshold for initial preparation of an EIR, which reflects a preference for resolving doubts in favor of environmental review. But once a public agency has already approved a project, A supplemental EIR is required only if there are substantial changes in the project or the circumstances surrounding the project, or if there's new information that requires major revisions of an EIR. So it's not just this de novo review where the whole process starts again. There's a different standard for modifications of a CUP down the road, for example, if they wanted to scale out production or add more wells. So additionally, any court reviewing that decision on a modification of a CUP must apply a far more deferential standard of review based on the assumption, quote, and this is again from the Santa Teresa decision, that an in-depth review has already occurred. So the more deferential standard that applies to modifications is based on the presumption that in-depth review, usually an EIR, has occurred in the first instance. So this idea that the back end will be protected by adequate review isn't true when an EIR is not conducted in the first instance. And so if, just pointing up here at this slide, if you look at the differences between how the planning department, this commission, and even a court would look at an initial project, such as exploratory wells, where there's a low threshold for an EIR, where there's a presumption in favor of an EIR, and where there's stringent court review, basically de novo review of this issue, as opposed to a future modification, where if they wanted to add more wells or in other ways modify the initial CUP, there's a higher threshold for an EIR. The presumption is flipped against us, and there's deferential court of review to the planning department's decision, and that is simply not a trade that we're interested in making. Moreover, the idea that future environmental review will adequately protect the communities or the environment's interests is particularly unconvincing in the context of oil exploration. As the Court of Appeal noted in Brentwood, another published Court of Appeal decision that I've cited both in the letter and in my submission today, quote, 99%.
Okay, continuing with our speakers on behalf of the appellant. Ray Perry was not available previously. The next speaker is going to be Carol Hawley. As I stated to Mr. Brooks, I see you're here for a couple of topic areas. I'd like you to consolidate that into one speaking appearance at the mic, please.
Yeah, no, I will be speaking just
Thank you.
once, and I've timed it, and it's about 6 minutes, maybe a little shorter
Fine,
toward
that's
the
fine.
end. Okay. Good afternoon. My name is Carol Hawley, and I am a retired elementary school principal from the Ojai Unified School District. I'm here to tell you about a couple of things that really troubled me as I read through the M&D. One of them was that CEQA does require, and this is easy to read, you can Google CEQA and look under the guidelines, and you can look under what is the baseline requirement of a CEQA document. And it is that the description must include the current conditions of the project area itself, including the surrounding area. And they define environment as, environment means the physical conditions which exist within the area which will be affected by a proposed project, including land, air, water, minerals, flora, fauna, ambient noise, and objects of historical significance. This is the baseline description in the Modelo Canyon initial study. The proposed test site is a sloping area within a canyon that is bordered by the base of a steep hillside and a ravine with an intermittent stream. A dirt road crosses the proposed drilling pad. There are no structures or trees on the drill sites. The site is surrounded by trees, and trees line portions of Modelo Canyon Road leading to both sites. There's only one sentence in the environmental description that does not call the site a drill site or a drilling site, and there is absolutely no mention of the surrounding area. This is a picture of the drill site. What do you see? This is the neighbor immediately to the west. This National Wildlife Refuge was established in 1974 and includes 2,471 contiguous acres. The refuge is also home to the California Condor Recovery Program, where the condors are struggling to make a comeback from near extinction. This is a picture of a condor chick in its nest. This type of nesting habitat is pretty unique, but it occurs in the hillside canyons above Piru. The project area is also within this critical Santa Susana to Sierra Madre Mountains linkage, described in the South Coast Missing Linkages Project. The Santa Susana Sierra Madre Mountains linkage includes, in part, Piru Creek and large areas of private land west and east of Piru Creek. The environmental review conducted by our lead agency is silent as to what species might be using this portion of the linkage. So what species might be in the linkage? Mountain lion, mule deer, American badger, all could have a high frequency in the area. Here's the key. The South Coast Wildlife Connectivity Project already identified this land as critical habitat in the linkage. In my experience, a study included in the public response documents explains a linkage this way. The most important determinant is the species of interest. For instance, a corridor that allows movement of coyotes may be unsuitable for cougars or kangaroo rats. The corridor is wide enough when it meets these functions for each species of interest. The planning department concluded that the project is on a disturbed pad with an existing road and will not increase road density, therefore it will have no significant impact on wildlife connectivity. Why is road density relevant in this remote area in the vicinity of Piru Creek? Modelo Canyon Road is a dirt road that will be widened from 8 to 10 feet to 28 feet. 20 feet with a 4-foot brush clearance on each side. Assumedly, it's not being used much, if at all, right now. We don't know. There was no assessment done of the baseline condition. With just 2 wells, that usage will jump to 6 medium to very large trucks a day, according to the MND. Human activity will include noise, pollution, lighting, chemicals, vibration, and dust, to mention a few. This activity will fragment the linkage in this specific area. A study must be done as to how the species using the linkage currently at the outset of the initial study will be impacted. Only then can a finding of significance be determined. What might the impact of a full reopening of the Modelo area of the Piru oil field be? This determination is not one based on speculation. It's a matter of developing a simple table of species and each annoyance issue versus the total number of wells and let it build out. At some point, the impacts would be significant. The applicant has a right to know if the impact might be determined to be unmitigatable at some quantity of oil in the field. Not only the public, but the applicant deserve an analysis of the impacts of the reopening of the oil field on this critical wildlife corridor. According to the biological study, the biologist who did the study for this M&D said that there were 3 crossings of Modelo Creek prior to reaching the proposed project site. Incredibly, they're not mentioned in the initial study, M&D, or CUP. Here's what one of those stream crossings looks like. Messy. Ventura County Planning asserts that CDFW has evaluated the project and a streambed alteration agreement is not needed. But that's not what the record tells us. CDFW did not respond during the allotted time period to a request regarding the stream encroachment to 30 feet next to the proposed drill pad. Therefore, the encroachment can be allowed as a default. But Ventura County Planning had the power, and one would presume the environmental interest, to request the time period for a response be extended. Secondly, according to the very comprehensive and clear wetlands project portion of the Ventura County Planning Department website, a streambed alteration agreement is granted only after a CEQA review is completed. It is not a substitute for CEQA review. There is and was no biological review of these crossings and the widening of the road to 28 feet through the streambed. The environmental baseline for this project has to include all of these critical aspects of the current environment. Instead, the Planning Department began their initial study both describing in writing and in their mind seeing a drill pad. The current biological conditions were never identified and therefore never studied. There must be an EIR to determine the true level of significance. Another thing that CEQA requires is an accurate, stable, and finite project description. And that is the sine qua non of an informative and legally sufficient EIR. In other words, it's indispensable and essential. So, this morning, we were told that the drill pad is going to be drill pad 10. But the study was done with these questions in mind. Will DECOR drill on the lower pad, which is either well pad 10 or well pad 16, or the upper pad, which is now identified in the responses to our questions about clarification on which pad it was, that it was well pad 16, but used to be the location of well pad 1D. The CUP states the drilling pad is the location of the former Crocker well number 16. However, the only map in the drill in the CUP is a map of the drill pad and facilities of well pad 10, as you see. This is a map made by Seafrog showing the locations of well pad 16 and well pad 10 derived from GPS locations provided by Dogger. The two pads are about 700 feet apart. They are not about the same pad, nor are they interchangeable. So now we know, or we presume to know, that the drill pad is going to be on drill pad 10. We don't know how far that is from the Condor Nest because no one has identified drill pad 10 prior to this. We don't know which pad the biological review was done for because it was marked well pad 16. The CUP was granted for well pad 16, and now it's changed to 10? Without an accurate baseline description of the site and a discrete location, there is no criteria from which to determine the level of significance that this project will have on the environment. Sine qua non means without which you have nothing. Thank you.
Thank you. Next speaker is Stephen Colome. Apologize for the pronunciation.
Sure. There's no accent on the E. It's Steve Colome.
Okay.
And I'm going to be speaking today as an expert witness in the areas of air quality and public health. I'm retired from the faculty at UCLA in environmental health sciences, where probably the majority of my students were licensed physicians and practicing physicians who are coming back for continuing education in environmental health, which is my area of expertise. What I intend to discuss today are a combination of issues that have received really short shrift in the county documents to date, including flares, VOC emissions, greenhouse gases, which I will modify my comment, not having seen the addendum that came out this morning, and public health risk. Any one of which, in my opinion, presents a fair argument for requiring, in this case, a full EIR for the proposed project. I was very disappointed in any of the records that deal at this point with air quality presented by the Planning Department, which either deferred to the applicant with no information given documenting any data, assumptions, calculations, or sensitivity analyses of the potential air quality impacts of this project, which are real. And I don't know where they were going with greenhouse gases, but previous to this morning, the county was assuming that since the Ventura County APCD had not yet established standards, they didn't need to address this issue. And frankly, both of these are unacceptable abdications of the responsibility and duty of this agency. Okay, with that, we'll turn to the issue of flares, which have again, received virtually no information in the county analysis. So I'll give you a short tutorial on flares. This is a picture of what's called an industrial flare. They're really very, very simple devices. You've got your input of the emission source, which in this case is probably mostly going to be methane, but there's some questions here in terms of what those organic gases are going to be going in. And there are some traps, and there might be some steam injection, and there's a pilot light up at the top of that, which ignites these combustible gases when they come out. Well, most industrial flares are quite simple devices, and this particular diagram comes from an EPA document called AP42, which identifies the emission potential from industrial flares. But I'd like to tell you that AP42 is based upon very limited and, at this point, quite outdated analysis. In fact, the most recent reference material in the current version of AP42 comes from 1983. And that was truly at a time, over 30 years ago, when a lot of our methods for identifying emission characteristics of a source were quite limited. Now, data which are largely being generated today in Europe indicate emission factors from this type of flare of about 6 times what EPA's AP42 has estimated. Okay, it doesn't stop here because EPA is currently reviewing its AP42, and as of August 19th, I received notice from the agency that they're proposing new and revised standards, emission factors for flares. They're currently in the comment period, which ends sometime next month, but most likely, and in my professional opinion, what we're going to see is a sharpening, both in terms of the emission rates. They're going to be higher than they were previously assumed to be, and we're going to have a larger array of contaminants of some concern. So let's turn to slide number 2. Now, these are flares. What we're going to see up there, if it is developed, is not going to look at this point like this. But the point I want to make with this flare is that the assumption in AP42 is that the flares are well-behaved and non-sooting flares. In fact, real flares in these gas and oil fields are very frequently sooting flares. Now, I can't tell from the record whether it's going to be an elevated flare like this or a ground flare. Both of those would have potential implications for what the potential emissions are from this particular source. So now I have some questions for the county because they're so deficient in providing information. What's the composition and the compositional stability of the flare gases? This is critical to understanding the sooting potential. What is the waste gas BTU rating and its variability? Does the applicant propose a mechanism to adjust for changing composition of that flare gas? What's the input pressure? Is steam injection planned? Yes or no? What is the gas flow rate and its variability? What is the water vapor content of the gas and its variability? Have the effects of changing meteorological conditions been considered by the applicant or the county? Are any control measures, for example, low NOx burners, considered as part of this proposal? What emission products are considered? Carbon particles, that's what we see here in the soot, unburned hydrocarbon, carbon monoxide, sulfur dioxide, if there's some sulfur gas that comes out of as part of the waste product, oxides of nitrogen. Then there's the potential, particularly with irregular injections of these waste gases, of unburned combustion products. The burping flare would be the cause of that. So then we have carbon monoxide. We have potential carcinogens of benzene and 1,3-butadiene and aldehydes. We just have literally no information, but I can tell you a flare like that is producing all of those chemicals. So all of these considerations are necessary to evaluate the emissions from the proposed project and determine whether any of the APCD thresholds are violated. There is no evidence in the record that the planning department has asked these questions or is even aware of the issue. My recommendations then is that there are really some fairly straightforward things that can be done. If a flare exists, that flare gas should be treated as a natural resource and it should not be wasted. We could follow the example of a state that's a little bit ahead of us in some of the recent oil and gas development of North Dakota, where their Department of Mineral Resources currently requires a reduction in wasted flare gas with production caps on the amount of oil that can be drilled if those targets are not met. It was recognized in North Dakota that the market wasn't really working to reduce this, so they're encouraging producers to prepare for the future when these gases are compressed, captured, and transported in some manner as a otherwise natural resource which is being wasted. The World Bank organization, the World Bank has formed the Global Gas Flaring Reduction Partnership with the acronym GGFP due to the greenhouse gas implications from wasting of natural gas in these flares. And the county could require offsets for flare emissions even if they're below the current ABCD thresholds. These are all things that could induce a better result from any flares. But secondly, and we'll go to the next slide, I'm going to point out an issue that I see all of the time in oil and gas, which is a lack of available data to the public on exactly what's happening that has a role for, has an implication for environmental degradation. It turns out that there are commercially available mass flow meters that are designed to measure the gas flow that goes through an industrial flare. This is a gas flow meter that's designed, it says, for the gas field, and it comes from a company up in, I think, Santa Cruz here, commercially available. The county could require this and require data logging and make those data available publicly. It's the least that could be done. In terms of VOC emissions, the county used information provided solely by the applicant. We haven't seen what that data are on the emissions of reactive organic gases, and the applicant apparently told you that it's less than 25 pounds a day. Well, that's an assertion. It's not a particularly high bar to cross that threshold, and so we really need to see if there's any veracity to that claim. I again see absolutely no transparency to that analysis. It's probably about as transparent as the crude that they expect to pull out of the ground. So I have then more questions for the county. Was methane separated from other hydrocarbons in the applicant material? If so, what are the individual daily and annual emission rates for methane and reactive organic carbon compounds, according to the applicant? Where are the applicant's data, analyses, and assumption? And who in the county or the APCD was responsible for evaluating its accuracy and veracity? Were accidental and undetected releases evaluated? What are the emission estimates from the well site, piping valves, and other potential points of leakage? What are the estimated breathing losses from the storage tank? So we can go to the last visual slide, and we'll leave that up there. I picked this one only because it is a 500-barrel tank. That's the size of the tank that the applicant has said would be at that site. So take the dimensions of that. That's about 12 feet in diameter and 25 feet long. Holds about 16,000 to 20,000 gallons of crude oil. Now must be quite aspirational, because if they're intending that a tank of that size is going to be what they use and still truck out loads of oil each day, I think the anticipated production level is going to be rather substantial. So it is not prima facie evident that the VOC emissions are less than 25 pounds per day. Therefore, there is a fair argument for evaluating the potential emissions of this pollutant category within an EIR. It is the responsibility of the lead agency, in this case the Planning Department, to provide the APCD with environmental review of VOC emissions. They did not do so, so the APCD cannot address whether the thresholds are or are not exceeded. A serious issue. I'm going to just briefly mention greenhouse gases, because before today the Planning Department basically shined that on. There are plenty of examples of oil and gas developments exceeding expected methane emissions. In fact, there's a recent National Academy of Sciences report which identifies higher greenhouse gas emissions from existing wells than were previously thought. Greenhouse gases are released during drilling, transfer at valves, breather vents, during tank transfers, and due to incomplete flaring. So I do want to mention here, one of the issues, and it's not just greenhouse gases, but it's also VOCs, is the loading losses. So if we take the truck that comes up here and drains out some of the crude out of this storage tank, what's going to happen is that all of the vapor that was in that truck, unless there are vapor recovery systems in place, is displaced and ends up in the environment. Now, this half-empty tank, after that tanker has left, starts being filled up by the pumping equipment, and as it is filled up with liquid, it again displaces VOC emissions, or VOC that are in the headspace of that particular tank. I don't want to get into the technical details of that, but if you want to ask about it, we can go there. In terms of public health risks now, the proposed project is a short 1.5 miles from Piru. The planning department dismisses the potential for public health impacts on citizens, but once again, in my opinion, is putting on blinders. Piru is downslope from the site, and one thought that has not come up at all in any discussions that I've seen is that there is the potential for downslope slumping of the emissions from the site, from the drilling site, right into the town of Piru. So now as we get into the winter time period, when there are very tight temperature inversions, now normally there's adiabatic cooling, and the higher we go, the cooler the temperature is. But with a temperature inversion, and this happens in the winter, there is an increase in temperature at some altitude. Now that could be 30 feet off the ground. This would be intuitively obvious to any of the valley farmers, this phenomenon. So that, in effect, would be like taking the drilling platform, the drilling, and sliding it right down into the middle of the town of Piru, with all of the VOC and other emissions being submitted right to the population that's there. So in conclusion, I think there are far too many unknowns, and there is a reasonable evidence that the current proposal may present public health and environmental risks that have not been properly considered or have been ignored and have not been mitigated. The unknowns exist because, in my opinion, the planning department has failed in its responsibility to the public. So in my professional opinion, there is more than sufficient evidence and suggestion to make a fair argument for a full EIR, and to not do so, I think, is irresponsible.
Thank you for your comments.
No questions?
Next speaker? No, thank you. Teresa Hardigan? Is Teresa Hardigan? Yeah, okay. Excuse me, the next speaker on this list of speakers I have here is a James Hines.
Oh, I thought you called my name.
I know I did, just a moment. The next speaker after Teresa Hardigan is a James Hines. I don't have although he's on the list, I don't see a card in my stack here, so I need to get a card from that.
I'll be just...
Thank you. If you could fill that out while you're waiting.
Statements will be...
Thank you.
Have been submitted.
Thank you. Please, continue.
Hello, my name is Teresa Hardigan. I'm an RN, and I'm here to speak on behalf of my husband, Kevin Hardigan, who has been a general contractor in Ventura County for over 30 years. And he had some things he wanted me to ask about, mostly in relation to the Missouri crossing. So I'm going to read you his letter. I don't know if you received it or not, but to the members of the Ventura County Planning Commission, I was surprised and a little shocked to learn how this oil and gas project was getting different treatment from the Ventura County Planning Department than we are currently facing in our neighbor county, Santa Barbara. He's referring to CEQA rules which apply throughout the state, but he happens to have a couple of jobs right now that apply. So he is using them as an example.
Hardigan-Foley Construction of Ventura must frequently navigate the challenges of CEQA, and while we don't always agree with the decisions that are made, it is the law, and it is for all of our benefit to make sure the environment is protected. Here are two examples to show you why I think that this oil field project requires an environmental impact report. Example one is a project of ours that needed a CUP amendment at a private school which plans to replace and upgrade aging facilities while keeping their student population growth to only 10%. The project is designed to lead certified standards for all buildings and dorms, incorporating state-of-the-art energy conservation and on-site electrical generation. The County of Santa Barbara initially granted the project a mitigated negative declaration, but during public comment, just one neighbor questioned and complained about noise and dust, and the county threw the project into a focused EIR. Example 2 relates to your incomplete review of the impact on stream crossings in the Modelo Canyon project. We have been working on a project where we remove a dry creek bed crossing, a Missouri crossing, and replace it with a clear span bridge spanning bank to bank above the 100-year flood level. We would only be able to work in the dry season. In order to begin the process, the following studies and recommendations were required: stream bed analysis, survey and channel engineering, habitat restoration, consulting and design, archaeological survey, sensitive species survey and monitoring. And then we need review and approval from Santa Barbara County Planning, Zoning, and Public Works, California Department of Fish and Wildlife, the Regional Water Quality Control Board, and the Army Corps of Engineers. Do we enjoy going through this long and drawn-out process? No. But why should the process be different in Ventura County? How can the widening of several Missouri Creek crossings in Modelo Canyon be granted so easily to Big Oil, especially when there are no restrictions on using it year-round? I urge you to follow the law, overturn the planning director's decision, and complete an EIR. Sincerely, Kevin Hardigan.
Thank you.
Thank you.
Jim Hines. If you could introduce yourself.
I'm not Jim Hines. I'm
and
Michael
again,
Shapiro.
Fill out a speaker card before you leave.
Yeah, I did, because I'm next to speaker. You should have it from Michael Shapiro, correct? We did. We handed it in. Yeah, okay.
Okay, go ahead.
Jim Hines, in the interest of time, I'm not going to read his comments. You have it. They were submitted. He can't be here today. He happens to be the forest expert and conservation chair of the Ventura County, of the Sierra Club's Los Padres chapter. And he wanted to be here to personally address the critical importance of Modelo Canyon as a wildlife corridor. In fact, you know, it has been designated as a critical wildlife corridor in the Ventura County Piru Area Plan, and because of that, it's worthy of your time just to read his comments. He's traveling with today, at this very moment, with the Assistant Secretary of the Interior for Fish, Wildlife, and Parks. They're here in Southern California, and ironically, they're here touring the area to help local officials protect existing wildlife corridors and find where they can new ones, and figure out how they could protect and preserve the ones we have. My comments are as follows. With all the expert testimony being presented today, we encourage you to read all the additional submitted material. A lot of expert testimony included in that, meaning quote-unquote experts, and of course lay people. All the testimony combined, expert and lay testimony, presented, all represent that there is indeed, and we quoted this a lot today, but it's something sort of like a mantra, right? Substantial evidence to make a fair argument that the project that's the subject of today's appeal hearing may indeed damage the Piru Wildlife Corridor. It's obviously well established that CEQA law requires the lead agency to provide substantial information and discussion of all the potential environmental impacts of the proposed project. However, and we've spoken of this already today, other people have, the mitigated negative declaration's cursory analysis, not a complete thorough analysis, but a cursory analysis of the project's possible impacts on the Piru Critical Wildlife Corridor, states only that because the project would use existing roads and an existing disturbed site, that it would not increase road density, add to fragmentation of habitat, or introduce new barriers within the linkage. And frankly, such a finding is utterly false. It's patently absurd to make that conclusion. And I think we've also, in some respects, even illustrated some of the slides how that's the case. Declaring as fact that the project's oil trucks and other service vehicles, as well as noise and light pollution, would not increase road density or add to the fragmentation of habitats is simply not true. It's refuted by substantial evidence to the contrary. Since the Modelo oil field has been abandoned for some 20 years, it's reasonable to infer that the existing dirt road has been rarely used. Yes, it's a cattle ranch grazing area right now, but that's actually compatible with condors. That the wildlife corridor has otherwise kind of reverted back to a relatively undisturbed habitat for some 20 years now. Indeed, the area has experienced, one could say, relative tranquility for the past 20 years. So this new proposed project before you is an entirely different story. The facts are that the current Modelo oil project presents, again, the mantra, substantial new evidence, already in the record, that supports a fair argument that, for example, the widening of the dirt road from 12 to 20 feet will have significant impacts. That the accompanied sudden onslaught of a steady stream of rumbling oil trucks will have significant impacts. That all kinds of newly introduced supporting service vehicles will have significant impacts. That the flaring of waste gases will have significant impacts. That all the accompanied dramatic increase in noise, light, and air pollution will all, combined and individually, have significant impacts. However, we don't know from the record so far presented by the applicant and the planning department how many, if any, vehicles will be even traveling in and out of the canyon. That's really not specified. The mitigated negative deck omits any detailed description of the current usage of the dirt road or the frequency of the presence of substantial human activity on the site. And without a current, accurate baseline, there can't be any meaningful analysis of impacts from the project. But again, I'd like to remind the commissioners that CEQA law guidelines, again, section 15091B states, the findings required shall be supported by substantial evidence in the record. Finally, again, based upon extensive testimony today, together with the facts CFROG has submitted, it has been shown that significant environmental impacts do and will exist. And therefore, it's a fact required to prepare a comprehensive environmental impact report for this project. Until such an EIR is completed, any issued CUP is premature at this time, and it should not be granted. And as a footnote, I just want to say, one of the reasons I came aboard CFROG as an advisor, because I like their acronym, it's Citizens for Responsible Oil and Gas. I want to let you know that we are not against fossil fuels and oil and gas. Oil is necessary. I support oil in this county. I support the jobs that it provides. We just want it to be responsibly taken. Thank you very much.
Thank you. The next speaker is Helen Conley.
Good afternoon, Planning Commissioners. My name is Helen Conley. I'm a retired teacher. I was a curriculum developer, and I taught philosophy and critical thinking skills. So I do find some inaccuracies in the records when we're going through them, although I am not an environmental scientist. I am here today to submit my statement as part of the public record for the appeal to you, the Planning Commissioners, on this project. You should deny the planning director's decision to grant the CUP on drilling wells in the new oil field in Modelo Canyon, and we need you to call for a full EIR. I don't see why that is so difficult. It is just one more step to make sure that our county is complying with responsible environmental policies for the oil industry, which I understand is planning great expansions in our county. This will be an opening for you all to better understand what they may have planned for the future. I'm a resident of Oakview, and I'm a member of the Board of Directors for Responsible Oil and Gas, and I say responsible because we do feel that way. I refer you to the brief that we filed for this hearing, and specifically to pages 32 through 37 that address water resources and groundwater quality. I present this testimony as former speakers, our have said, as evidence of a fair argument that you find the current version of the MND, the Mitigated Negative Declaration, grossly inadequate and in direct conflict with the stated policies of the general plan and the guidelines that you have set out for yourselves here in Ventura County. We are calling for this full scientific study because the cumulative impacts on water resources are not addressed in this mitigated negative declaration. And what will be used during this time frame has not been delineated at all during the 5 years of this exploratory drilling. An EIR would answer these questions for us. The public needs to see estimates and disclosure as required of which groundwater basin the private well water referred to in the document will come from, to know if the Modelo Canyon wells will be depleted or not. We need to know where the wastewater or waste muds will be disposed of and the amount and composition of any chemicals in the drilling muds the company proposes to use. Additionally, I have been advised by an oil geologist that drilling mud is composed of not less than 60% water. This directly contradicts the Planning Department's first MND statement that no water would be necessary. Really? They stated that they would use no water? Then, after the original initial public testimony in May of this year, that assessment of water use was changed to state that only limited water would be used as part of the drilling process. Added to that revised report was a tank to store water for fire protection. This is inadequate and contradicts the very guidelines in your general plan for the Piru area. Further, there has been no consultation with the Warring Water Services in Piru on the location of any new wells or the impact on local resources that serve Piru residents. And we have some Piru residents here. It's very important that you hear their testimony. They're very concerned about this project also. Because of this gross lack of cumulative assessment of water resources, there is no evaluation of the risk to pollute aquifers downstream from Modelo Canyon Creek. Should the periodic flooding and washouts of 1 foot high drilling pad berm and collapse that storage tank could happen, we've seen those kinds of, yes, we've seen this in Ventura County. We've seen this often during flood times. And this is a possibility for the Modelo Creek also. This is a picture of the Matilaha Canyon, though, to be clear. The increasing use of our precious water resources for the new oil drilling like this, with a looming possibility of hydraulic fracturing. Remember, they did originally ask to hydraulically fracture. And in May, at the hearing in front of you, Seneca Oil was here and they stated in the public record that fracking in this part of the area in this county is not possible without hydraulic fracturing, and you all heard that statement. It is hard to reach the crude oil like this unless they do some hydraulic fracturing or acidizing. This is now required information for any new drilling in Ventura County. Yet this oil development may claim that because they are not new, as you've heard explained by previously by one of our testimonies, that this oil development may be able to circumvent your processes and not alert you to the idea that they will be fracking in the Modelo Canyon. With no data documentation or proof about the source, location, or the specific amounts, it shows that the Planning Department was only guessing, and that's kind, that there would be no threat to groundwater resource in this area. Further, we are in a serious, serious drought in Ventura County in California that is impacting agriculture and industrial business and all of our residents. These drought conditions are creating a potentially significant, and that is Planning Department speak, emergency, I would call it, conditions on us all. And if the private well the applicant plans to use to provide water for drilling and fire protection is in the Foxen Canyon aquifer, there is a severe overdraft in that aquifer right now, and we know that there are being restrictions placed on users of that aquifer as we speak. Remember, the water demand, which is The MND claims will be temporary is only temporary if the exploration is unsuccessful. And you've heard testimony that it's unlikely that the applicant would be investing this kind of money and time in that area if they did not expect to find crude oil. With regard to the surface water impacts on Modelo Creek, a red-line stream bed, and the potential for mudslides and disruption of stream bed flows, Seafrog notes that the number of crossings is not mentioned in your MND, and you've heard that. They do not mention the number of times that trucks will need to cross the stream bed to get to the pad, the drilling pads. It appears the stream bed environmental concerns are addressed under the MND section on flood control and watercourses, and that section claims less than significant impacts. We obviously disagree with that. Yet according to your own policies and guidelines for flood control, Ventura County's flood control project anyone that has a limited impact must submit a detailed site plan and drainage report to be prepared by a civil engineer, there we do have our experts, and to be attached to any application for permits to your office. These applications and permits were not attached, as there was no water report attached to the original MND in my original comments to at the hearing on the 22nd of May. Seafrog calls for a fully studied flood control plan that would keep debris, sediments, and chemicals from moving down Modelo Creek into the environmentally sensitive and protected lower Piru Creek. In addition, the staff report downplays the significant impact of truck traffic on the Modelo Creek, with 3 to 5 crossings, not one, 3 to 5 crossings of the stream bed on the road to the project site. That means, according to their data, a minimum of 12 crossings, 6 round trips per day, plus up to 2 tanker trucks a day moving through the creek bed. Thousands of crossings a year is hardly less than significant and merits a full EIR, especially since the volume of truck traffic would continue to increase over time as more wells were added. For these reasons and other reasons brought to your attention today, we call for a full environmental impact report before this oil project can be properly assessed and given or not given an approval and granted a conditional use permit by the County of Ventura. And thank you very much for my time.
Thank you. Next speaker is Julianne Lugo.
Actually, I'd like to let Kathy Pace speak before me. She's wearing water.
So you no longer want to be a speaker?
No, I want to be a speaker.
Then come on up. This is your opportunity.
Okay. My name is Julianne Lugo. I am a resident of Piru and a member of the Piru Neighborhood Council. In June of a few months ago, DECOR came to our neighborhood council meeting to discuss the proposal of these wells. We asked at that time whether or not they had completed an EIR, and we were told that yes, they had, or that they were going to. So when we found out that there hadn't been an EIR done, we were kind of surprised. As we began to find out more information about what was going on with Seafrog and the Los Potros Forest Watch, it became apparent to the rest of the residents that it was, in fact, something that we needed to really consider and come before you guys to discuss. As a resident there for almost 40 years, we have had significant health risks posed to our residents due to the oil industry, due to the citrus and agricultural industry. We have had lots of cases of non-Hodgkin's lymphoma, leukemia, asthma, and things like that. So with the with the adding of these wells, there is some concern regarding the amount of traffic, dust, things like that. You guys are all well aware of the Santa Ana winds that come through Ventura County and the area. In Piru, it kind of turns into like a tornado during the Santa Ana winds. Everything that comes down from the canyon comes right into our little town. It's thick like fog. And so those concerns about what is in that dust makes us worry about what these additional wells could expose us to. You guys have talked about, or it has been discussed about the California condor, the habitat, it poses a risk too. Well, it poses a risk to us too. We're worried about our nesting and foraging habits and all of those things there. The California condor, we see all the time. We live there. I've had one land in my backyard and eat dog food out of my dog's bowl. So they are present. They are everywhere. And we would invite you to come out and drive through Piru, talk to the residents, find out, look at the area and see what really, really is going on there. It's a beautiful place. It has restored itself from what it used to be when there were all these traffic and oil well production sites that were there previously in the early 90s. Right now, it is just, we're really shocked. We're really shocked that these companies can come in and not notify the residents in a way that we feel is proper notification, as far as the exposure of what could happen to us, our children, and generations to come. It's a real concern. I have 159 signatures from residents in the town that are asking that a full EIR be completed. So right now there are over 2,000 residents that currently live there. There's 593 households. 296 of those are under the age of 18. So we have a lot of kids that currently do have problems with asthma. And we don't know that that is generally related just to oil wells, but it's a concern. And with a population that small, you have to take into consideration what health risks that there are. It's a small area. There shouldn't be as many cases of asthma or as many cases of cancer or as many cases of respiratory diseases that we are exposed to. And we hope that you guys will take into consideration that there are those people that are living downstream, not just the condor, but the residents of Piru. All right.
Thank you. Do you want to submit
Yes.
your list of signatures as an exhibit? We have a question for you before you leave the podium. Sure. Commissioner Dukas.
What was the name of your organization again? The Piru Neighborhood Council?
Yes, the Piru Neighborhood Council.
Is that something that reports to a supervisor then?
Yes, Kathy Long. Okay. I also have some areas, the Piru General Plan, and I was looking through some of the things that are of concern to Piru. One of those things is the amount of truck traffic that we have currently going through Piru. We are aware that there are trucks currently going through 24 hours a day. They speed through our town. There's a lot of noise. We have residents, like I said, who are dealing with lots of health issues. They complain about the noise and traffic going through because they can't get their rest because there's never a quiet time. If you've ever been to Piru, it's a very quiet town normally. The outside areas we don't get much direct traffic coming from the highway because it's seated back a ways. There's only two entrances into Piru. One is along the 126 where, I'm trying to think what street that is. I guess it's Center Street. And that runs into a rural area and then over the bridge and into the town. The next one would be at an intersection at the 126 and Main Street, which is the road that directly leads up to Lake Piru and would lead up to Modelo Canyon. So the traffic that we usually have is residential. But with the addition of all these trucks, you hear them dun, 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 driving all the way through. You can hear everything in Piru at nighttime when it's quiet. So, like I said, we really have these concerns. We want to make sure that the residents, like we said, get notification because unfortunately a lot of them are socially disadvantaged. We have a lot of people who speak Spanish who don't read or write because they are families who have come in that service the fields in the area or the orchards. And we just want to make sure that they know what hazards are out there and how are we going to be able to protect them and the area.
And you've been a Piru resident for almost 40 years?
Actually 41.
Okay.
41.
So, and can you tell me what it was like when there was the oil production there then?
Back then, I mean, the trucks were coming through a lot, but one of our big concerns has always been during rainfall season, because everything that comes up from the canyon comes directly into Piru. I mean, you can't control Mother Nature and the weather. All of that water, we've had times when Piru's been blocked off because of flooding. We've had times where Piru's been blocked off because of fire. During the North earthquake, we were blocked off because of the explosion that happened in Fillmore, and we didn't have access to really get anywhere. We also didn't have electricity and water for several days because of the damage to the poles and the pump system of the water. So those are concerns that, Piru kind of gets forgotten about sometimes. They forget that people are living and working and raising families there. So we just really want to make sure that we aren't forgotten in this, that our concerns are taken into consideration and that our families are taken into consideration also. And to speak to the wildlife corridor, there's wildlife going through Piru all the time. We have bears going through Piru. I've had a mountain lion in my dumpster before, and I live about less than 100 yards away from Piru Creek. So there's always stuff going on. There's always animals parading through Piru. So I know that they're parading through the canyons. So we want to make sure that everything and everyone is protected through this.
Thank you. One last question on my behalf.
Sure.
Do you know if there is a designated truck route through Piru in and out? There's only one way to get in, two ways to get in and out of Piru.
2 ways to get in, right.
Are you acquainted with whether or not there's a truck restriction route?
Right
If not,
now,
I can certainly get that information from the staff.
it might be listed in the Piru area plan. It just says that any oil development permits shall be conditioned to minimize or avoid truck traffic impacts on the community of Piru. Oil operators should consider alternate traffic routes or traffic migrations such as centrifuging drilling waste, pipelines, and wastewater injection wells. Unfortunately, right now, everything's going through Piru. It goes right through Main Street.
You can't get to the site without going through Piru.
No.
Thank you.
Good afternoon. My name is Kathy Pace. Good afternoon, Mr. Chair and Commissioners. Yes.
I have an address here, but no idea where you live, just beyond your
That's
street.
616 Island View Street in Fillmore, but I work in Piru.
You live in Fillmore?
Correct. Next town over from Piru.
Know it well.
I am talking as a pure layperson because I don't know all this stuff. I currently am living in Fillmore, and I found out about the whole project when one of the neighborhood council came and talked with me at my place of work. I work for Waring Water. I am not representing them by any means because I have no idea any of this was going on. I was not notified. My higher-ups may have been notified, but I will take all this information back to them. But one of the things that concerns me is that in living in Fillmore in 2012, I found out that I live next to a Superfund site. It is 300 feet from my backyard, 300 feet from a school. And in living there, I have had to fight the big oil companies, and I don't want the same thing to happen to the citizens of Piru. The impact, the EIR that they are requesting, I hope that you will grant them and approve the appeal, mainly because all of the things that they've talked about, the truck noise, the lights, all of those things will impact their small town. I live next to it. I have smell, I have noise, I have trucks. We get it all. Right now, I've been living with that for 4 years, and it grates on my nerves. It's horrible. And that's what they'll have to deal with. And they're a small town. They are poor people. You know, when you have someone come up and pay their $50 water bill with quarters, they're poor. They do not have the resources to go to the doctors. They do not have the resources to go get tests done to see if the chemicals are invading their houses. They are poor. There's one school. There's a clinic that's open random hours. These people can't afford to have this kind of stuff happen to them. I hope that you will consider what they are saying. I know that you are considering the animals, as she said, above, and taking care of them, but you do need to consider the town. There are only 2 ways in, 2 ways out, and those trucks are going to be noisy, and they're going to disrupt everything. And I will take all this information of what my notes of what everyone has said, why this is good, why this is bad, back to my employer so that they can know what's going on. And I hope that someone contacts the companies, the big oil people or you guys, to let them know what's going on, because this is the first I've heard of it. And I'm hoping that nothing bad happens because they don't have resources. That was the other thing. Living next to the Superfund site, Mother Nature will take her wrath on us. And in March, water came off the Superfund site, leaked right into Pole Creek, which is right next to my home, went down the Santa Clara. So I know that the oil company will try their darndest to make sure everything's fine, but you cannot guarantee that, and that will impact these poor people. It'll impact their families. It'll impact generations to come. Thank you for your time.
Thank you. Excuse me, we have a question.
I'm sorry.
I'm sorry, I apologize, we do not. County Council, Commissioner Dukas?
Yes.
Based on what Ms. Pace said, is there an environmental justice issue here with regard to CEQA? You don't need to answer right away if you need to think about it, but the last 2 speakers have brought something new to my attention, and with regard to the impacts on people who are without a lot of resources. So environmental justice, I know, is
Right. I don't believe so. I believe CEQA is focused on actual impacts on the environment, and so you have to look at physical changes, either direct or indirect, caused by a project. And so those impacts could obviously affect human health, but you still need to focus on the actual physical changes that may be harming people.
well, we heard plenty about that, about dust, about
Right.
VOCs, about
But in terms of CEQA, in terms of there being a significant finding based on an impact disproportionately harming people of lower incomes, I'm not aware of any case law interpreting or allowing a significant finding to be made on that factor.
Thank you.
Thank you. Romelia Richmond, followed by Jennifer Sage.
Hello.
If you could come forward, Jennifer, and sit in the first row here.
Hello, my name is Romelia Richmond, and I grew up in Piru. My family has been there since about 1915. My dad was born there. My grandmother was born there. However, now I do live in Santa Paula. Throughout my childhood, I noticed lots of people getting cancer. It started in '72 with my aunt as well as 2 other children, and they all passed away in 3 to 5 months from being diagnosed with cancer. And at that time, everybody in town started to get scared that there was something wrong with the water. And we used to question it, but over the years, with the underrepresentation, the fact that we have been economically suffering, we are politically weak, the environment has been abused and still is. We are medically neglected and educationally behind. Therefore, the community doesn't know how to become aware of anything that's going on. Not only that, but they don't understand how to get their voice heard. One such way that I was able to do that is go to school. I have a degree. I hold a BA in history as well as in Chicano studies. My research has focused on Piru and cancer. And a lot of what I found is that, yeah, there is something with the water. However, when I asked for testing and different things to be done to see exactly what's going on there, I couldn't get no help, and everybody answered me with, it'll cost you thousands of dollars, which I'm sure the EIR will as well. However, I don't have the money to do that, but I think big oil does. And so since the 70s, cases are still springing up. Most of the cases of cancer in Piru are non-Hodgkin's lymphoma as well as leukemias. And if you were to do further research on those two forms of cancer are lumped into the same research foundations. Why? Because they are attacking the body and the immune system in the same way. So their symptoms are the same, and so that's why the National Cancer Society of Research does that together. But the reason I bring up these two forms is because, like I said, in Piru, there's a lot of those cases. In 72, one of the kids was my aunt, who I'm named after, and she was diagnosed with leukemia. And then we flash forward to, the 80s, when my next door neighbor had got cancer. I am so sorry. I've presented this so many times, and it just hits home. She was also diagnosed with leukemia. And then in 2001, my next door neighbor, Danny, had got diagnosed with non-Hodgkin's lymphoma. A year after him, my mom. So when somebody in Piru gets sick, the whole community feels it because we've all had somebody that has been in their shoes. Like Jules said earlier, the noise that comes through from the trucks and the 24/7, that came from my Nina's son. His father is really, really sick right now and just came out of the hospital not long ago, and they didn't know if he was going to make it. They're right on that corner that gives you the stop sign before you travel up to the canyon. As a kid, and even as far as a few years ago, I myself would go hiking all the time. We would run the rapids and the inner tubes. That's not safe anymore. When you pour a glass of water from the tap in Piru, it takes so long that what we would do at home is fill our pitchers up with water and put it in the fridge overnight to let all of that stuff that's making it clean settle. And not until the next day could we make Kool-Aid. When we did our washing, our dishwashing, right? We would rinse our dishes in hot water. And now living in Santa Paula, I realized this isn't the norm. But what would happen in Piru is that when you hit the hot water against the glasses, it breaks them. In Santa Paula, I wash my dishes the same, and it doesn't do that. In Santa Paula, I have no problem drinking the tap water. It doesn't take hours and hours to settle. And in Piru, I won't drink the tap water there. I do want to mention that, I do have concerns that anything that's affecting the air and the water and the land, that's how runoff happens. When you do something and it rains, it seeps into the ground and it goes into the groundwater. We have one well that we use in Piru for drinking, and that source comes from the Santa Clara River Valley, which Piru Creek runs directly into. This has been a concern for me for many years, and in fact, I'm going to be applying for grad school to continue this. I'm tired of seeing family and friends go through what we've had to. It's a horrible thing to get sick from people coming in to make their lives better. We don't get the money. We don't get the jobs. They do, and they leave. They don't live there. They don't go jogging up to the lake like I do and come back with dust in my mouth and asthma. I have asthma. All of my brothers and sisters, well, my brother and sister as well have asthma. All of my sister's kids have asthma. And we were all born and raised in Piru, right? We were born in Santa Paula, but raised in Piru. Piru Creek isn't just the home of fish and wildlife. It's also home to us people. Experienced hikers will go through Modelo Creek because it's a nice peak to look. It's a nice area to look at, and it's relatively close to other areas of interest for hikers. The rapids, like I mentioned, people used to run those. We can't anymore because the lake has closed off, letting the water come down. And if you were to look at that and see what happens when the water is released, we would live it as kids, and you see everything. To this day, there's still remnants of the movie theater that once existed in Piru. No cleanup was done. When the toxic waste leaked into the ground from the Piru dump, no agency wanted to take any. Nobody wanted to take care of it. It was this agency. We didn't own it then, so it was this agency. It's really sad that Piru is so unrepresented in the way that it is. I really can't say how many good memories there are for me in Piru. But what I can say is that there's a lot of bad ones too. And it's not from Piru or Piru people, it's from remnants of people coming in to do things. Before it was citrus, and we had the beautiful aroma of citrus everywhere, and it employed the people in the town. But over the years, those orchards are teared down. And, they're left like that until somebody decides to redevelop it, agriculture or something, but then the dust gets kicked up. And that brings in all of these health issues, right? So I'm just thinking if they're going to go do this, and one of my uncles used to work at that Modelo Canyon oil well. It is going to impact those people. He lived on that road, and it does impact the people on that road. There's only one way up and one way down, and it's curvy. How, if you were ever to just stay a day in Piru and, stay the night or something, you would see the effects that people have as to everything that comes in. So I really hope that maybe now somebody could do an EIR, and maybe we could get closer to understanding things, and maybe this proposed site won't be the cause of anything directly. It's going to add to the rest of the risk factors in the community. It's going to add to whatever's going on already in the air. It's going to add to whatever's going on to the soil and as well as the water, which is a big concern. If we have one water well, what happens when that water well is polluted? We don't get water. During the Northridge earthquake, I know we had to stay at the school. We had bottles of water that we filled up from home. What do we do when we can't do that? We go back to oil drilling, boiling our water. But not only that, but the noise that was brought up earlier. In my research that I've done, I interviewed a 98-year-old woman at the time, and she said that when she hears big trucks, it takes her back to the Depression. It takes her back to the fear of World War II. It takes her back to all of this stuff because all she used to hear was all this psychological warfare going on. They used to hear the big trucks and the big planes. And all of this comes back to those elderly residents. And it scares them. And I don't think that it's fair for them to be scared of something that's not benefiting us or our community in any way. And that's about it.
Thank you. Thank you for your comment. Before I go to the next speaker, I just realized I passed over Mr. Brooks. I represented to you. You get the opportunity to be a couple minutes behind your speakers, if you'd like to do that now.
In the interest of time, I'd like to just move everything to the conclusion.
Great. The next speaker is Jennifer Sage, followed by David McDermott. If you could move to the front row, please.
Good afternoon, Planning Commission. I'm Jennifer Sage. I did not plan to speak, but I've been here to sit. And I just had a couple comments that I wanted to bring up, so I'll try to make this brief. I am in support of an EIR, before exploration drilling. One of the problems that I heard from that you had that CEQA had said that there is a pipeline leak. The only one that they knew of was basically in 1911. And I would like to challenge that, and I think you probably need to challenge that before you go any further. That was, I believe it was on well 36, I live in the Upper Ojai Valley. I have a ranch there. I have 3 oil wells. 2 of them are on my property. 1 of them borders my property. I look at many oil wells in the distance of my acreage. And throughout the 23 years that I've been there, there has been many oil leaks. And the oil companies, such as Vintage right now, uses private construction companies to do their oil cleanup. And I do have a list of a few of them. Hofmeister Construction is one of them. And I don't know if you've asked him, but my son has also worked on oil cleanups. And there is more than one. It happens very, very regularly. The oil pipes that were put in 1911, all of them in the Upper Ojai Valley are very, very old. They're cracked. As you have pipes that break in your house, this is what's happening. The infrastructure is extremely old. And there is not only oil leaks, but there are pools of, when they say an oil leak, it is a pool. It is almost a lake that they have to get bulldozers in there. And I've witnessed this many times when I'm just living from my property. I've seen the lights in the distance, and I've walked over there and reports from my son and from the construction, independent construction companies. So I do ask that you research that, because that is not true. Maybe they only have 1 listed. This is an ongoing problem. You said that there's no growth around the oil wells. That they said that there'll be there's no growth around the roads and everything. And I will say, but besides building a road, they also spround Roundup as a weed abatement. And it's, I believe, 10 feet from both sides of the road where nothing is allowed to grow. So just kind of to clarify the no-growth situation on that. My problem is on the exploration, that they have to report to Dogger on this. We're talking fracking, which is allowable, and we're saying that it can take 4 years before they report to the public. That really scares me. And I think you really need to consider that as a really huge problem. We don't know what they're doing in those 4 years. So this is why I would say forefront in ERI on this. Your nesting site is 2.5 miles from pad number 2, 1 mile from pad number 3. Have you ever walked 2.5 miles? How long does it take you to walk? We're talking about condors flying. We're talking about them nesting. That's a really close proximity. I'm not a bird kisser, okay? I'm not a tree hugger, but, just to me as an outsider, that sounds awfully close to me. And we're talking about them nesting, okay? Producing young and regenerating. They also said earthquake may not affect oil wells. It might not affect oil wells, but we do know that it affects oil pipes, which are in place. So I question that. Okay, oil pipes have pollutants in them. They break from earthquakes. They say fracking is an earthquake. It is an earthquake. What are we doing? Why are we allowing this? It's an earthquake. It's okay if it's natural. It's another thing if it's man-made. If we're causing this, we have no known ramifications of what can happen. We don't know. We don't know because it has not been investigated yet. Please investigate it before we go ahead and allow all this fracking to happen, at least within our county, if we can stop this. It's monumental to the environment. If we have ants that can sensor earthquakes, how does that transcribe? You know, we are causing this. We're fracking. We're causing earthquakes. I don't care how small they are. I think that's almost probably all I have to say, except for which really sent up a red flag to me was that creek is a red line creek. This is a county ruling to protect our environment. Why would we even sidestep this? I didn't know if it was a red line, but I've just heard it is. And if that is in fact true, which you should really look into that, there is a setback line which was stated. That's the rules that you all made for the county. I hope you uphold to that. And the last thing I can say is I moved on my property in 1982. I built my house there, and I have a horse ranch there. And 3 years later, I developed asthma. I started getting very sick for the first 3 years. I developed asthma. I am a chronic asthma and COPD patient right now. I suffered cancer, and I hope it's in remission. And there can be 100 reasons why that happened, and I'm not pinpointing on this. But I would say I'm requesting, because I do have questions about all of that, that at least we have a ERI report on the particulate matter to see if they're carcinogenic or what levels they are before you go ahead. Thank you very much.
Thank you. I'm sorry, next speaker is Mr. David McDermott, followed by Deanna McCormick. If you would move toward the front of the room, please.
Chairman Rodriguez, and Planning Commissioners, staff, and all you good folks out there. I'm David McDermott, Senior Attorney for DECOR. I've been there for about 1.5 years. Prior to that, I was Assistant City Attorney for Santa Barbara and Deputy County Counsel for many years. Yes.
Mr. Can I stop you for a minute?
Yes, please.
Are you speaking on behalf of the applicant?
No, I'm opposed.
Okay. Okay.
Did I put something down wrong in there? Let me go sit down and wait my turn.
You're up there. You've got the mic. Go ahead.
Oh, is that right? Okay. It's not going to be long. So anyway, I was just saying that I've been over there, and I've advised folks like yourself, and I know it's a long day. So thank you for your attention. Just a couple things. One, flare, gas, that whole issue. We have to use a flare, because if not, we've got to put in a gas line which goes for miles and miles. We can't store gas on site. So I don't know if folks are really aware of that or appreciative. I think the gentleman from Los Padres wasn't sure exactly what he meant, exactly what would it entail if we were not allowed to use a flare. But that's not a possibility, so the flaring really has to go with the project. I would really like to commend staff, and someday I'm probably going to be up here trying to say that they didn't do a good job.
Can I just jump in there for a second?
Absolutely.
But you can capture gas and then run turbines, right? Gas turbines, right?
You can. I am not an expert in this.
Okay.
And the reason
I just wanted to make sure that
right, we can't store it on site.
Unchallenged.
I mean, it's not what, because we had kind of an anecdotal deal, a conversation. I wish that our geologist was here. We are trying to do an exploration of 2 wells. There's a lot of, wow, I get interrupted. This is a test to see if I can keep my train of thought, right?
Continue.
Okay. So we want to do the 2 exploratory wells. I know there's been a lot of conversation about what's the percentage, what's the likelihood of success. I will tell you that if we did not have some hope for success, we would not be doing this. We have a lease agreement with a landowner. We have an obligation to move forward. So we're not doing this just to be good people, but we hope to find oil. But there's so much uncertainty there. And so when it comes to study the foreseeable impacts, the only foreseeable impacts are temporary wells, a temporary production facility. If we want to go forward, we've got to come back. We must comply with the law. We cannot sneak in and frack. One, it wouldn't work. Two, we wouldn't do it. It's not on the card, it's not in the table. So I can give you my personal assurance, officer of the court, DECOR would never do that. We have applications in other places. We follow the law, and that's what we'll do here. I just want to correct something. I think the young lady represented that at a meeting we said that an environmental impact report had been done. And I think it's just a bad communication, because that was never said. I think we might have used the word environmental review. I'm not even sure, but it was at a neighborhood meeting which we were invited to attend. And so I just want to be clear, and I hope that you don't think that we would go to a meeting, represent something that was patently false, and try to get away with that. That just didn't happen. We really hope that you will take the information that is relevant to the CUP modification. You have been given so much information, over, 6,000 pages and more, that is supposed to be part of the record, which you then must review and consider and determine how you're going to rule on it. I don't know how you do that when 6,000 pages were turned in yesterday. So I'm going to ask that, and urge that you trust the competency of the Planning Commission that didn't go at this lightly. What you're hearing today, I believe in part, is a fear or a dislike or a concern for oil in general. Carbon, footprint, the environment, all valid and good things. One, I don't think it's all concentrated in our case here today. And I don't think that the argument should be, well, if we can stop these 2 exploratory wells, then that's a start. I would ask that we be judged on the merits of our modification, our request. We will do what we say we're going to do. We're not going to tell you that we'll accept a condition and then ignore it. I believe this project has been conditioned, probably from my point of view, more than I would like, but totally reasonable. And so please deny the appeal. Allow us to move forward. If DECOR were to mess up, you would know it. That would be in our track record. But we haven't messed up yet. By the way, on Condors, we have oil wells at Temescal. There, the Condors are right in plain view, and we are trained. We train our folks for all the micro trash. It's not a new experience. So going into this project, even though we will totally accept and understand an education process, our folks are trained in this. We understand the Condors are right next door. So anyway, thank you for this time, and hope you will deny the appeal. Thank you.
Thank you. Deanna McCormick, followed by Ron Whitehurst. If you would move forward, please.
Good afternoon, everybody. Thank you for hearing me. I'm representing CNA, the California Nurses Association, today, as well as I'm on the board of the Ojai Raptor Center. So I'm also, not only public health, but also a wildlife enthusiast. And I do want to urge you to wait on this project until a full environmental impact assessment can be completed. I've heard that as I've come in and out today, because I keep going back to work. And I'm really happy to hear that so many people are asking for this. And if there's nothing really wrong, then why not have it? Many good points have been addressed at the initial hearing regarding the period of exploration proposed, the potential piecemeal implementation, and what criteria will determine the end point of this project. In addition, valid groundwater, water treatment and water resource concerns have been raised, especially during this intense drought. Thus far, it is my understanding that drilling companies do not need to inform the public on what processes they plan to use, including the materials or chemicals involved. We are not satisfied with the verbiage exploratory drilling. Since this project is in our own backyard and there are no details given, we are requesting transparency and clarification so that we can ensure that the impact on the environment and our community has been adequately assessed. Since disclosure of the chemicals and contaminants are being withheld, we must automatically assume the worst. Accidents do happen. The MND did not have a hazmat contingency plan except as per the county. There have been at least 9 known spills that I've known of since 2000. Which have released hazardous waste, oil, and oil additives into our community, which have devastated many taxa of wildlife, as well as the community surrounding. Additionally, oil workers are subject to gross occupational hazards. The statistics from the DOL, the Department of Labor, and the CDC show a correlation between drilling activities and the number of occupational injuries related to drilling, including motor vehicle accidents, explosions, falls, and fires. Oil workers risk developing pulmonary diseases, including lung cancer and silicosis. They have also exposed to environmental toxins from the diesel machinery and trucks, including ground-level ozone, which is a potent irritant responsible for the reduction of pulmonary function and the exacerbation of asthma and emphysema. In turn, this does cause cardiovascular disease, chronic obstructive pulmonary disease, and cancer, as I said before. There are potential economic and ecologic issues, drilling malfunctions, and violations of regulations designed to protect the environment, which will lead to a long-term environment and health damages to the surrounding community. Moreover, our wildlife, which includes but is not limited to the threatened species, the sage grouse, the long-eared owls, and the burrowing owls, just to mention a few, especially with the lights on at night, traffic, especially noise. Specific study on the sage grouse show that their breeding process decreases by 73% with excessive man-made noises. The recommendations, this is all I have left for you. I'm quick today. The recommendations, one is to please conduct a full impact environmental full impact assessment. Implement an oversight committee, not having the wolf watch the hen house. Require a worker environment awareness program, as he did say that they do watch microtrash. Relocate roadkill away from the work site to minimize the condors foraging in that area. Create a hazmat contingency plan. Protect the environment by reducing toxic waste and holding toxic oil and gas waste to the same standards as other types of hazardous waste. Implement a robust inspection and enforcement programs and fully disclose all chemicals. Most of all, we really want full disclosure. Any questions?
Thank you for your comments.
Thank you so much.
Ron Whitehurst, please. Followed by Sherry Topper.
Hello, my name is Ron Whitehurst. My wife and I run Rincon Vitoba Factory right near Highway 33 and Shell Road. We're in the midst of an oil field, so we're quite familiar with the traffic, noise, smells, and general disruption of the community by oil drilling activity, which has increased in the last 3 or 4 years. So I'm here speaking on behalf of Ventura 350. We want to encourage people to reduce their use of fossil fuels. One of the ways of reducing the small chance of problems from earthquakes, fires, and accidents on this well site is to not drill. That's real simple. There's no pipeline, so you're going to be trucking the fossil fuel by truck through this brownfield community, apparently with the cancer cluster already, creating more havoc for them. I'm a pest control advisor. I daily work with petrochemical, toxic petrochemicals. I actually advise people not to use them, but I'm familiar with them. And the petrochemicals coming off of the wells are, similar to some of the toxic pesticides. So I'd like to speak to the cumulative effects that was quickly dismissed by Mr. Baca, that on an ongoing basis, wells are permitted to release 500 pounds of volatiles per well per year, with an option to increase that by simply paying a fine. And what are some of these things? So, of course, there's methane, but there's also the BTEX materials, benzene, toluene, ethylbenzene, and xylene. These are materials declared by the state of California to be carcinogens, mutagens, and carcinogens. And there could also be hydrogen sulfide, which is a neurotoxin. All of these things will be drifting downgrade to the community of Piru. Scientists say that we need to leave 80% of the known reserves of oil, gas, and coal in the ground to fend off catastrophic climate change. Exploring for more resources is counter to the direction we need to go for climate stability. Oil production brings big dollars into this county. The subtext here is that we need to take care of the moneyed interest. But Mr. Baca, with his dismissiveness of significant questions, shows his bias to promote oil production. When we allocate comparable resources to renewable energy production, we get tenfold more jobs. Solar panels don't leak, and wind turbines don't pollute the air. Let's move towards more sustainable regenerative technology. WISPA's estimate of recoverable oil was reduced recently by 95% by United States Geological Survey. So this oil boom is more looking like an oil blip. And we would encourage the local chambers of commerce to hitch their wagon to renewable energy that will bring more jobs and more revenue than this receding technology. Our county produces about $2 billion of produce from agriculture. And if you look at the industry standards for well casing failure, we see that there's about 5% of the well casings fail immediately, and 100% of them fail within 30 years. So that every new well that we drill is kind of sealing our fate that we're going to have a major contamination of our surface water and groundwater. So water is a necessary resource for growing food. So we have competing uses of water here in this county. So I would encourage you to accept the appeal and require an EIR for this project.
Thank you. Sherry Topper.
Chairman Rodriguez and commissioners, thank you for allowing me to speak today. My name's Cherie Topper, and I am here on behalf of the Santa Barbara Audubon Society. Our Audubon Society is a chapter of the National Audubon Society. We've got more than 1,200 members in Santa Barbara County, including an engaged and active conservation committee. I'm here today to represent this membership, and we're standing in alliance with Sea Frog, Los Padres Forest Watch, Ventura Audubon, and others in our cohort to support the appeal for a full EIR for this project, with consideration for reasonably foreseeable development of the Modelo Canyon site. We also support the requirement for condor protective measures recommended by the U.S. Fish and Wildlife Service without alteration or waiver. I came to this field after many, many years of designing, building, and managing ultra-high reliability imaging sensors. Among the projects that I mentioned, that I managed or worked on as an engineer or a program manager are the Landsat and WorldView 3 imaging satellites that ironically provide us with substantial evidence of global warming due to the release of man-made greenhouse gases. I would surmise that, like these imaging systems, our planet is made up of a network of complex interdependent subsystems. And before change is introduced to that subsystem, predictive modeling is needed to truly understand the systemic impact of the change. We are now seeing the tragic effect of uncontrolled, poorly understood, and unmitigated change on our ecosystem. In fact, the September 9th Audubon Climate Change Report culminated a 7-year study using 40 years of combined data combined with sophisticated environmental modeling. It presents us with the sobering consequences of this uncontrolled change. That study showed that we may lose nearly half of our existing bird species within the next century due to the effects of global warming on habitat. The reason why I believe that this is relevant to the Modelo Canyon case here is that we're introducing a perturbation into a high reliability system. That high reliability system is our environment, and I think we'd all agree that that is vitally important. And to keep my remarks short, I'm just going to review one of the list of best engineering practices from my many years of experience in successfully deploying these products. I'm just going to give you one of the best practices that we used to ensure that when we put an imaging system up into space, that system was going to work. And one of the primary things that we did was we did an early assessment of the impact of the full implementation of that system. We didn't just look at that system and say, okay, we're going to build a little infrared camera and we're going to take a picture down here on planet Earth and sure, everything's going to be fine once we launch it. We took a look at the entire picture. And like what we had to do to ensure the success of these systems, we recommend that you require a full EIR so that you actually understand the implications of that reasonably foreseeable development, rather than just taking a look at the segments of this project in relative isolation. We revealed that we believe that would reveal potential issues that could potentially prevent the development of the site in the future. But my main point is that, please, I urge you to use facts, data, and predictive modeling to really understand what we're trying to do with this project. I thank you for letting me present these comments today.
Thank you. Final card is a John Lates, L-A-E-Z.
Good afternoon. My name is John Arbeláez. I am a representative of Earthworks. We are a nonprofit organization based in Washington, D.C. And
I apologize. I thought that was part of a middle name. I apologize for the mispronunciation.
No worries. We are an agency dedicated to the responsible extraction of fossil fuels, including oil and gas. Earthworks has some serious concerns regarding the proposed project to reopen oil production wells in the Modelo Canyon. Based on the testimony that I have heard today and that I have read from the reports, this does not sound like an exploratory project to determine if oil is present in this area. Oil has been known to exist in this area, and the applicant would not be spending the resources that it has so far unless there was some kind of certainty that the oil would be found there. The Commission's findings that an EIR is needed is without merit. Any work, including the drilling of test wells, increased traffic and construction, noise and odors, will have a detrimental effect on the fragile and surrounding ecosystems. This warrants the need for a full environmental impact report. Only through a full and thorough EIR will the effects of the project be completely understood and mitigated. Dismissal of any scientific data from other states and countries, such as Canada, such as was mentioned earlier, is not only irresponsible, but goes against the ethics of scientific research. This absence can lead to an inadequate regulatory framework and the creation of unenforceable safeguards that will not protect people and their surrounding environment. The EIR must provide the public with detailed information and thoroughly and fully evaluate the potential effects associated with oil and gas development within the proposed scope of the project. A full life cycle analysis of the project, from the planning to construction to production to transport and to use of the extracted hydrocarbons, must be included in order to present a full and clear picture of the process. When negative and adverse potential impacts are detected, mitigation measures and alternatives must be looked at to minimize the impacts to people, economy, and the environment. We support the efforts of Los Padres Forest Watch and the Citizens for Responsible Oil and Gas and urge the Commission to perform a full EIR on the Modelo Canyon test wells. Thank you very much.
Thank you. Mr. Brooks, I told you I'd give you the opportunity to wrap it up.
Thank you, sir. I'm going to sum up and try to finish up so much of what we had proposed to bring to you, more substantial evidence, we've condensed or dropped. We've gotten rid of an eyewitness to the OI 36 spill. I'm not going to talk too much about the San Cayetano fault, which repeatedly was not in any of the documents or on any of the maps that initially were proposed. They used maps that they stated there was no active earthquake fault in the region. In fact, one of the most active earthquake faults is there. So at each time of at each point of the process here, we've brought what we believe is substantial evidence and corrections to the record. The record has been correct. You can notice that even this morning, they dropped in more information on greenhouse gases that wasn't there before. It's been a piecemeal process to build an MND that still survives. That's not good planning. That's not the way you do it. You do an EIR, and you put it out to the community and the scientists, and they review it, and we all discuss what the impacts will be. And we all come up with good ideas for mitigation. It's been said repeatedly that we are citizens for responsible oil and gas. Somehow that's interpreted as being anti-petroleum. It's not. I drove here today. I know I use it. I've used it throughout my life. But at the same time, you heard the real experts in this process, who were the residents of Piru. Were they surveyed? Were they questioned? Was there analysis done of the cumulative impact of all the oil field operations that are the truck traffic that's coming down Piru Canyon Road through their community? And you say, why is that the responsibility of DECOR? Well, in many instances, there are no CUPs where these new wells are going in. They just pop up. There's no review at all. They're on old CUPs. They're on no CUPs. When there's a true opportunity to look at what was not done in the past, this oil field was never studied in the past. There's remnants of 63 oil wells up there now. Has anyone done a survey of whether those well casings are leaking, are fractured? No one's even visited them to do an analysis of what's in that canyon now. How can we go forward with reopening of it? And they keep calling them test wells. They're wells, okay? They drill them to the ground. They're pulling out petroleum. They're transporting it in and out, and they're bringing it all to the people. Now, the Piru Neighborhood Council board, they didn't mention that, voted unanimously in support of an EIR. And you heard their emotional testimony. And Commissioner Hydukas, there is some environmental justice going on up there. Because here again, we are faced with a moving environmental football. We bring forward substantial evidence and experts. They either dismiss it based on their own opinion and no counter-scientific evidence, or they just ignore it and don't even add it to the record. such as the location of the actual drill pad. We told them repeatedly that it wasn't 16, it was 10, or was it 10, was it 16? And now this morning, they finally have decided that the drill pad that in question is 10. Why are we at this process now? That should have been something that would be fully studied in an environmental impact report. We wouldn't have these questions and these issues and these beliefs of illnesses and asthma, okay? Somebody needs to take a look at that. I don't know if you probably didn't see it, and I don't know if I have a picture of it. And I hate to get to be into the the tree hugger category, because so many people seem to think it's wrong to hug a tree. This was Sunday in New York City. 400,000 people marched, saying, "Do something about greenhouse gas." This morning, Mr. Baca, I guess after working all night, dumped in a huge section on greenhouse gases that was never in the MMD. I haven't read it yet. I don't know what his analysis was. I presume he says that there's no impact on greenhouse gases, because that's usually his response. You heard from the people of Piru what they're breathing. No study has been done of the additional stuff that's coming down Piru Canyon Road. Why has that never been studied? Why is this not an opportunity to do that study? We say it is. We respectfully urge you to set aside the MND. It's clearly deficient of the CEQA review. Direct your planning department now to prepare an environmental impact report, because we've shown you. The experts have shown you. The people have shown you that there is substantial evidence of a fair argument that the proposed project may, not will, but may create serious damage to the environment. That is the threshold. We've shown it to you. We all live in Ventura County. Let's make it a better place. Thank you.
Thank you. Are we, pardon? Yes, we're going to take a 10-minute break here. Yeah, okay, let's continue with the, have you take your seats, please. Let's continue with the meeting. One final comment as far as public comments on rebuttal. Mr. McDermott's card was kind of mismarked, and so you spoke earlier, but does the applicant have anything further to say before we close the public hearing?
No, thank you.
The answer is no. Okay, thank you. Then we can go ahead and close the public hearing. And just...
If I may, Mr. Chair, in case we have some questions, why don't we keep it open until after staff is reported?
Okay, okay, that's appropriate. Staff, your turn.
Thank you, Chair Rodriguez and members of the Commission and everyone who has come out today and spent such a long time with us. I have a few things that I want to say, introductory comments. Clearly, we heard about 3 hours of public testimony, and we have a lot of responses to that. I have some introductory comments I want to do, then Brian will have some comments. I want to have Holly to have the opportunity to address some things that we heard from a biological perspective, and then our County Counsel, Jeff Barnes, is going to have some comments as well. So I want to really refocus back on the project that we're doing. I heard a lot of things today that said, I don't see why it's so difficult to prepare an EIR. It's just one more step. And why not have it? And why can't we be more like Santa Barbara? And I want to explain that because in this county, the Board of Supervisors has adopted thresholds of significance. And those thresholds of significance are gotten to through the initial study process. So we get an application in and we review the application in front of us. This happened to be 2 exploratory wells and 2 truck trips per day. That's the project in front of us in its very essence. So we take that project description, we put it through the rigorous county review, air pollution control, groundwater, transportation department, watershed protection, and the thresholds come out where they come out. It's not a guessing game. We don't just say we're going to come into it and prepare a negative declaration or a mitigated negative declaration or an EIR. It's come through at a very methodical way by using thresholds that were developed by our board so that both of our constituents, the people that live in the county, and the customers that are applying for the permit have some reasonable expectation of where they're going to stand. So, I've heard a lot of things today about, that they want full disclosure, and you need to get full disclosure of what's happening here through an EIR process. And I want to tell everybody that a negative declaration and a mitigated negative declaration and an EIR, they're all full disclosure documents. We have hundreds of pages, hundreds of responses to each and every comment that was heard at the public hearing, in the environmental review process. It's full disclosure. I know the word environmental impact report and EIR. I hear it every hearing I go to. But I'm telling you, there's a difference between an EIR, and the difference is simply this. It is saying if you cannot mitigate to that if you have a project that may cause a significant effect on the environment, but then if you can't mitigate it, if you can't mitigate that, then you need to do an EIR. So let's just take the issue of the condor. So we worked lots of hours, lots of meetings with both the state and the federal agency that is responsible for protecting this endangered species. We don't take that lightly. They gave us the mitigation measures, apply these and mitigate to a less than significant impact. We apply those, and EIR is not necessary for that because there is no taking of a condor. That's the way that the process works. You have to have an impact, an obvious one that cannot be mitigated, that would say if you're taking 2 trips a day, 2 truck trips a day, what is the health risk impact of those 2 truck trips a day, both on a project level and on a cumulatively considerable level? So I keep hearing that, and I want to be really clear that the process that we've done is the process that the board has asked us to do. So we're not out here applying any regulations. The planning department is a proponent of the process that was given to us by the board, by the state through CEQA, by the federal government. We do not apply, we're not proponents to anybody's particular project. We apply the law fairly and evenly. So I want to talk a little bit about the PNC because I'm concerned about what you said. We went out, clearly, as we do. We have very good relationships with the PNC and with all of the MACs, and they are advisory boards to the Board of Supervisors. So clearly, we listen very carefully with what they say. It wasn't just DECOR that was out. We sent our staff out. And so I understand the words environmental impact report or environmental review can get confused. There was never any doubt. We were never preparing an environmental impact report. And when we came out, we had the environmental review. And it was the environmental impact report wasn't what was approved. It was the project that was approved unanimously by the PNC. So that's, so if there's some discussion that we need to have, I would like to have that. I wouldn't want anybody to ever think that Piru is forgotten. I can guarantee you it's not. We did a full EIR on the area plan update that we did out there just a couple of years ago, and I know that Supervisor Long is very up to speed on everything that goes on in Piru. So I just wanted to make that known. And I didn't hear until today, through your testimony, that Piru was at all, that there was a petition filed, that there was a concern that you had. I received no calls, nor did staff, that there was anything except the unanimous approval when we went out there a few months ago and clearly explained and articulated the whole process. So, I'd like to be able to get together and have some further dialogue just on how we work back and forth, because that was a real surprise to me. And then, I just want to say, too, that I understand that oil and gas is kind of a hotbed issue right now, which is why we did do so much training, and that training was very popular. I only heard very good responses from that because I can see, these issues arising, and I just want to be able to put this out here for the public that we don't take these issues lightly, very seriously. I don't think that you'll find any oil company or DECOR for this matter that says that, we looked at anything other than with full and 100% scrutiny. And then we also have some things to say. There's some basic things that happen. This creek is not a red line creek. We'll get into all of that. I just wanted to be clear, because I don't want there to be any misperception that we're taking anything that CFROG or Los Padres Forest Watch, and I actually believe that the information that is put on the record by Mr. Kuiper and by Mr. Brooks and his team has changed our responses, and we've changed things in response to their comments, and that is not piecemeal planning, as Mr. Brooks calls it. That's the CEQA process. We prepare a document, we send it out to the public, we take their comments into consideration, and then we include them in our document if we've missed something. That is the process playing. That is not piecemeal planning. That is planning working at its best. So I wanted to get that out there as well. And so I'm going to turn it over to Mr. Baca and Holly to talk about some very specific things that we need to get on the record.
Mr. Chair, members of the Commission, the first thing I want to point out, and I'll concur with Director Prilhart, the commentary by both CFROG and the Los Padres Forest Watch organizations have resulted in improvements in the negative declaration and improvements in the conditions of approval. And Mr. Kuiper particularly found one improvement that I had promised that miraculously did not appear, and that's why it is in your errata sheet. And I wanted to point that out. First, what we've added to the mitigation measure number 5 has to do with power lines, and we just added, right now we have all power lines, poles, and guy wires shall be retrofitted with Raptor guards and various other language. Well, that stays, and what we're adding is that new power lines shall be installed underground if determined to be necessary to avoid impacts on the California condor by the planning director in consultation with the U.S. Fish and Wildlife Service. Now, the project doesn't include any power lines, and so this is sort of a placeholder in case something comes up and somebody wants to put in a power line. Pretty much it's going to have to go underground unless you can approve otherwise. Then there's another section that particularly Mr. Kuiper caught, and I agree totally with him. It currently says that the permittee shall implement the BMPs, that is the condor protection measures, unless waived by the U.S. U.S. Fish and Wildlife Service or a county-approved qualified biologist. Well, that can't happen because, number one, the county can't turn its regulatory authority on its permit over to some other person or agency. So the revised language says the permittee shall implement the BMPs listed above throughout the entire life of the project unless modified by the county planning director in consultation with the U.S. Fish and Wildlife Service and the California Department of Fish and Wildlife. A county-approved biologist shall confirm and photo document the installation of the BMPs. So the county's in charge of that, and you notice it says modified, and basically you have to meet the purpose of that condition to avoid the impacts on the condor in order to allow modification. So those are the kind of improvements that you get in the public review process, where other people that haven't looked at the document 45 times get a chance to look at it. I have various other commentary, and if you'll forgive me, I'll just go down my list here. There was some commentary from Commissioner Idukis that there's other measures that could be taken to make the site better. We've added some language for construction fencing. We've made sure that term caution tape has been removed everywhere in the document, and it's being replaced by construction fencing wherever we need to have something fenced off. We've added to the definition of micro trash, or to the condition involving micro trash, and I can read that into the record, I think. Here it is. All construction debris, food items, and we've added cigarette butts, and other trash, including micro trash, including but not limited to small items such as screws, nuts, washer, and so forth, so that there's no limitation on what we identify as micro trash. Then we've also added will be covered or otherwise removed from a project site, and then in parentheses, including the access road at the end of each day prior to periods when workers will be there. So we've added that to expand that definition. We're going to add the requirement for a hand washing station, and also add to the requirement for pre-construction biosurveys that there are stop work authority is granted to the biologists who are inspecting the site. Now, if I can borrow my CEQA back from my leader, there was some discussion presented by Mr. Richard Hawley regarding CEQA section 15149 and 15A and B. And I'm afraid that he misread the law while he was reading that. While an EIR is not a technical document, in the fields of endeavor that involve geology, engineering, medicine, and various other things, the information that goes into the document has to be obtained from a licensed professional. Thereby, a planner can write an EIR and do a section on geology, but that section has to be based upon a geological report signed and stamped by a licensed geologist. So, and that's what the law says, and it says right at the end, which will be prepared in support of an EIR. That means that a person who knows nothing about geology simply can't write the geology section of an EIR. And that is consistent with, of course, Section A, which says certain professional fields are subject to licensure in the state of California. Mr. Kuiper made the comment that well, we know oil exists at the site. It's actually squirting out of the ground. Well, that's a true statement. It is squirting out of the ground, and so he likened that to say, well, this is the same as the case in San Benito County, where the Citadel Petroleum is drilling a known oil deposit. Well, if the DECOR project was proposing to drill into and produce from the productive zone, the known productive zone in the abandoned Piru field, well, that analogy would be correct. They would have to look at future production because they know the extent of that productive zone. They're not doing that. They're drilling below that zone, the zone that actually was produced at the Piru field was very shallow. They're drilling below that zone to a zone that has not been produced before. And that's the criteria under which they receive confidential status from the Division of Oil and Gas. So it basically, as I said before, the Citadel project involves drilling into a known oil deposit with known boundaries and extent. The DECOR project does not do that. Furthermore, the court decision, whether temporary or final, it supports the county's view. It even specifically says that if you're doing 1 or 2 wells, you don't have to look at a future production scenario. 1 or 2 exploratory wells, you don't have to look at that. And that was part of the decision. You have in Exhibit 7 of your staff report a complete review of the decision by the Monterey Court, and it clearly supports the concept expressed in the staff report and the recommendations by staff today. As Ms. Prilhart said, that it's the MND is a draft document. When the applicant signs on and says, "I agree to the mitigation measures you've identified," and we put it out for public review, it is a draft, meaning it's subject to change. If we determine later that there was a mitigation measure that is needed, and we would ask the applicant, they'd have the choice to say, "No, we won't do that." Well, at that point, we would call for an EIR, because we'd have a mitigation that we determine is needed, and the applicant doesn't agree to it. That's called an EIR. In this case, we put out an MND, and we believed, and in concurrence with the wildlife agencies, that we had all the impacts adequately mitigated, and we still believe that. But we received public commentary as why not include all these other mitigation measures, which we didn't think were terribly necessary, like the one about not having people with firearms on the site, and we included them. It's not to say that the MND wasn't adequate when we put it out the first time, and even if you do identify a measure like that in public commentary, it's okay to put it in the document. But the curious thing about the testimony we received today is it appeared that the argument was that by accepting the suggestions of CFROG and Los Padres Forest Watch to include additional mitigation measures, now your MND is inadequate and you need an EIR. Well, I thought by adding your suggestions, we were improving the MND, not making it worse. So it's kind of an illogical suggestion that because you've added mitigation measures, now you have to do an EIR. In the Los Padres Forest Watch presentation, there was the thing where he talked about there's challenges. They've recognized challenges dealing with the management of the condors in their sanctuary. Well, those challenges were specifically addressed by the U.S. Fish and Wildlife Service to the county on this project. So we are addressing the challenges by incorporating the 22 mitigation measures that the U.S. Fish and Wildlife recommended to us. So it's not like we're making it up. In a couple of other items with the Los Padres Forest Watch comments, underground power lines, we're going to take care of that. I've just given you that language. The flaring, we have a mitigation measure that is recommended by the U.S. Fish and Wildlife Service, and so they don't recommend that there be no flaring. And the DECOR representative is correct. This project could not go forward without being able to flare. The access by the U.S. Fish and Wildlife Service and the CDFW, we're going to add language into that one mitigation measure that if anyone, any of the DECOR personnel observes I think I may have the exact, we're going to change the language slightly to read in Biological Mitigation Measure 5.5, access to the site shall be made available to the representatives of the state and federal wildlife agencies. That's CDFW and U.S. Fish and Wildlife Service, upon request. Should a California condor be observed on site by DECOR personnel, U.S. Fish and Wildlife Service, the California Department of Fish and Wildlife, and the Planning Division shall be contacted immediately. And so they'll have full access to the site, and the applicant hasn't disagreed with that. There was an issue about the setbacks. Well, number one, the creek isn't a red line creek, it's a blue line creek. And the wells will be more than 75 feet from the creek, and the minimum standard is 50 feet. And on top of that, they're temporary facilities. If they don't get another permit after 5 years, they'll have to be abandoned and the site restored. So, and that's just in ordinance. We don't need a mitigation measure for that. That's required. So, it meets the setback standards. There's been a lot of talk about substantial evidence, and I would say a lot of paper has been submitted, but we look for substantial evidence that there's an impact that's associated with this project. And I wanted to give you some examples of the evidence that we've been provided that we've determined is not substantial evidence of an impact of this specific project. As I mentioned earlier, that there was a pipeline break in 1994 during the Northridge earthquake. Well, that's interesting, but since this project does not involve the installation of a new pipeline, or perhaps even the use of a pipeline, there's no connection between these two wells and that issue. That the casing in a well, Ojai 36, failed. Well, one well out of 12,000 that failed, and in a county that has 4,000 actively used oil wells, injectors and producers, doesn't mean that's reasonably foreseeable that this particular well, which would actually be the newest wells drilled in the county at the highest level of engineering standards and newness, would actually suffer that fate. There was testimony by someone that well casings fail within 10 years or 30 years. Frankly, that's just not correct. I mean, these wells are designed to last for the life of the well, and besides, there's inspections every year at all these oil facilities, and when the wells are built and constructed, there's specific design and testing standards of the cement jobs and the casing integrity before the well's ever allowed to be used. So that's just not based on any facts. Then there's the evidence presented that there's an earthquake hazard that will result in damage to the wells, followed by spills that will be significant impact. Well, that is completely speculative. That's three levels of speculation. First, that the earthquake will occur in the 5-year period, that it'll be close enough to even shake the site, and that anything will leak. And it's not like we didn't look at the issue. We examined the record maintained by the Division of Oil and Gas for the last 20 years for all oil spills from well, I think the smallest spill they recorded was 2 tablespoons, where someone spilled a cup of oil off of one of the platforms. And that is recorded in the list there, all the way up to the pipeline break that sent about 3,000 barrels of crude into the Santa Clara River. And so you look at that, and the record shows that in an area with thousands of wells, it's remarkable how few leaks there have been. And that's discussed in detail in the topical response to comment included in the MND. The water demand, that somehow the use of water by this project is significant. I guess the first place to start is the Citadel project involves 47 acre-feet per year of water as an ongoing feature. In this case, this particular project involves the temporary use of about an acre-foot of water, and there's no long-term water demand. So under the county's thresholds mentioned by Director Prilhart, any use of an acre or less from any groundwater basin is considered less than significant under our thresholds, under our initial study assessment guidelines. Furthermore, there was commentary about that the water might be pulled out of the Fox Canyon Groundwater Management Agency regulated aquifer. It will not be. And even if it were, it would be subject to regulation by the Fox Canyon Groundwater Management Agency and could only be withdrawn in accordance with their rules and regulations, which of course are designed to prevent that aquifer from being damaged. So there's no impact there. And then a lot of testimony about hydraulic fracturing and that it causes impacts, earthquake and whatever. This project doesn't include hydraulic fracking. So it's just not, so that the evidence that they present about hydraulic fracking is just unrelated to the project. Impacts on condors. There was, and I want to read something from, this would be a response to comment E19. And unfortunately, I didn't turn the page to that. But this, let's see if I can find it. Help me, guys. There's F. All right, before that. Thank you. So this was actually one of the commenters brought this up, and I'm just going to read this. This has to do with the 2011 Fish and Wildlife Service biological opinion involves, cited by the commenter, involves oil activities within the Los Padres National Forest. And of course, the project site is not located in the Los Padres National Forest. It's further away from the main area of condor activity. In any case, the proposed project involved the potential drilling of 2 oil wells and testing of these wells over a 5-year period. During this period, human presence, blah, blah, blah. The U.S. Fish and Wildlife opinion states, and this has to do with, actually, I take it back, the 2009 biological opinion, and it's titled, Proposed Leasing of 2 Drilling Sites on Well Pads in the Sespe Oil Field. This U.S. Fish and Wildlife report lists the recommended mitigation measures, which are going to be incorporated into our project, and then it states, the proposed activities would affect a very small portion of the California condor's range and are not likely to cause a decline in species abundance or recovery potential. So they found with the imposition of the recommended mitigation measures, there's not a significant impact, and that's the U.S. Fish and Wildlife Service on a very similar project, only one that's inside the forest and inside the Sespe Condor Sanctuary, not 2.5 miles away. So again, we didn't find that there was substantial evidence, and Ms. Harris will talk more about the condor issue. The noise impacts on wildlife that have been brought up, that somehow that's a significant effect. Well, at 1 or 2 trucks a day, and you have to drive back there a couple of miles, you're basically talking 48 minutes a day that you could possibly have truck noise on the road. Well, that's in addition to whatever the farmer and the rancher is already doing to gather cattle and drive his pickup truck. Well, that's noise less than an hour a day. And so the other 23 hours a day, the noise environment will be exactly the same. Well, that's not a substantial change in what there is now. Now, in terms of noise on the highway, we go back to our ISAGs. Project noise on a road that's within the county's regional road network is not subject to the noise thresholds. So there's no impact there. Then there's a commentary about there being a substantial loss of habitat. We're talking about 1 acre in an area of tens of thousands of acres of open space. And when you look at at an aerial photograph or even just a map of the oil sites, 99% of the land is just open space. The oil facilities themselves occupy less than 1% of the land in the entire area, because they're drilled from small pads, a half acre or an acre in size, and the rest of the area is open space. The days of drilling wells on 10-acre centers and covering a landscape with oil wells and oil derricks are long since over. The way that works now is you have a centralized drilling pad, and you do directional drilling, and you have all your wells concentrated on one small area. Well, for good reason. Seneca wants to maintain as few areas as possible, and directional drilling is so well used and routine now that that's just the proper way of doing it. And then there's comments about cumulative impacts, that somehow 2 wells can cause a cumulative impact. Well, remember the standard under CEQA, that you have to have a considerable contribution to a cumulatively significant impact. Well, first, no one's identified the cumulatively significant impact yet. And then we're talking about 2 wells out of 4,000 actively used wells in the county, or even several hundred that are in the immediate vicinity in the Sespe oil field. And so we have not seen any evidence at all that there's somehow those 2 wells would accumulate with some other major impact. We haven't seen the impact yet, and how these 2 wells could really be a considerable contribution to that is not recognized by us. So I've already addressed the power line issue. I was at the Piru Municipal Advisory Council meeting, or the Piru Neighborhood Council, excuse me, that was on May 21, 2014. That was the day before the planning director hearing on this project. And the Neighborhood Council voted 4-0 to recommend approval of the project. It was very clear at the meeting, and I presented to all of them, including copies, that we had prepared a mitigated negative declaration, and and I even held it up. This is the environmental document for this project. It's a mitigated negative declaration, and there was no vote at all that recommending an EIR. The vote, in fact, much of the discussion was about how DECOR could possibly contribute to various things in the community. But the vote was strictly to recommend approval of the project. There have been commentary about impacts on cultural resources. Well, there was a study done and a survey done to see if there's any archaeological resources on the site, and none were found. So we don't have any evidence that there's going to be an impact on cultural resources. Then there's various general commentary about the risk of oil spills, including spills at the site and pipelines and transport. And as I said, we reviewed the 20-year record that has been kept by the Division of Oil and Gas. I believe their record started on the day the Northridge earthquake occurred and has continued since that time. And there's just a very low level of spills recorded, and everything has to be reported. Nothing's cleaned up and not reported. It has to be reported and reported immediately to Dogger, and then they have to report as to what steps they took to clean it up, and then it has to be inspected by Dogger to find out that it has been cleaned up. So it's just not a significant impact. It's very low likelihood and a very rare event. I guess it's been stated at various times that somehow the Planning Division dismisses the comments we receive from the public and from interest groups and other people. Well, we received at least 222 comments on this project, and we made a detailed response to each one of those. And I would tell you that not a single one of those comments rose to the level of providing substantial evidence on the record that there's going to be a substantial impact of these two wells. And it's in your binder and in your packet, and we have thoroughly analyzed each of these and talked with the appropriate agencies, talked with Dogger, and so each suggested point of impact specific to this project we've addressed. Even some that are not even related to the project we've addressed. So it's not like we've ignored or dismissed outright anything. We've thoroughly analyzed it, and that's why you have a gigantic binder in front of you with hundreds of pages of material. There was testimony today about toxic waste and cancer concerns. I think that's outside of the scope of the project. And somehow the concept that people live on that road, well, I was on the road 2 days ago. There's no one living on Modelo Canyon Road. There's no buildings or houses or anything within eyeshot anywhere near the project site. And in fact, the project site is about at least 1.5 miles beyond a locked gate. So it's not something that is, and it's a private road, it's not something where the public can just drive up there. So there is no public connection anywhere within 1 mile of the site. There was also some commentary that somehow gases that might leak from incomplete burning at the flare would somehow swoop downhill and pollute or cause problems in Piru. Well, there's a mountain between the drill site and the community of Piru. There is no possible way they would go downhill. They would have to go uphill and then downhill. In fact, it's 1.5 miles from Piru as a condor flies, but it's 3 miles driving it, and to go up Piru Canyon Road and then go on Modelo Canyon Road to get back in there, it's quite a ways to drive. And so if any gases were ever to leak and accumulate and remain as a coherent blob, they would have to go all the way down Modelo Canyon until they got to Piru Canyon Road, and then they would have to go down the road. But of course they wouldn't go down the road, they would go down Piru Creek and go away from the city down the creek bed to the lowest point. So I'm not sure how the gases could ever actually get into the community of Piru, since they would follow the lowest topographic point. They would have to go down the creek and bypass the city. So that can't happen. There was an interesting point brought up in the testimony that the infrastructure at various oil sites that exist around the county is old and decrepit and starting to leak, and things are happening. Well, the activity that people may have witnessed in terms of people coming in and replacing pipelines, replacing tanks, is because several years ago, the state passed a law, you could call it the decrepit tank law, saying that all that stuff had to be tested, and if it didn't meet certain standards, it had to be replaced. So like Aera Petroleum has replaced literally dozens of miles of production lines because they don't meet current standards. And that's happening all over the industry. And since that time, Mr. Hessen, the district deputy at Dogger, has told me that even the low rate of spills that they have now has been dropping because of all the replacements of tanks and pipelines required by that new law. There was commentary about spilling hazardous waste in our community, and I think they were referring to the wastewater that comes out of an oil well and perhaps the crude oil itself. Well, number one, the wastewater that comes out of a well is not toxic waste. It's Class 2 waste, which is classified as non-toxic, and there are two commercial places in the county where that material can be disposed, and there's no evidence that this particular trucking operation will suffer a failure rate any greater than any other of trucks on the highway. And then there was commentary about exposure of oil workers to toxics. The oil operator is subject to various regulations with OSHA and Dogger that minimize those kind of hazards, so they have to meet the law like anyone else. There was commentary that the operator may violate the regulations and violate their permit. Well, that's what we call a notice of violation, and that's why we have a code enforcement division to prevent that and punish those who do. But we can't evaluate projects starting with the assumption that the applicant is dishonest and criminal whenever we don't see them. There was a desire to focus on renewable energy. Well, that's a national policy and a national debate, and we really can't address that in a local permit process. The climate change question, I would say that the members of Seafrog and Los Padres Forest Watch certainly saw that analysis of climate change that I put into the errata sheet today to incorporate into the document, because that was the exact same analysis that was put into the Mirada Petroleum case of 2013 for 9 new oil wells. And those were 9 permanent oil wells, not 2 temporary oil wells for a 5-year period. So in that case, that was fully reviewed. It's part of an adopted mitigated negative declaration for that case, fully reviewed by the Air Pollution Control District, and that was for 9 wells, and it was way less than the significance threshold, the greenhouse gas generation. In this case, the amount of greenhouse gas generation is 2/9 of what was done on that, so it's approximately a 1/5 of the impact of what has already been determined in a certified document to be less than significant. I asked my director, is that enough? Okay, well, I'd like to hand it over to Ms. Harris for some comments on condors.
All right, well, I would just like to say that I concur with Ms. Perlhart and Mr. Baca, and I only have a few clarifications for the record. Basically, the fact is that there has never been a confirmed condor injury or death attributed to an oil operation. The letter that we have from U.S. Fish and Wildlife to Ventura County does cite 11 condor deaths related to power lines, and however, it just says that the condor may be affected by oil and gas facilities, and as such, they recommended the mitigation measures in order to reduce that. No evidence has been provided to the contrary of that. The condor mitigation measures, as we've said, were developed over the course of 4 meetings with the resource management agencies, including California Department of Fish and Wildlife, United States Fish and Wildlife, which is also required under the general plan and the Piru area plan. We also extensively corresponded with them over the course of the year that we spent developing this mitigated negative declaration. Consistent with the Piru area plan and the general plan, we also consulted with the California Native Plant Society and the Audubon Society. So with the U.S. Fish and Wildlife recommended mitigation measures, there will be no project-specific or cumulative impacts to special status species, including the California condor. I just wanted to clarify the CDFW streambed alteration agreement process. We partner closely with our agencies such as CDFW to try and streamline the permit process so that they can rely on our environmental documents for any permits that they may require as a responsible agency. It is true that CDFW declined to issue a streambed alteration agreement for this project. They did provide some mitigation measures in writing to the county and to the applicant that we did integrate into the MND. It is often the case that when CDFW is satisfied with the county's mitigation measures, they will opt out of issuing a streambed alteration agreement, provided they're satisfied with our mitigation measures. With regard to the condor mapping that the appellant provided in his presentation, we did also have that data from U.S. Fish and Wildlife, including the spots you see and also the movement and nesting data, and we did reference that map in our MND and included that and considered that data in our analysis. So real quickly, I'm just going to correct or clarify the status of Modelo Creek. Modelo Creek is a red line channel, but that is 3,700 feet down from the drilling pad. So neither the creek crossing or the drilling pad is in an area of Modelo Creek that is considered a red line channel. The temporary oil wells would be more than 75 feet from Modelo Creek, which in this area is a blue line. The creek buffer has been adjusted consistent with the recommendation of a county-approved and qualified biologist with the appropriate erosion control measures. And the existing setting of Modelo Creek is defined by grazing and agricultural activities and siltation from the creek moving through a historic fill of Monterey Shale. I also wanted to clarify the value of the habitat area at the 1 acre site where the where the temporary drilling would be. Again, this is a site that has historic fills of Monterey Shale and is defined by non-native and invasive plants and vegetation. This area where they're proposing the 1 acre drill pad has a low habitat value. Consistent with our zoning ordinance, the applicant is going to be required to revegetate this with native plants after the oil well is abandoned. I'd also like to take some time to clarify our analysis of the wildlife migration in this area. The public is correct in that this isn't a mapped linkage through the South Coast Missing Linkages Project. We received 2 biological reports from county-approved biologists that did address wildlife migration and map linkages on site. No new roads are proposed as part of this development, and no new barriers would be introduced. I also personally discussed with the author of these studies, Kristen Pernaud, because she had heard about the project and just wanted more information, so I spent the time to talk to her about this. She did not provide comments on the project. I also ran this by the Linkage Implementation Alliance, which is a group that is tasked with protecting and implementing the linkages identified in the study in which this project is in. So I think Mr. Baca clarified the mitigation measure changes that we're recommending. I also have language to include worker education as mentioned by Commissioner Adukas. So I can read that into the record if you guys would like as well. So that's all I have, and please let me know if you have any questions. Thank you.
Questions from the Commissioner Adukas?
Was that the end of staff's responses? Because I only have about half a dozen. But for biology, somebody said you've got to use existing conditions as the baseline, and what I'm hearing from you is that that's what you did.
Mr. Chair, Commissioner Adukas, that's right. Okay. We looked at existing conditions as the baseline.
Thank you.
Mr. Chair, do you have this? Do you want to read it into the record? The training requirement?
Yes. So essentially, we would amend Biological Mitigation Measure 6, which is the pre-construction biological surveys, relocation, and monitoring. We would add under a requirement, basically a paragraph stating that all personnel, including drill workers, construction crews, shall participate in a special status species and sensitive habitat education program prior to the beginning of construction and for the duration of the CUP. The program shall be developed by the permittee and shall include at a minimum the following topics: the occurrence of special status species, the sensitivity of species and habitats to human activities, legal protections for special status species and sensitive habitats, general special status species activity patterns, reporting requirements, measures to protect the special status species and sensitive habitats, and personal measures that employees can take to promote the conservation of special status species and habitats. We would also add under monitoring and timing of this mitigation measure that the permittee shall submit to the planning department or division the special status species and sensitive habitat education program prior to the issuance of a zoning clearance for construction.
Chair Rodriguez, members of the Planning Commission, I wanted to hopefully briefly address and hopefully clarify a few legal issues that have been raised during the hearing. I think perhaps the most important issue I want to clarify in terms of CEQA and the county's permitting process, which to outsiders, I can understand why it wouldn't be clear, but the contention was raised that by approving this test pilot, the county would basically be opening the door to a modification of the project under a more deferential standard of review under CEQA, and that's not the case. If DECOR in the future, if this test project was approved and the testing did show that there was production that they wanted to do later, production drilling, that would be treated as a new project under the county's permitting process. So they would need a new conditional use permit for that, which would start a new environmental review. And so I don't want to get too much into the technicalities of CEQA, but the attorney who was presenting correctly cited a more deferential standard of review that's associated with modifying a previously approved CEQA document called an addendum. And so a court basically gives the agency and the CEQA document the presumption of correctness. That would not come into play if DECOR subsequently wanted to do a production project. It'd be a whole new CEQA document. In the event that an EIR wasn't prepared, and I'm not saying that would be the case, I don't know what the CEQA document would look like, but if it wasn't an EIR, then it would be the same fair argument standard that that I'm sure you're dealing with today. So I just wanted to clarify that. In terms of the cumulative impact, there's been a lot of discussion about that, and I believe Mr. Baca addressed that, and basically whether there's a cumulative impact that would require an EIR. It's a two-step process. The first step is identifying a cumulatively significant impact on the environment, and just like everything, that would have to be supported with substantial evidence, a fair argument that that kind of impact did exist. And then the second step is whether this project's contribution to that larger cumulative impact is cumulatively considerable. And what I wanted to stress and go a little bit beyond what Mr. Baca said is that when you're making that analysis, you have to take into account the mitigation measures that have been imposed on the project before you. And so those are basically wrapped into the project, and so when you're making that analysis, you assume that the mitigation is there. And so you say, okay, this mitigation is there. Even with this mitigation, is there still an impact that could occur on top of that? And the same goes for just looking at the project straight impacts, not cumulatively considerable. Under the fair argument test, you look at this project including the mitigation. So it's all wrapped together. I believe Mr. Baca addressed the Center for Biological Diversity in San Benito case. And again, the test there, just like in every CEQA project, is what is the scope of the project? What's a reasonable, or are there other reasonably foreseeable components of the project that could occur later? And if so, those do need to be analyzed as part of the current project. And so in the San Benito case, the court, based on the specific facts of this case, 15 test wells, it sounds like there was a lot of information about the oil resources that the oil company was going for. Under those specific facts, that trial court judge said, yes, it looks like production is reasonably foreseeable, so they have to look at those impacts. Just like other people have been saying, that the court stressed that it wasn't a situation where there's one or two test wells, like what we're dealing with here. But the ultimate question goes back to you all. Is production reasonably foreseeable? And if so, what would that project look like? And CEQA is always a balancing act. You want to look at a project early enough on to inform earlier decisions that could lead to an ultimate impact, but at the same time, you need enough information to be able to conduct a meaningful review of whatever those later impacts might be. And so, as I said, in the event that this DECOR project does go into production, I just want to be crystal clear that that would require subsequent environmental review. It would not be a deferential standard review. It would be a new CEQA document. And so those impacts would be disclosed and addressed in the future. A comment was made, I believe, during the Forest Watch presentation about mandatory findings of significance. And in the county's initial study, that box was checked, a potentially significant impact there. Just like my previous comments about mitigation, if mitigation is adopted, that reduces that potentially significant effect. In this case, I think the mandatory finding of significance was related to biology. You have to take that mitigation into account. You can't discount it and pretend it's not there. That's all wrapped up into the project. And so only if you find that even taking into account that mitigation, there will be a significant impact, do we get to the EIR. Let's see. A reference was made to the federal government's oil leasing practice, and apparently they have a program or requirement of a reasonable foreseeable development scenario. I just wanted to stress that doesn't have anything to do with CEQA. There's no such requirement under CEQA or under county policy, and so that's a separate process. And again, here the county isn't leasing its own property. That's in the context of a government leasing its property. It's not in the context of CEQA environmental review. So I just wanted to be clear that there's no CEQA requirement that the planning division undertake that sort of project analysis here. And finally, a case Whitman versus the Ventura County Board of Supervisors was cited earlier, and I believe it was cited for the proposition that a cumulative impact analysis should be required in this case. I just want to stress that every project and every situation is different, and like Director Prilhart testified to before, the planning division works from the county's initial study assessment guidelines in determining whether any individual impact or cumulative impact goes beyond the thresholds of significance. And so the Whitman case was, it came out in 1979. That was the early stages of CEQA. Just very briefly, that project involved an exploratory slash production project in the Cesar Creek area of Upper Ojai. And I say it included both because one of the issues why the appellate court sent it back to the county for further review was that a pipeline was contemplated for construction in the context of the production aspect of the project. And so the way it looks like the way the project was described, it was one test well, but it sounds like the applicant was confident they were going to find oil. In fact, there were 57 wells that went active in the area in the 3 years before that CUP was applied for in that vicinity of this project. And so there was an oil pipeline that was contemplated as part of the project. And so the court said, no, you have to look at that oil pipeline as part of this project because it's clearly contemplated if you go on production. So you have to look at that issue. And then in terms of cumulative impacts, the court said that because of those 57 other new oil projects in the immediate vicinity of that project area, the court said, look, your cumulative effects analysis, which was 1 or 2 sentences long, was deficient. And so you have to assess the cumulative impacts of all those other oil projects that are coming online in that same area. So, sharpen your pencil and do it. That project did, however, it was assessed under environmental impact report, and the case itself doesn't say why. The case does say that it was the oil well and area was proposed for undisturbed sensitive habitat area within 1/4 mile of a residence and 1/2 mile of the Los Padres National Forest. And so just like every project, location is key. And so I'm sure that informed the decision to prepare an EIR initially. I will say, having seen EIRs from that era, the amount of environmental review that went into EIRs back in that era wasn't very great. And so what I've seen is that even an EIR from back then doesn't have the same kind of analysis that the planning division today puts into mitigated negative declaration and the initial study. I don't think they had initial study assessment guidelines. They didn't have standard mitigation or anything. So I just want to say, I don't want you to compare apples and oranges. I want to tell you about the case, but it was a different regulatory context, a different project, obviously, in a different location.
Thank you. Commissioner Dugas?
I'd like to follow up with my question about environmental justice. It sounded like there was a cancer hotspot. Is that something that, moving forward, if it turns out that, there is further development of the oil field there, is that something that that should be looked at? I took that testimony very seriously.
Of course, as well you should, and I don't have the technical expertise to be able to answer your question. It would be the type of issue that would planning would consult with the Air Pollution Control District with. There are initial study assessment guidelines having to do with air pollution and greenhouse gases, and so those are the standards.
And they also mentioned water quality issues.
Water quality as well, and
Yeah.
so the way to address that type of concern would be for the county as a whole to look at those initial study assessment guidelines and county policy to see if those need to be adjusted.
Okay, moving forward.
Moving forward, right.
Yeah. I had a couple of technical questions.
You have the mic.
Is there a vapor recovery system on the tank, that tank that was there? They were concerned that, when they unload the tank onto the trucks, that somehow vapor will get out. Is there some kind of recovery system on it?
Mr. Chair, Commissioner Idukas, the test tanks, they have connections that are like pipeline connections, flexible hose that
So there's no escape?
I imagine there is some escape, but that's all counted in terms of the Air Pollution Control District's assessment of the pollution, the air emissions. And in reference to your previous comment, health risk assessment is part of what APCD does when they assess whether there's a significant impact of a particular generator of air pollutants. So that would be something that would be part of the analysis that would occur at a larger project.
It just sounded like there were sensitive receptors there. And, I believed all that testimony, that there's, a lot of cancers and asthma in that area.
Mr. Chair, Commissioner Idukas, in the vicinity of the well pad, there's nobody within 2 miles of that site, and the site has no access to the public. And so there's no one there. The only thing that could possibly affect people in Piru would be the air emissions coming from truck traffic. And 1 or 2 trucks a day does not trip any kind of a threshold. If in the future there is some greater level of oil development, that would be a whole new project and would no longer be temporary. They would obviously come in for something that we would classify as permanent, and all of that would be analyzed. Similar to the health risk assessment that was done for the expansion of the Grimes Rock mining facility that your commission reviewed last year. There was a full health risk assessment on the trucking emissions going through the cities of Moore Park and Fillmore. Now, in that case, there was 460 trucks per day. There would never be that here, right? And there's only 2 right now, 1 or 2. So that would be addressed in the environmental document.
Okay, thank you. There were two other suggestions from the public to relocate roadkill. Is that something that that we could add? Or would we want to look at that?
Mr. Chair, Commissioner Idukis, I haven't given the roadkill idea much thought, but I don't see there's any reason why they can't pick up any roadkill. I mean, they'd be the ones doing it, and move at a certain distance from the site. I mean, so there's literally no food laying there on the ground. I think that's sort of like the same conditions we have, that they're not to have anything out in terms of food that is attractive to birds. But I think we can add that.
Okay. And last thing, someone suggested an oversight committee. In what other cases have we had oversight committees?
Mr. Chair, Commissioner Idukis, we're here at the Oversight Committee today. That would be you.
I think this person wanted, perhaps more a citizens oversight committee.
I'm going to leave that to the planning director.
So Commissioner Rodriguez and Commissioner Dukas, we don't have oversight committees per se, but we do have working groups. So when we were having an issue with the wedding venues and events venues, we set up a working group, a voluntary, that they could come in and that we could run past conditions of approval, talk to them about weekend enforcement, see what we're going to do to make their venues work better in their communities. So we do have things like that, working groups that we set up that we can talk back and forth and have those conversations. And I'm happy to have something like that in the oil and gas realm too.
Okay, so moving forward, if it turns out that there's more activity in this area, then that's something certainly that could be looked at.
Absolutely, and I am going to reach out to the Piru Neighborhood Council and talk to them a little bit more specifically about our role and their role in coming out and reviewing permits, and I'll go out there myself in the next month or so, or the next time they meet, and kind of go over the process with them as well.
Thank you.
Commissioner Dukas, I heard one thing today that I guess as the planning director that I would like to weigh in on, and perhaps your commission would agree, that perhaps what we should do through the Piru community is limit the trips to daytime trips. I was hearing some testimony that nighttime trips are problematic. Yes? That's something that you could review.
I'll dovetail on that. One of the issues I heard and picked up on, obviously, from the testimony was the issue of truck traffic. We've heard enough now to know there's going to be a limited number of trucks that come to and from the site. However, I think we have the ability to define when they will roll onto the site. And so I would also like to see those restricted to daytime hours, and certainly not nighttime hours, for a variety of reasons. Not only the impact on the community, but the issue of safety going up and down that road, and the potential for some problem as a result of that. So work with. I think if this CUP is approved, then I think staff needs to work to define those hours, and I don't think anybody likes to be woken up before 6 o'clock in the morning. Maybe 7 o'clock is more appropriate. I think there is identified and defined hours of privacy in all sorts of statutes. We can come up with something to address that issue, I would hope.
We can do that.
Another question I have is, why do we, I missed it, I saw it, but I missed where it came from. Why do we need to have an emergency helicopter pad, which requires obviously additional grading?
Mr. Chair, well, there actually isn't necessarily any additional grading. There may be some brush clearing so the helicopter doesn't land into brush. But the issue there is that if in the event of a fire, and if there's a fire down canyon, and you have the oil rig and the personnel there isolated, they need to have an escape route. to get out in the event of a wildland fire. So the idea is there'd be a marked on the ground helicopter pad that if there is a fire in the canyon and they can't get out to Piru Canyon Road, they have another escape route. And so, we'll work with the fire district exactly where it's going to be. There's a potential one that's been identified currently that's along the existing road. There's also a potential site that's nearer to the drill pad that is already flat and there and waiting. So we're going to work with the fire district exactly where they want to have it. But they don't need to have it graded or anything. They just need to have a clear landing spot that you don't hit an oak tree or something. There won't be any trees. The site they've looked at, it just has very sparse brush on it.
Okay, and I'm assuming, trailing those comments, that would include staffing from the sheriff's air units, since they in fact fly the helicopters.
Wherever the pilot is coming from, that'd be fine. But the purpose is for not for fighting fires, but it's for just personnel emergencies.
No, I understand that, but they're still flying the sheriff's personnel pilots are still flying those crafts, and
that would be correct.
I would expect that any comments related to that would include any input from that sheriff's unit.
Yes.
Just a moment while I review something here. So I'm clear on this issue of the CUP request for MND. The original CUP for that site expired when the airfield was abandoned, and that being LU 08-0100. And PL 13-0046 was approved in 2008. Is that correct?
Mr. Chair.
Am I misreading something?
Well, it's been a long day, so everybody gets a mulligan. The oil field, the Piru, the Modelo area of the Piru oil field, the last well was abandoned in the current productive zone. The last well was abandoned in 1990. So it's been 25 years or 24 years since the last actual production has taken place there. That was under a pre-existing CUP. I don't have the number off the top of my head, but that was one of the older CUPs that was granted decades ago. And that CUP has long since expired and is gone.
Yeah, actually, there are three of them, apparently.
Well, there's, people keep trying. In the LU 08-0100 case, that was actually an application that was filed in 2008, was approved in 2012, and then before that one was actually implemented, the applicant themselves determined they needed to do additional work to make the pad fit the drilling rig type of thing, and we felt that was sufficient work, that it went beyond the scope that we had disclosed in the original project, for which an MND was prepared and adopted, and that's why we're doing the second process we have now.
Okay,
and so the
PL
13...
The CUP was applied for in 2008.
2008.
And it was approved in 2012.
It was approved.
And subsequently in 2013, there was the additional request or review that we're looking at now.
A more clarified project description that we felt needed additional review, and that's why we went into this process that you're in here today.
Okay, thank you. Any other comments or questions of staff?
Yeah.
Commissioner Maggie.
I think you may have said something about this, but why is it set at 5 years, the CUP?
Mr. Chair, Commissioner McGee, the 5-year request was the request of the applicant, and it's temporary. It's not like.
I understand that.
Even if they're producing at 5 years, they have to shut them down unless there's some other permit action.
Okay. I mean, did they say, well, we won't be able to figure that out for 5 years, or?
Well, Commissioner McGee, diving back into my decade in the oil patch, the reason for that is there's two things you're testing when you drill a test well or a couple of exploratory wells. First, is there any oil there at all? And then if there is some oil there, can it be produced at an economic rate so that you're not losing money, so you're making money? And so part of the assessment as to whether you can actually make money is to produce the well for a couple of years and maybe drill the second one 2 years later and drill it in a slightly different place and produce it for a couple of years and establish a decline curve on the production rate and an evaluation as to what the water cut will be. That is it going to be 10% oil and 90% wastewater, or is it going to be 60% oil and 40% wastewater? So you're looking at all those engineering factors, and then after you've finished your test period, you can look back and say, well, gosh, is this field big enough for us to develop? Can we make money with it? Or is it better off we leave? And so testing an oil program over 5 years is a pretty common thing.
Thank you.
One more question related to County Council. I heard your comments related to CEQA and expansion of the potential exploratory site wells if the CUP is granted. Is there anything that prevents this commission from mandating, specifically mandating the EIR if expansion of that site occurs? How is that addressed under CEQA?
In terms of production, if they went to production?
Correct.
The way CEQA works is that the actual production project would need to be assessed later. That project is not before your commission today, and I do not believe you have the authority to prejudge that project and its potential impacts today. And so, no, you couldn't mandate today that any production project would certainly require an EIR.
Okay, thank you.
The project description does say production, but it's just of these two exploratory wells.
Right. I was addressing a hypothetical future project, whatever you call it, that is different than what's being proposed today. And my point is, you can't name the environmental document and type of review that would be required for that subsequent project today.
Okay, no other comments. I'll go ahead and close the public hearing.
Excuse me, Commissioner, will there be a chance for rebuttal at all?
No.
I do have a point of order on the new material that was submitted that we had not had a chance, only in regards to the law, and I would ask for 1 minute. Because several representations were made about the law that have not been briefed.
We are finished, and unless County Council tells me differently, I have to go by what I've been presented and been advised by council. So public hearing is closed. You want a few minutes to gather your thoughts, or you want to proceed into discussion? Why don't go ahead, Ms.
No, if you want, if anybody else.
It doesn't matter if I go ladies first.
I'll go ahead and lead off.
Commissioner Wessner.
If the chair approves. If the chair approves.
I didn't want to wait and bother Commissioner Onstadt here.
First of all, I want to thank everybody today and all the information, all 6,000 or 8,000 pages and the information. When we had the workshop, I was anticipating this. I don't think that's a breach of any anticipation. It's not a breach of anything. Because this is an interesting situation. In 27 years of sitting either here at the City of Moorpark, both EIRs, MNDs, subsequent supplemental EIRs, discussions, I have to agree with County Council. There has been just this evolution of CEQA documents. But the fundamental purpose of CEQA, as my study has been, is the fact that CEQA was developed so the public would have an opportunity to get adequate information. In fact, I noticed even in the 1979 decision, the fact that the courts specifically stated that the sufficiency of the environmental report is to be reasonably feasible and perfection is not required. And I would believe that, in my opinion, to be of any of the CEQA documents, including a negative deck. So there would be enough information available that an adjudicator, this body, could say, A, I have enough information, B, I don't have enough information, and send it back. So again, it's an informational document that's to be adequate. And NMND is a CEQA document. As I stated in the very beginning, I was interested in the whole cumulative interest. I looked at the other appeal positions that the appellant took, and I felt it came back to the cumulative. Could each one independently could be mitigated? But again, it gets back to, I think under CEQA, in my opinion, or what I understand it to be, I'll slow down now, is the sum greater than the total of the parts? And that's what I've been wrestling with all day. Regardless of the expert testimony, regardless of the background or the situation, is there enough before me to make this decision, depending on it? A lot of what we learned in the workshop was there are multiple agencies looking at multiple aspects of this type of venture. Not at the least of is Dogger and their inspections. I specifically asked the question of Dogger, what would happen if fracking occurred because they lied to us? And representations were made as far as the GPS inspections, et cetera, that the probability of that was not only slim, but none. The second question I asked at that workshop was, what punishments? It's one nice thing to have rules, it's another thing whether you can enforce it. And it was made quite clear to me, both under our CUP and discussions with Dogger and Dogger, that we could enforce those. The one exhibit that I received, the fact that we stated that no one can honestly think otherwise, given this reality, promise of future review is meaningless. I take exception to that. This body is well known for reviewing things and requiring things to come back. This is a 5-year request by the applicant. Their representation is the fact that there'll be a 14 months. There'll be a lot of people looking at this. For it to be brought back for full production, I would anticipate that time that we would be looking at an expanded document. But right now, it's a test well. And I have enough information in front of me for the MND, I believe, is an adequate CEQA document at this point in time for this CUP, which is, again, a conditional use permit, which we control as the oversight. So if we want to require the directors, we have done with other CUPs, to bring this back 6 months, 14 months, that's totally within our purview. So I understand the concerns, but the fact, again, is the CEQA process is to the public the opportunity to be made aware of those concerns. But a decision has to be made. And I'm looking at, again, this is a conditional use permit for a temporary situation, an MND, whether or not it's adequate and whether the mitigations are sufficient to mitigate. One of the people talking today, Ms. Topper, raised the issue about best management practices. Most of the conditional use talk about best management practices. And again, this document is not meant to be pristine or perfect. It's meant to be adequate. So these best management practices that we rely on the experts to enforce are in place. So I am inclined with the modifications, and I gotta be honest with you, I lost track to the modifications that staff recommend. So to move forward to deny the appeal, this is not a motion, but that's where I'm at, and I'd like to hear the balance of the commission.
Commissioner Onstad.
I share Commissioner Wessner's assessment, and I won't repeat it. And it was a great deal of help to me to have the Benito case and the Whitman case distinguished. And I was also concerned with the authority that was cited earlier, that if this matter came back to us as a result of successful production, it would be given a different standard of review. But I've been assured by the county that if they come back for a modification for a production situation, we would have the same standard of review that we have today. And with that, the questions that I had have all been answered by staff and county council, and I share Commissioner Wessner's opinion that the appeal should be denied and the CUP should be granted as amended.
Commissioner Maggie.
You got the appellant supporters. You had a lot of folks here today. I thought you did a really good job. I don't see this as it's not segmented. It's a different CUP, if you will, from doing something permanent on that drilling pad. I too think the MND is adequate. It's got some holes in it here and there, and most of which have been patched, I think. Code enforcement, I hope they're on their toes during this 5 years. And I think it's pretty clear that how everybody that's spoken so far up here is that if indeed Decorah lucked out and found some oil, they talk about 1 in 20, who knows? I guess it's like Las Vegas, you gamble, right? And they want to go forward with something more permanent that knowing who is out there still diligent about supporting this or making sure it's done right. It may not be an EIR, I don't know, but I know it's going to be thorough. I can tell you that right now. And so at this point I'm looking to not support the appeal.
Commissioner Dugas.
I'd like to commend everybody that came out. I think that the participation, the interest really did make changes to the mitigation measures that are being imposed on this project. The thing that really stands out to me is whether or not you believe that this is a reopening of the Modelo area, the Piru oil field, or if you believe that it is just exploratory. I believe that it is exploratory. I've had some experience with these types of projects where you hope that your investment of dollars and time pay off, but often they don't. And it really is unknowable until you get out there and you test. And so I don't think that we would have useful information. It would just be wishful thinking and crystal balling and speculation to have an environmental impact report that that looked at where the lenses are, where you would get something that would make economic sense to go after. So I think we have a difference of opinion here. It sounds like there was a lot of scrutiny as far as the impact to the condor, and as a birder, I really appreciate that. That doesn't mean that I don't care about the people there. This is the first I've heard of the cancer cluster there, and this is a great thing that you're able to bring it out here, so that we can hear it and we do follow up. And I believe the planning director, when she says she wants to reach out to the neighborhood council to see what can be done from planning's point of view. And I'm sure that the planning commissioner for that area will be in contact with the supervisor to talk about that. But it sounds to me like we have some, there were some facts in dispute. It sounds like we've got those settled, but we basically have a difference of opinion about whether or not this is reopening the oil field or whether this is exploratory. I believe it's exploratory. I think at this point it would be premature to ask for an environmental impact report of the reopening. I'll be keenly interested in following this. And I know from your point of view, because I've been on that side of the dais, so I know how frustrating it is. You feel like, well, then I have to watch this for 5 years. And it's very frustrating, and you wish that you didn't have to do that, and I understand that. But that is what you have to do. So I would not be inclined to support the appeal. I'd be inclined to deny it.
There's no purpose in rehashing everything and some of the comments that we've all heard already. If in fact this CUP if in fact the appeal is denied and the CUP goes forward, a couple of things came up as it relates to any potential initiation of exploration wells out there, and it came from staff, and it had to do with the inspections, the code enforcement inspections of the site and the requirements and doggers inspections, et cetera. And I think I heard a comment that the county has the ability to coordinate and share information on that particular issue. If in fact this goes, if in fact this appeal is denied, then I would expect, and the CUP is approved, I would expect that that would be written in and included in any documentation as it relates to any CUP. It occurred to me after I received your comments related to truck traffic and that type of stuff. We're talking about 2 truck trips a day potentially off that site. I don't want to get caught up in semantics. We were talking about tanker trucks, we were talking about delivery trucks, and we weren't talking about flatbed trucks. And I think there needs to be a clarification and understanding when we're talking about 2 truck trips a day, what we're talking about. And if it's appropriate for me to reopen the public hearing for that brief clarification, I can do that. But it seems to me that there'll be additional truck traffic onto and off of the site just through the normal course of operation. So I think there has to be some sort of awareness of what total cumulative truck traffic would be on that site if a CUP is approved. And if I'm misunderstanding what 2 truckloads a day would be, I'd certainly appreciate your comments.
Mr. Chair, if I may interrupt, the 2 trucks we're talking about are deliveries where the fluid that they produce is taken off the site, and those are by small tanker trucks that take the fluid off. There's other occasional trips with a passenger vehicle of the maintenance personnel that may visit the site once or twice a day, and so that's the traffic load. And so no more. It's 1 to 2 trucks per day. So that's the estimate. That's what they're limited to under their permit. And as your commission has already opined, we're going to add a daytime condition that they operate in the daytime after 7 a.m.
Is that the drilling periods was approximately 25 days to drill, was it not? And wouldn't there not be additional people, personnel in it, utilizing it during that 25-day period?
Yes, during the short-term drilling. I think what you were talking about is what would happen during the production phase,
Right.
which would just be an occasional person and then a tanker truck once or twice a day to take out the fluids. During the drilling period, of course, you have the drill rig and the personnel on that.
Right.
So just like any construction project, you're going to have a short-term period for drilling the well, which may take a month.
If there is to be a restriction on the truck route through Piru, one of 2 ways, I would hope they would pick the least obtrusive way, and perhaps that's the access to the east more. I don't know if it is or not, but that should be discussed, I believe. The access further to the east, I don't know what the name of the street is. Perhaps you know. I don't know. But whichever way is the least... I beg your pardon?
It's Center Street.
Is it Center Street? Would probably involve fewer residential property. More?
There are 63 residences that were just built there. It's called Via.
Oh, that's right, the housing, yeah, we approved it.
We approved that.
Yeah, but if there is at least, if one route is better than the other, please discuss it and adopt it.
I guess at this point, well, first off, I would like to point out to your commission, and of course this came up at the Grimes Rock project, is that we really can't regulate traffic once it gets out on the public roadway or the state highway. And I'm not sure what the designated truck route is through Piru, but we'll take it as direction from your commission that we can evaluate the truck route and have a proposal by the operator, and it'll be subject to review and approval by the director as to which truck route goes through. And we can also meet with the people who live there and the Piru Neighborhood Council as to what they recommend as the recommended truck route.
Good.
But and we can just have that as a condition and direction to the director to decide what the appropriate truck route is.
And just to piggyback on that, just because we don't have the authority to condition it, it doesn't mean that they couldn't volunteer. They could volunteer it.
I don't, I'm going to make the assumption that Mr. McDermott has not jumped out of his chair and would not disagree with whatever truck route the planning director decided to impose upon the project.
Good.
Thank you. I'll close the public hearing portion again. I'm satisfied. I mean, we've heard a lot of testimony, a lot of emotional testimony, a lot of testimony from people with expertise in a variety of areas this morning in a cumulative fashion. I think if we were here another day, we'd probably have another day worth of testimony. But I'm satisfied that I think we have enough information to move forward, and there's a lot of things that I've obviously asked questions about in areas that I'm not completely comfortable about, but a lot of that has to do with the speculativeness of what will happen if in fact the CUP is approved, and we can't go there because that's not what's in front of us. I think I'm satisfied with County Council's comments on those areas and staff's comments on the areas, and I also am inclined to support recommended staff action on this issue.
Mr. Chair, if I may.
Do you have a motion? Mr.
Yes.
Wessner.
I'd like to move the recommended staff actions to deny the appeal with the refund of the fees, with the additional 40-page errata included, and with the additional information that was provided by Mr. Baca, including the daytime truck trips restriction.
We have some discussion?
We need a second first.
I'll second that.
We have a second. We have discussion.
I understand there's been a request to rebate the fees. Is there? Yeah, I thought you might want to look at that.
This is the board's adopted fee schedule, right? And so they've applied, they've paid their fee, and at this time when they paid their fee, I believe it was $2,000. So they pay the first $2,000, the applicant pays the second $2,000, and everything else is borne by the planning department. So what it says is that's the way that works. The fee is imposed, and it says if any appeal is fully upheld, all fees paid by the appellant shall be refunded. That didn't happen. If the appeal is, or it may not happen, if the appeal is upheld in part, the decision-making body hearing the appeal shall determine at the time the decision is rendered what portion of the appealed charges should be refunded to the applicant. So the only authority that your planning commission has to refund any portion of it is if you're going to uphold a part of the appeal or not. Otherwise, if the appeal is fully upheld, of course we refund the money, but if not, the fee schedule says the money is collected.
Mr. Chair, if I may amend my motion to withdraw the fee refunding.
Can I make a quick
No.
response to that?
No.
Okay, we have an amended motion. Do I have a second?
Do we, wait a second. Is the motion to deny the appeal and grant the CUP
As by the staff recommendation with the amendments made by Mr. Baca,
I second
including
it.
the 40-page errata.
I'll second the motion.
Okay, we have an amended motion and a second to the amended motion. Any further discussion?
Mr. Chair, very quickly, just I would like to make sure to clarify the motion that it's not just the material in the errata memo, but also the changes that were brought to your commission's attention today.
That's exactly what I stated, the additional information you provided.
Okay.
And the record will include the documents that were received today. I believe we had a petition from 150 people, and I think there was another document that was submitted. Will also be included into the record. Further comments? I guess we can go ahead and vote.
Excuse me, point of order. I'd like to be heard on the
No.
refund issue. It's a separate issue.
No.
It's a discrete, separate issue. And I think we have a speaker here on the law.
I received this. I received a card, and obviously I'm trying to get through this meeting and don't have the ability to read what was on the card. I don't know who it came from.
The answer is we don't have the authority.
It's from the primary speaker for the appellant. For a county's fee schedule, we would like the opportunity to address a matter of refunding the appeal fees given the changes made to the project in response to our appeal. Thank you, Jeff.
We don't have
We
the
don't-
authority.
We don't have that authority.
Can I make a quick point?
We don't, no, the public comments portion is closed, I'm sorry. And we don't have the authority to hear your comments on that. That said, I think we'll go ahead and vote on the issue.
Where is it? What do I have to do? Oh, Jesus. Oh. Thank you. What am I going to do without you? Without? You can have the Corvette.
Okay, the motion passes, so we're following the recommended staff action, the appeal is denied. We still have a couple of items on the agenda. I think we can continue. Item number 8, report by the plan director on board actions and other matters.
So I'll be very quick, Chair Rodriguez. I just want to let you know, you probably all read the paper, that the board voted on Tuesday 4-1 to uphold your decision to not grant the CUP to Tropical Paradise. So that decision was final on Tuesday. And then I want to go over your calendar. So it looks like you had an item scheduled for October 2nd, and that item has been postponed to October the 16th. Unfortunately, when we printed out the mailing labels for that, the date for the hearing only printed on every other label. So every other person that got it, it didn't have a date of a hearing, so we're going to renotice that, and we've let our applicant know that, and so that's been rescheduled, and we've checked in with your calendars for October 16th. And then we also have a Planning Commission hearing on October 30th. At that point, it looks like we hope to be here with our wireless communication facilities ordinance. It's out for public review right now. You're not going to be here that day, the 30th?
I told you.
Yeah, okay.
More than one occasion.
Yeah, and I think that we knew that, except that, there's a, a limit to what we're able to do and trying to hit the board by the end of the year, too. So we have that. We also have a variance on...
I'm not offended if you proceed without me.
I'm sure you wouldn't be, because we have a variance on that day, as well as the compliance report that we have to your commission that you asked for, the one-year report on the Lockwood Animal Rescue Center in Lockwood Valley. So we'll be back with that one-year report on that as well. So that
You can save the time.
looks like all we have on your calendar so far, and Mr. Baca apparently has something he'd like to share with you.
You moved the item from October 2nd to the 16th.
October the 16th, right. And were you
then
notified
you-
of that? I think Lori did you send us something out to them on that? Oh,
Did
not
I-
yet.
did
Okay, I see it on
also-
the tentative calendar. So we're not going to have a meeting on the 2nd. We will not have a meeting on the 2nd.
Okay, so the the tentative calendar that came out yesterday, or I received yesterday, also talked about moving something from the 16th to the 2nd.
Moving from the 2nd to the 16th.
Okay. I
And then on the
misread
16th, it says postponed from October 2nd. So
Right.
there's 2 notes
Okay,
on that.
Okay, my misread, thank you.
Mr.
Bach?
Chair, this goes under the subject of other matters, and I'm going to take advantage of this forum. San Ynez High School was built in the 1920s, and since that time, 70,000 people, roughly or so, have attended that high school. 60 have been inducted into the Athletic Hall of Fame of the high school. My son, Brendan Baca, will be inducted tomorrow night as the 61st member of the Hall of Fame of that high school. And just wanted to point that in. He's a soccer player. He's played goalkeeper for 16 years. He was a starter in college and played at various levels. His team was ranked 7th in the nation at one point. So,
Okay, Dad.
You're a proud papa. Congratulations.